then filed an affidavit in response to the founding affidavit of the FSCA and Advocate Tsidi. And in that affidavit that she filed, the answering affidavit, she didn't deal at all with the criticisms that were made against her about bias, about not having considered the matters as she should have, about her report having been unreasoned, and so on. So in the founding affidavit, she really concentrated on the question of jurisdiction. One of the things that was raised, and this is a matter that arises in, is an issue that arises in a lot of the cases that are before this inquiry, is the fact that she investigated a matter, a complaint that related to things that happened more than 2 years previously, a matter. So the complaint, one of the issues here was the question of jurisdiction. So in her answering affidavit, that's what she focused on, the question of jurisdiction, and what she really wanted was for the matter to be remitted back to her, for her to investigate again. So she didn't deal with the criticisms against her conduct, against her actions, the criticisms of bias, and so on, and so on. So the charge really relates to her failure to have dealt with that, with those issues. And one of the issues that was raised by the FSCA in relation to her is that as a litigant in a court, she has a higher duty to explain herself, to explain her decisions. She considered the review, but she didn't really explain why it is that she considered the review. She didn't really explain what her decisions were backed up by. And that was the issue, and that's the issue that's raised in the charge. So charge 7.3 really talks about Advocate Mkwebane's failure in the litigation that relates to the FSCA matter. And what it says is that because she considered the review without explaining herself, she then considered that the irrationality and forensic weakness that the applicant, which was the FSCA, was alleging in the papers was founded. And then she failed to appreciate her heightened duty towards a court to explain herself to the court as far as her decisions are concerned. And that's what really this matter is about. Unless there are questions, Chair, that's the context of this charge.
No, thank you, because you know when you land or stop, you don't indicate that you just the pause seems like you're looking for something or still continuing. So thank you. I take it that you have landed. Thank you for that. That's the context, honorable members. Slow tempo. Today we're going to be, I want you to be quicker to put up the question, but so that I go to the members for their commentary. And the issues here, it's about us, that's not the one I'm looking for, Tsepo, because the matter here is that in the litigation, unlike your lifeboat and others, in the litigation in respect of this one, we want to check if Advocate Mkwebane, and it's been confirmed now in the context, whether she declined to defend the lawfulness of the findings and the remedial action in the report, also whether she failed to give proper explanation for her findings and the remedial action. And if that is the case, to further respond whether she conceded that the FFCA report was irrational, forensically weak, and misunderstood and misapplied legal principles, and whether she demonstrated a failure to appreciate the public protector's heightened duty towards the court as a public litigant. I invite you members, having listened to that summation of the context and the refreshing of what's involved in this particular charge, I want to invite you to comment and make your contributions. Honorable Dlagude.
Thank you very much, Honorable Chair. I'll just show my face and switch off my video. Thank you. Honorable Chairperson, I fully agree with the summary given by Advocate Mayosi that the public protector failed to defend her conclusions. She further did not explain why the conclusion drawn by the applicants were wrong, including that of bad faith, improper motive, and dishonesty. She simply refused to explain herself. What is of concern is that the PP did not afford Advocate CD and others an opportunity to respond to the submissions of the EFF. She disregarded the documents filed by Advocate CD and others. She failed to consider evidence of the third parties that supported them. It was apparent that she selectively used evidence to suit the decision she wished to take. She was simply going through the motions and had already made up her mind to uphold the allegations against Advocate CD and others. She further failed to disclose the fact that her meetings with the EFF, and did not give the implicated parties an opportunity to respond to the information received from the EFF. The parties learned about these submissions in Rule 53 filed by the PP. I submit, Honorable Chair.
Thank you, Honorable Dlagude, for your contribution. Honorable Nkosi.
Thanks, Chair. This is myself. May I please switch off now?
You can go ahead. We know you.
I'm not AI. No, Chair, I think I agree with Honorable Dlagude. And of concern for me is that the public protector does not deal with this charge in evidence before the committee. And as shown in the summation, that she only refers to it in relation to other charges of maladministration in relation to management of the office. So it is concerning that such a gross conduct or neglect on her side would go unanswered by her. This is very serious, Chair. So I agree.
Thank you, Honorable Nkosi, for that contribution. Any other member who wants to make a contribution? Honorable Siwela.
Thank you, Chairperson. You can see.
Yeah, we see you. We see you.
I'm still there. Thank you. Chair, thanks. I just want to support the summary by Advocate Mayosi and also to concur with the two speakers that indeed our PP has failed to respond. So to me, that was a gross misconduct, because denying to respond or to defend yourself, it is highly questionable. That's my concern. But in short, I support the summary. Thank you, and the two speakers.
Thank you for the contribution, Honorable Siwela. If there are no further contribution, is there a dissenting or a different view to what has been shared? There being none, I now proceed. We'll proceed to the next charge. Ms. Mori, you're going to be much faster with me today. I'll only read the questions when you put them up there. So you have a heightened duty yourself to assist the chair today. It's not that one. We're going to the next charge.
Yeah. Hello, Chair, can you hear me?
I can hear you.
Yes. We're trying to work things out with SEPO. So,
yeah, please do.
So, Chair, the next charge is charge 4, and this is the charge of misconduct and or incompetence. It has various layers from paragraph 10 to paragraph 11.4. For the moment, I'm going to be dealing with paragraph 10. This is the charge which has commonly been referred to as the HR issues. And what the charge really involves is an allegation that Advocate Mkhwebane has herself intimidated, harassed, and or victimized staff in general in the office, or has failed to protect staff in the office when they have been victimized, harassed, and intimidated by the former CEO, Mr. Mahlangu. Again, that relates to staff in general. But then the charge also involves, it particularizes certain individuals which are named in the charge.
Just a pause, Advocate Mayosi. Honorable Ngosi, is that your old hand or is that a new hand? Honorable Ngosi? I take it it's an old hand. Go ahead, Advocate Mayosi.
Thank you. So the charge deals with staff in general, and it also deals with staff.
Old hand, sir.
No, thank you.
Staff that are named in the charge. So I think the exercise that the committee is going to be required to pursue is whether the evidence establishes victimization, intimidation, harassment in relation to staff in general, and whether those things are established in relation to the particular individuals that are named. So there was evidence that was led by the executive managers in the organization, and Advocate Mbofu, on behalf of Advocate Mkhwebane, made much of the fact that there was no relevance to calling all of these people in to speak to this charge. But the people who were called, the witnesses that were called by the evidence leaders, didn't come to speak only to this charge. They came to speak about Fruitless, about CIX, and about other things. But because they were staff members in the organization at the relevant time, they also then spoke to this aspect of it. So I think, Chair, we need to deal with each individual that is named here first, and go through that for the sake of expediency, and then the committee obviously needs to decide whether the evidence establishes any of these issues in relation to each one of those individuals, and then in relation to staff members, period. So the question around Mr. Spelo Samuel, he, of course, was involved in the assault with Mr. Siabi in 2011. he then left the Limpopo office and he went back to Free State, and ultimately he was he wrote an affidavit to the Speaker in March 2020, and then he was charged with in relation to the assault, amongst other charges, disciplinary charges in the organization, on the 11th of March. Whilst Mr. Samuel said in his evidence he himself didn't feel intimidated or harassed, there seemed to be a suggestion that the charges relating to the assault were connected to the fact that he had written the affidavit or the statement or to the Speaker on the 10th of March, and he was making interviews, and he had come out, and he, in his own version, was a whistleblower. So I think there needs to be some kind of debate in the committee around whether the evidence establishes some kind of victimization or harassment or intimidation in connection with that. And I'll leave it there, Chair, with Mr. Siphello Samuel before we move on to the next individual.
Okay, I think that helps. In that way, we take them one by one. Thank you, Advocate Mayosi. And therefore, members, I'm inviting you, I think, to respond to the question whether, in your own view, having been part of this inquiry from the beginning, having listened to witnesses with testimonies presented, whether you're able to find whether there's evidence of intimidation and harassment to each of these members. There's much a broader question around Mr. Siphello Samuel, given the issues there, which might not be the same as other members. But I'm inviting you to respond and make your contribution. Honorable Olangola.
Well, thanks, Chair. I think, yes, indeed, this is a correct approach that we take them one by one, because their situation may not be the same, and would not like to cover them at once, whilst the merits of their issues are not the same. Chair, I think with Mr. Samuel, there were issues that were raised even on the reasons why he was moved to Free State, in that the relationship in the head office degenerated to an extent that he had to be moved to Free State. But more than that, Chair, leave the issues of him not being greeted by a person they were investigating and all those things. I don't think they are really material. But I remember to a certain extent when the public protector alleged that Mr. Samuel did not even attend the inspection in loco in the Fred Dairy Farm report investigation until Mr. Samuel came and showed a photo of him with the public protector in the inspection in loco, which was an antithesis of what the PP said. But then, Chair, I think the presentation from the PP's side was only on issues of Mr. Samuel having been suspended for assault and all those things. It did not really go to the merits of what Mr. Samuel was alleging as an intimidation and harassment from his employer. And from where I'm seated, Chair, the version of Mr. Samuel still remains undisputed, because when the PP was supposed to come and disapprove, sorry, Chair, and disapprove what Mr. Samuel was alleging. The PP focused on Mr. Samuel having assaulted someone else, blah, 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 and even went to an extent of calling that person as a witness to tell the occurrence of that day. So as it relates to Mr. Samuel, Chair, I stand to think that indeed Mr. Samuel was harassed and intimidated. Thank you very much, Chair.
It's just before you sit down, so that you combine all of the elements for each individual. You would have to respond whether there would have been harassment or intimidation to Mr. Samuel by the PP, or alternatively, Mr. Mahlangu as the CEO would have done this on behalf of the PP, both harassment and victimization. It would help just to speak to all of those.
Chair, the reason why I'm focusing on the PP,
okay,
it's because the PP even went to an extent of saying Mr. Samuel did not attend the inspection in local. And that was actually proven to be not true. So it from where I'm seated, is some sort of intimidation and harassment of staff by the public protector. Yes, there are cases where you see that Mr. Mahlangu, the then CEO, was pointed to have harassed some and all that. But in this case, it does show directly that it's the PP. You'll remember, Chair, the story that was narrated to the committee by Mr. Samuel in the provincial headquarters of the Free State government and all those things. So from where I'm seated, Chair, Mr. Samuel was indeed a victim of intimidation. Thank you very much.
Thank you, Mr. Ngola, for your contribution. Honorable Sukas.
Good morning, Chair. Good morning to all my colleagues and everyone on the platform. Yes, Chair, I would agree with what was said by my colleague. I think I want to
okay, I've seen. Let's assist Honorable Sukas. Honorable Sukas, you can switch off the camera now.
Is one of those witnesses that came before this.
Thank you. Go ahead.
Thank you. Thank you, Chair. Yes, I think Mr. Samuel is one of those witnesses, Chair, that certainly I felt was even in his testimony when he came before the committee, suffered greatly both his professional credibility, in how he was treated before the committee. And I would agree that yes, Mr. Samuel was victimized, and it is the sequence of events in terms of the original incident that happened at the public protector, subsequently under then public protector Thuli Madonsela, and then the complaint by Mr. Samuel followed the disciplinary action that was taken against him. He was victimized by both Mr. Busi Mhlangu and by the advocate Mkhwebane, because it is unfair for a matter to be brought against a person in the timelines that it has been brought against him. Then following his complaint, it is exactly the same circumstance that was brought by the public protector and her lawyer regarding unbiased treatment when there is a case against, say, for instance, in this case, the CR17 story, the Pala, all of that. You have elements of the same. You can then apply the same here. But I'm not going to defer to that other than to say the sequence of events, what has been transpired since he lodged the complaint with the speaker and his subsequent treatment. It does relate or come to victimization. One thing that I also want to highlight that was actually very painful that we didn't bring up was when the then CEO was testifying and made it a point to say that Mr. Samuel was ill all the time. You know, the dignity of Mr. Samuel. He suffered greatly, I believe, and I think at the time of his testimony, he was still not reinstated. There is a clear case of victimization, and that it was in the institution, it was not addressed properly, and you can only say that then there was a campaign to deal with this man decisively. Thank you.
Thank you, Honorable Sukas, for that contribution. Honorable Mananiso.
Thank you, Chairperson. Chair, one would want to partly agree with my colleagues who have spoken before me. And I want to say that indeed, the testimony that came before us didn't give us a sense in terms of the response of the PP. However, one have seen that with the testimony that came before us through Mr. Samuel was victimized, and as well, what the PP did, it was to retaliate to Mr. Samuel. That's it from me with regards to her using her power and authority. That's my submission, Chairperson.
Okay, thank you. Honorable Dlagude.
Honorable Chair, are you on to me?
Yes, Honorable Dlagude.
Thank you very much, Honorable Chair. Honorable Chair, my apologies. I really agree with my colleagues who spoke before me, especially Honorable Ngola. Honorable Chair, Mr. Samuel appeared before this committee as a witness, and he raised those issues of victimization and intimidation within the institution by both the PP and Mr. Mahlangu. So what we expected as a committee was for the PP's defense to prove to us that there was no such. Unfortunately, the focus was on Mr. Samuels, that he victimized, he assaulted someone else who then was called to appear before the committee as a witness. So without any evidence that rebuts what was said before the committee by Mr. Samuels, then for me, it seems that the victimization and intimidation did take place. And also to say that Mr. Samuels also brought in, after being accused of not participating in the local inspection and all those things, he then showed us a proof of him with the PP doing the local inspection. So I want to say, Honorable Chair, to agree with the sentiments expressed by Honorable Ngola, to say that those, the witness, Mr. Samuel, what he gave to this committee stands, Chairperson. There was victimization, there was intimidation by both the PP and Mr. Mahlangu. Thank you.
Thank you, Honorable Dlagude. Honorable Lotrit.
Thank you, Chair, and good morning to all the colleagues. Chair, I would also support what has been said, and I think it is quite clear from the evidence that was led that even the CCMA exonerated Mr. Samuels. And if I just look at some of what the Commissioner found there, that some of the charges were deemed to be hopeless and could not constitute misconduct by any stretch of the imagination, and that the disciplinary action is a clear demonstration of anger. So that clearly to me indicates that there was indeed a case of victimization, and also, as I think Honourable Sukas said, that the disciplinary charges were instituted exactly the day after Mr. Samuel's later complaint. So to my mind, I think there are clear evidence of victimization. Thank you.
Thank you for your contribution, Honorable Lotrit. Honorable Suela.
Thank you, Chairperson. Chair, I want to concur with the other speakers that evidence given before this committee by Mr. Samuels really indicated the issue of victimization, more especially from her side. And then the issue of saying that he was not part of the inspection, which happened where he proved by producing pictures before us, is also questionable. So again, the focus was on the assault. But if I remember very, very well, the person who claimed to have been assaulted, when he gave evidence before this committee, it was the issue of Kamina Kawena, because they beat each other, because that's what we heard in this committee. But the issue of victimization to Mr. Samuels was high, and the PP failed to defend that with her team. So I'm really in support of what other honorable members are saying, that Mr. Samuel was victimized. Thank you, Chair.
Thank you, Honorable Suela. I remember you put the Kamina Gawena to Mr. Siabi. You seem to be consistent on that. Thank you for your contribution. Any other member on this matter who wants to contribute? Honorable Tlape.
Thank you, Chair, and good morning. Chair, I'm looking at the questions, and what is outstanding for me was the proof, which then brings a lot of responses that the honorable members has brought in of victimization, of intimidation and whatever, but the protection of the employer of Mr. Samuel, I found it wanting on the issue that he fought with the client, because there's always two sides of the story. Now, you can't just institute a disciplinary action without hearing both sides. Hence, I would speak to issues of being threatened and having DC instituted against him. So that lacked protection from those that employed us. And Honorable, I think it's Honorable Sukas, spoke about him always being sick, according to the CEO, and that is a sign of burnout. When you look into issues of labor relations, if you're not happy if the working environment is not conducive, you are bound to pick such as signs of burnout when protection of those that employ you. Thanks.
Thank you very much, Honorable Tape, in adding also other elements for completeness. Thank you. Any other member? Honorable Ngosi.
I agree broadly with what members are saying, but I just want to note that the independent panel did not find Mr. Samuel's evidence to raise prima facie evidence of victimization. And therefore that in terms of our finding, it would be based strictly on what he gave evidence, on what he said in the committee in his evidence, to choose from that there was harassment by or on behalf of the public protector. In this regard, I think that as members, we should really use our aid memoir to arrive at that decision, so that we are able to reach a decision independent of the independent panel ourselves. So that it must be clear that it is not a finding of the IP, but it is what we are deducing from our interaction with the witness and exercising our original rights, our original responsibility. Thanks, Chair.
Thank you very much for bringing up that angle, Honorable Nkosi. Any other member? And is there a member with a different view or dissenting view of what has been said so far? None. Advocate Mayosi, any final remarks you want to make?
Chair, I think there's an aspect that members need to speak to, which is whether or not the charges that he faced were trumped up, which is paragraph 34 of the questions. I think that is an aspect that needs to be spoken to.
Okay. Thank you. Any quick response to that, members? Any member? Honorable Sukas?
Yes, Chair. My comment on that, Chair, is just the timeline. I think the timeline speaks to, like I said, I called it a campaign, but I think it seemed as if the charges and the disciplinary action, all of that followed Mr. Samuel's complaint. And it is within that context that one can say that these things were brought up because of Mr. Samuel's complaint.
Almost like a reaction, is that what you're saying? Okay.
Yeah, I tend to agree that the charges wouldn't have been brought up had Mr. Samuel not challenged, not the authority, but the decision-making process and arriving at decisions that are not consistent with the requirements, I mean, with the prescripts of the PP's office, and be seen to be standing up to authority, right? That what do you call it in our parlance, speaking truth to power. And I think on that basis, if now strictly not speaking in terms of what the evidence is here before us, but in respect of the type of atmosphere that ensued after the appointment of the PP, it's clear that she brooded no dissent to what she thought should happen. And therefore, these charges for me arises from the fact that Mr. Samuel stood to her authority and stood his ground in relation of what he knew was supposed to be done. So they were trumped up for me. Thanks.
Thank you, Honorable Kosi. As I go to Honorable Mailam, Maneli, and Van Minen, I'm going to ask Honorable Mananiso and Clapper to drop your hands, if it's old hands, unless it's new hands, so that I can see who's next. And as well as Honorable Sukas. Honorable Mailam.
Thank you, Chairperson. Chairperson, my only comment with regard to the charges against Mr. Samuel, and I'm struggling to recall the exact nature of the charges, but the incident with Mr. Siabi, Mr. Samuel admitted that that altercation took place. And I think that a charge is not a guilty finding. It's a process that has to be answered. And so I think that with regard to the altercation with Mr. Siabi, to those charges. Thank you, Chair.
Thank you, Honorable Mailam. Honorable Maneli.
Thank you, Chair.
Yes, you can switch off your video so that you save your network.
I just wanted you to confirm, Chair, that it's me, not there.
Yes, it is Boise Maneli, I can see.
Thank you, Chair. Of course, Chair, the other points are already covered, and I wanted to just come to the point raised by Honorable Kosi on the timing of the charges as a reaction to what would have come. And I want to indicate, Chair, from evidence led, you would then understand that this is not just at that end point where he finally approached other authorities. But given his standing, he would be represented in forums where matters get to be engaged. And in that engagement, he would have raised these matters that make their work to be not easy, be it ability to go out and do physical engagement as investigators and so on, and those matters would be dismissed. However, there will be demand to meet the deadlines. And those deadlines would lead to what Honorable Member Dr. Manketsi would have raised about being burnout and so on. And you are still expected to respond. And the question was whether the employer has been able to help them to do the work. And it was clear at that time that protection wasn't there, but there was a demand for meeting up deadlines, right? And therefore, because you can't find anything else there, that's why even this part about the assault could be seen as trying to find something that you can use, because on the matters before you can't pin the person down. That's a submission I wanted to make, Chair, in agreeing to Trumba. Thank you.
Thank you, Honorable Maneli, for the contribution. Honorable Van Minen, and to be followed by Honorable Suela as the last speaker on the line.
Thank you very much, Chair. I think on the issue of the charges, I certainly think there's an indication that the charges were, I don't necessarily want to go as far as to say trumped up, but certainly massaged. But I do think the question needs to be whether or not the threshold of suitable proof is reached. I think the assault certainly did happen. I think there may well have been a defense against those charges of provocation. And I think that goes to really strengthen the suggestion that the charges were massaged be more than they were. But I'm not entirely convinced that the necessary threshold of proof has been reached in this regard. But I certainly think there are indications of the charges being assisted, should we say. Thanks.
Thank you, Honorable Van Minen. Honorable Suela.
Thanks, Chairperson. Without any waste of time, Chair, to me, the timing of the charges is highly questionable, because you complain today, tomorrow you are being charged. So to me, this was a pure revenge, which was happening or occurring to Mr. Samuels. So the charges really wanted just to indicate or suppress Mr. Samuels on his way to justice, because he complained. And my belief is that the authority there, or all those who are in power, they were supposed to listen to his complaint, but because he had no powers, and that's what happened to him. So the timing itself, it's highly questionable, Chairperson. Thank you.
Thank you, Honorable Suela. Thank you, honorable members. Any dissenting voice or different view on what has been shared in terms of the last point, 34? Thank you. There being none, we now proceed to 10.2 of the motion. Advocate Mayosi?
Yes, thanks. Thank you, Chair. Thank you, Chair. We now move to Mr. Abongile Madiba and the questions of whether there's evidence of intimidation, harassment, and victimization in relation to him. As members will know, Mr. Madiba passed away, according to the evidence of Mr. Mohaladi, a month after he was found guilty on the disciplinary charges that were put to him arising from his involvement in the FSCA investigation. So he obviously wasn't, his direct evidence was obviously not part of the proceedings of this inquiry. His evidence in relation to him was given by Ms. Mohaladi, and her evidence was she felt that the advocate Mkhwebane displayed an uncompassionate attitude towards him because he was not well, and he was a good investigator, competent investigator, and he was required to perform at certain levels where Ms. Mohaladi, according to her evidence, she felt he wasn't particularly supported given his health challenges. The evidence that Ms. Mohaladi led in relation to Mr. Madiba was also in regard to what the executive managers relayed as the unreasonable deadlines, and Advocate Mkhwebane's rigid and unbending attitude when it came to deadlines. And that's the memorandum of the 2nd of November, where Mr. Madiba explained to the PP why it is that he couldn't deliver on the Section 7.9s that he was required to deliver at the time. And her response, and he requested an extension. The PP's response was to reject that request for an extension and to in fact instruct that warning letters be issued to Mr. Madiba and Ms. Sekele as a result of their failure to deliver on what they were supposed to deliver. So I'll leave it there, Chair. The evidence is also relevant to the next paragraph, which is 11.1, about internal capacity and effective and efficient use of resources. But I'll leave it there when it comes to Mr. Madiba.
Thank you. Thank you, Advocate Mayosi. Members, there you are in terms of your responses, so that you respond to these questions, but generally to indicate whether there is an established evidence from what we've gone through to indicate that Advocate Mkhwebane intimidated and harassed, as well as victimized Mr. Madiba, whether Mr. Mahlangu himself harassed, intimidated, and victimized Mr. Madiba, and if Mr. Mahlangu did that, and if Advocate Mkhwebane did that, were there any steps that were taken to protect Mr. Madiba? I now invite members. Honorable Heron.
Good morning, Chair. Actually, before we get into the question, and maybe it also relates to the previous question, I wonder if either Advocate Ebrahim or Advocate Bauer can talk about whether we're dealing with splitting of charges or proliferation of charges, where the same incident is now leads to several charges. Are we in that territory where we are dealing with splitting of charges? Can we get clarity on that from a legal perspective?
Okay, I will ask Advocate Bauer to respond to that. Did you get that, Advocate Bauer? Or Advocate Mayosi?
Sorry, Chair, can the Honourable Member Heron just clarify the question?
Okay, please come back, Honourable Heron.
I'm asking whether these questions and these charges, which certainly Mr. Madiba, if I remember correctly, arises out of the same incident, and the same with Mr. Samuel, his disciplinary charges, whether in the motion, the charges that are put to Advocate Mkhwebane, we're not venturing into, or we're not ourselves creating a proliferation of charges, In other words, the same incident is giving rise to several charges that, that sort of throwing everything at Advocate Nkobani that could possibly be thrown without identifying the correct or the only charge that should be profit. So I'm just asking: are we not venturing into splitting of charges here?
Okay, thank you. Advocate Mayosi.
So the incident, just from an evidence perspective, the incident in relation to Mr. Samuel is a different one. It arose from an assault that occurred in 2011. It doesn't intersect with what ultimately occurred as far as the evidence that's before this committee in relation to Mr. Madiba in 2018. The honorable member will be aware, and as well as other members, that the evidence in relation to Mr. Madiba is very limited. It was really led by other people who spoke about him, including Mr. Lamula, who was called by the PP, who had different evidence about him. So they don't relate to the same incidents. But the question really for the committee is whether the evidence that is before this committee now in relation to Mr. Madiba really rises to the level of establishing harassment, victimization, or intimidation on the part of either Mr. Mahlangu or the PP. So my answer would be the evidence relates to different incidents and different experiences of the investigators. But the question really for the committee to answer is whether the evidence as it stands in relation to Mr. Madiba rises to the level of what is required.
Chair, may I just clarify? I'm not asking. I do understand that the charge relating to Mr. Samuel is a different incident to the charge relating to Mr. Madiba, and in both cases, I'm asking the way these questions are phrased. Did Advocate Nkobani intimidate Mr. Madiba? Using the same incident, are we going to say that? Are we not splitting the charges if we're talking about intimidation, harassment, victimization, all arising from one incident? And it's similar to Mr. Madiba. We asked all these questions arising out of one incident, which is the proffering of disciplinary charges. So I'm asking, are we not, with both of these maybe, splitting charges by asking, if we were to find Mr. Madiba was intimidated and harassed and victimized, all arising out of the same incident, or is that not a splitting of charges?
Advocate Mayosi, over to you.
Yes. So I think that question is a question that the committee would need to consider in relation to Mr. Madiba, Ms. Sekele, and Ms. Mohaladi, rather than Mr. Madiba and Mr. Samuel, because the incidents there are different. But the Mr. Madiba, Ms. Sekele, and Ms. Mohaladi, disciplinary proceedings were pursued in relation to them arising from their conduct in the FSCA matter. And when the committee deliberates about whether or not the charges were trumped up, that is where the committee is going to have to make that finding that it's a splitting of charges or not. But paragraph 10 talks about things that happened to staff in general, as well as to the particularized individuals. So I think the answer that I would give to Honorable Heron is, I think the question arises with Mr. Madiba, Ms. Sekele, and Ms. Mohaladi around the splitting of charges. And there's a debate that the committee should have there in relation to those individuals, but not in relation to whatever happened to Mr. Samuel.
Okay, thank you. Thank you, Advocate Mayosi. I hope that helps. Honorable members, Honorable Heron wanted clarities around the nature of the charges and whether we're splitting them, but the questions remain on Mr. Madiba. So I'm still inviting members to respond to that. Any take from any member on whether we do have, if there is any evidence that establishes any of those harassment, intimidation, and victimization by both the PP and Mr. Mahlangu on Mr. Madiba? Honorable Nkosi.
Thanks, Chairperson. I think that in relation to Mr. Madiba, the following for me. One, in relation to the FSC matter, indicated that the deadline could not be met and requested an extension. That extension was refused by the public protector, irrespective of a detailed explanation that was given. And the deadline was imposed. So not taking into consideration the circumstances that the investigator faced, the public protectors and Mr. Vusi Mahlangu seem to have insisted that this deadline be met. Just to use a different analogy, it's a form of Fordism, you know. Systems must flow. One must lead to the other in a mechanical way until you have the final product. Unfortunately, the nature of the work that it does seem that the public protector deals with does not respond to a mechanical factory-oriented method, where there are, for example, we heard that there are some issues that are party dependent, third party dependent. If a department doesn't respond, if a person affected doesn't respond, it affects the internal deadlines. So you can't approach it like in a mechanical way. The other issue is really that at the time, Mr. Madiba is said to have been of ill health. So instead of addressing the ill health issues or giving him time to recuperate or asking him if he copes with the issue and therefore it be shifted to another person, an insistence was made that these deadlines be met. So in my view, yes, he was intimidated, harassed, and was not given protection by the public protector, implemented through the instrumentation of Mr. Vusi Mahlangu as the CEO, acting CEO. Thanks, Chair. Chair, I'm done. Or am I don't have load.
I just got cut out. Honorable Nkosi, I cut out when you're speaking. Are you done?
Yes, I'm done. I was surprised that maybe I was speaking alone. I'm checking. I don't have load shedding.
Okay. I would have missed a bit of what you said, but let's continue. I think we treat these more as observations and not necessarily findings. But Honorable Heron, your contribution.
Chair, yeah, I don't think that we had evidence that rises to the level that can find intimidation, harassment, or victimization. I think, first of all, unfortunately, Mr. Madiba has passed away and was unable to give his own evidence. But the fact that an unreasonable deadline was imposed on an employee does not amount, in my view, to intimidation, harassment, or victimization. It may just be an unreasonable management attitude. And if I remember the evidence correctly, Mr. Madiba was then given an Audi letter which would have allowed him to respond to say why he couldn't meet the deadline. And there was no further action taken against him. So I don't think that we've established evidence of harassment or victimization or intimidation. Thank you.
Thank you, Honorable Heron. There's a concrete view raised there by Honorable Heron that it doesn't amount to what we have come across, doesn't amount to those issues as evidence. Let me hear Honorable Sukas and Honorable Milam.
Chair, I'm relying on my memory, and I think the evidence leaders can maybe respond to that. I recall that there was disciplinary action instituted against Mr. Madiba, and that reference was made by the witness that in one of the meetings, his son had to accompany him because of Mr. Madiba's deteriorating health. I mentioned this in response to what was said by Honorable Heron, that, and also to add that in general, it seems as if there was a culture, a punitive culture within the organization. We spend an excessive amount, not excessive, but we spend a lot of time on the question of the environment and the impact it had on the outputs of the organization or the performance of the organization, especially in relation to the judgment. So what I want to say is that there certainly was an environment where Mr. Madiba ordered testimony then of his colleague, and I think who was his line manager at the time, indicated that the overall environment and the pressure on deadlines and the insistence on the timeline, even the reducing of timelines, and the impact it had on Mr. Madiba, it has to do with the culture of the organization, right? And I think that's just I just want to respond to that. And inevitably that leads to the performance outputs of an organization, and it has an impact on the individuals in the organization for them then to feel that either they are harassed or they are intimidated, right? I wouldn't, I just wanted to respond to that. Thank you, Chair.
Thank you, Honorable Sukas. Before I go to Honorable Milam, so the point you're making, so you're not disagreeing with Honorable Heron that we're not able to establish that there would have been harassment, victimization, and intimidation by both the suspended PP and Mr. Mahlangu, but rather you are arguing that we would have established a very unhealthy and unhappy environment, which would impact on the performance of staff. So that's a point I take from you. Let me proceed. Honorable Milam.
Thank you, Chairperson. I want to concur completely with what Honorable Sukas has just said about the way Mr. Madiba was treated, particularly during his period of ill health. But my concern arises primarily from the use of Audi letters and the manner in which they were used. And it appears to me that Audi letters were weaponized in that many issues could have been resolved by a simple sit down and chat with the affected person. But instead, the approach was used. We're going a formal disciplinary process. You have an Audi letter, you must respond. Here's a timeline, and there will be consequences thereafter. So I am concerned that the use of Audi letters became weaponized under Advocate Imkoubane and Mr. Mahlangu. Thank you, Chair.
Thank you, Honorable Milam. Honorable Maneli, to be followed by Honorable Ngosi.
No, thank you, Honorable Chair. I think the points about the environment, one is going to raise that, as already raised. But I think the structure of the questions, as it relates to Mr. Madiba, brings this difficulty, Chair, because as I was quiet, I was trying to rely on memory and checking on my notes. This correctly. Is that a counter to this argument of him not being treated well and so on, still having to meet deadlines? Was that necessarily from a point of commitment of Mr. Madiba, may his soul rest in peace, was such that he would not let go on the task because he would want to complete what he would have started. And this was shown as a way of trying to give him the support. I'm saying the counter that would have been given. Now, in this case, when faced with that reality, Chair, is that even the supervisor of Mr. Madiba, it will be relative info as it is not led evidence by Mr. Madiba himself, given that reality. And therefore, even the counter to in that regard would have been on the basis of how they relate to Mr. Madiba and that they called support that they were trying to give. And I'm saying then in the absence of Mr. Madiba, like the other witnesses who came and presented their cases and could relate intimately with what has happened in terms of their personal experiences, it makes it difficult in that sense. So I'm just saying that as the questions are structured, would have been easy with Mr. Samuel who came and the others who came. And of course, there are sensitivities, I must say that up front, that we are talking to a person who could not answer for himself. And I wanted to persuade in that score, Chair, that probably we do not make an expression on this part in the absence of Mr. Madiba having led, except what we would have received from both sides and give the benefit of doubt in that score. Thank you, Chair.
Thank you, Honorable Maneli, for the contribution. Honorable Nkosi, is that a new hand, Honorable Sukas?
No, Chair, if it's me, yeah, Chair, I think I do understand the contention of members that you know, Mr. Madiba, may his soul rest in peace, may not have given evidence or be in a position to give evidence in this matter. But relying on what the other witnesses had said about him and the responses of both the PP and Mr. Mahlangu, it's clear that, for example, in addition to what I said earlier, Mr. Mahlangu testified that the PP does not involve herself in disciplinary measures. However, it is the PP who writes in a memo or in a report that the deadline must be met, failing which she insists on the deadline being met, and that disciplinary action be taken against Mr. Madiba after issuing him with a warning. That contradicts, in my view, Mr. Mahlangu's assertion that the PP never involved herself in disciplinary measures. But otherwise, yeah, if the reliance is on Mr. Madiba not being able to give evidence himself, that's a bit persuasive. But I think the evidence before us indicates that he, like all others, okay, let's say he, faced this harassment, this intimidation and victimization by the public protector, weaponizing Mr. Vusi Mahlangu as COO or acting COO. Thanks, Chair.
Thank you, Honorable Ngosi. As I go to you, Honorable Sukas, is that your next bite?
Chair, mine is to ask the question whether we are going into the general or whether we're staying on the specific individual. I just need to ask because there are obviously comments that I have on the general category that falls under the same theme.
We are on this individual.
Yeah. Thank you, Chair.
All right. So if I take it, members, from what your contributions are, there seems to be a general view that we don't necessarily have a concretely established evidence to conclude that there would have been this harassment, intimidation, and victimization by both the suspended public protector and Mr. Mahlangu, and that as I think Mr. Manel would raise, that we need to therefore say that we can't express that there is emphatically that on this issue. I think the strong points raised by Honorable Nkosi have been noted, but I think he seems also to be persuaded that we could go along in saying we are not having evidence to establish this. Am I summarizing you correctly on this?
Yes, sir.
Thank you. Any final remark on Advocate Mayosi before we proceed to 10.3?
No, I don't have final remarks, Chair.
Thank you. Proceed to 10.3.
Yes. Chair, I will deal with 10.3 and 10.4 together.
No problem. Go ahead.
Ms. Sekele and Ms. Mohaladi. Members will recall that Ms. Mohaladi gave evidence that related to them both, and Ms. Sekele filed an affidavit confirming the contents of Ms. Mohaladi's statement. They were involved in the FSCA investigation, and they were then charged in relation to their conduct in the FSCA investigation. They, together with Mr. Madiba, they were found guilty of some of the charges, and a sanction was imposed in relation to them. The PP didn't accept the sanction by the independent advocate who presided over the disciplinary proceedings, because she thought that what they had been found guilty of was serious enough to warrant a dismissal. She sought representations from them. They then approached the High Court, and they succeeded in their approach to the High Court in terms of setting aside the PP's decision to actually call for their dismissal in the face of the disciplinary finding. They then served out their sanction that had been imposed on them, and they returned to work. So the evidence of Ms. Mohaladi under cross-examination was clear that they did not challenge the disciplinary sanction for various reasons. The whole experience had been stressful on them, and so on and so on, and they took a decision that they wanted to return to work. What Ms. Mohaladi felt to be victimization in general was the manner in which Audi letters were issued to her, the manner in which they were disciplinary proceedings were pursued against them in the FSCA matter. Her evidence seemed to be that they had not really been involved in that investigation. She had just taken over the portfolio of GGI when she had to produce the Section 7.9 and the report in the FSCA matter, and she needed more time, and she had stated to the PP that she needed more time. So in essence, that was the essence of the evidence that Ms. Mohaladi gave in relation to how she felt victimized in relation to just not only the FSCA matter, but other matters that she had been involved in, how she was not heard when explaining why it is that she could not meet deadlines, even those that she accepted that she had imposed on herself. And yeah, so the victimization for her in terms of the evidence that's before the committee and Ms. Sekele arose from the matters that she was involved in. But when it comes to her, Ms. Sekele and Mr. Madiba, it then of course arose from the FSCA matter and the disciplinary proceedings that were pursued there. I'll leave it at that, Chair.
Okay, you've attended to both?
Yes.
All right. Thank you. Honorable members, I now invite you to respond to these questions. Same issues of harassment, intimidation, and victimization by both the suspended public protector and the former CEO. If in your view we have established evidence that there was such on these, let's start with Ms. Sekele, and then we'll go to Ms. Mohaladi. Any contributions, any takers? Ms. Honorable Sukas.
Yeah, Chair. I think the evidence of Ms. Sekele again points, when she presented her evidence, pointed to the atmosphere that resided within the Office of the Public Protector. And I think one of the previous points that we possibly did not note was that when she brought her evidence as well, she mentioned the issue of suspension of, again, the deceased Mr. Madiba, and I appreciate the sensitivity with that, so I want to not dwell on it. But she spoke on the suspension and the disciplinary. Again, for me, I think it painted a picture of the environment, and that I think in one, again, if my memory serves me right, there was mention of Mr. Matlangu being the enforcer almost, or that he was viewed as the enforcer for what the public protector wanted. So my comment on this is, I think the most of what for me stood out from a testimony pointed back to the environment that was within the organization. It also gave us a view of what were the ultimately contributed to the let's say the performance or lack of performance in some of the areas that is highlighted in the cases that was brought before the committee. So I think from that it was very valuable to know in terms of systems, processes, and the most important asset of the organization, the people of the organization, how they were treated and felt under the leadership of the public protector, and how that contributed to their work. Yes.
Thank you, Honorable Sukas. In terms of your response, we're not able to point out that we have evidence, but re-emphasizing the issue of the environment and the culture in the organization as the key issue that is emerging here. Any other members?
Chair Nkosi,
okay. Honorable Nkosi, followed by Honorable Heron and Honorable Maneli.
Chair, I agree with Honorable Sukas. If you look at what ensued really in this in this matter, or it combines both. So I'll deal specifically with the Sekele issue that it's very difficult to differentiate from.
Sure.
But Chair, it's clear that in respect of both, Sekele indicates that she came late to the FSC matter and that it was a complex matter. However, irrespective of the fact that it was a complex matter, something which would have, which the public protector or the CEO would have known, and therefore given her opportunity to familiarize herself with the issue. Instead, you need to meet this deadline. You need to meet this deadline. And on the basis of not meeting these deadlines, this was subjected to disciplinary action and decisions were taken on them. What concerns me, Chair, is that the public protector, in respect of the disciplinary action, differs with the decision of the chairperson and instead institute another process which they challenge in the Labour Court without reason, without giving them the opportunity to respond. So in respect of Sekele, I do agree that there is harassment, intimidation, victimization of Sekele. And this is in line with what the atmosphere was in the office. But also remember, Chair, that the warning given by the drafter of the section 7.9 that this matter may be challenged, which eventually did happen. And we'll come to that when we discuss Mohaladi. So I agree that the questions are answered in the affirmative. There was intimidation, there was victimization, there was harassment. Church. Thanks, Chair.
Thank you, Honorable Nkosi. Honorable Herron.
Thank you, Chair. Chair, I think this is where my question around splitting of charges arises. The public protector's refusal or to accept the outcome of the disciplinary process and to proceed against Ms. Sekelele and Mohaladi. I don't think we can say it amounts to both to intimidation, harassment, and victimization. I would say that it is victimization, but I don't think it can be harassment and victimization and intimidation. And that's the question I was raising earlier. So I would say that it amounts to victimization, but it can't also be harassment and intimidation. Okay, thank you.
Thank you, Honorable Herron, for your contribution. Honorable Maneli.
No, thank you, Chair. In agreeing to the point made by Honorable Nkosi, that I also go on the affirmative, yes, those who would have applied. And I think it can be seen also, Chair, from a point of not considering personal circumstances. That if you want this to happen, it has to happen. It would not matter if you are attending to your sick son outside of a province. If something needs to happen, it has to happen. That gets to a point of harassment. It won't just be about victimization in a disciplinary process. And of course, setting up the disciplinary process and then you do not agree with your own outcome that you should adhere to and get forced by another body to implement that you started yourself. It's I think, like Honorable Nkosi would have said, it's also demonstration of power, Chair, that it shall go the way I want. It doesn't matter what other processes would say. And that's really even about threatening jobs of people. So you're harassing them in that score. So I'm saying I think on this part I agree because, Chair, in the passage that has been shared, and I think that's the reason, Honorable Nkosi, the two are combined instead of separate, because even in the affidavits, they would have a lot of collaboration in terms of what really happened between Sekele and Mohaladi in that score. That's the submission, Chair. Thank you.
Thank you, Honorable Maneli. Before I proceed to other members, I see your hand, Advocate Mayosi.
Yes, thank you, Chair. I think if I'm understanding Honorable Heron's reservation correctly, there is merit to what he raises, in the sense that in this charge, what Advocate Mkhwebane and or Mr. Mahlangu are said to have done is to have intimidated or harassed and or victimized staff. And the committee just needs to be aware of the fact that the committee can't find harassment and intimidation and victimization all in one in the same action. It has to be either intimidation or harassment or victimization. I just wanted to point that out, that the committee should perhaps be aware of that during its deliberations on this charge.
Okay, thank you. Any further members to contribute? I think from the 4 members who have spoken, issues of environment and the culture and organization are raised by Honorable Sukas. Honorable Nkosi is of the view that these issues of harassment and victimization do apply, and Honorable Heron on the victimization part that he can connect with, and the emphasis on the harassment part and the use of power by Honorable Maneli. Any further inputs or comments, members? None. Honorable Suela.
Chairperson, I have got a problem with my gadget. Sometimes when I try to raise up my hand, I'm not seen. But I just want to concur with other colleagues, Chair, that issues of harassment really does prevail into this, so that we put it in record. That's what we have realized. I am really in support of what other members have said, but I've got a problem with my hand. Sometimes I will have to shout if the chair allows me to do that, because it deprives me to participate, Chairperson. Thank you.
No problem. Thank you. And Honorable Sukas, on some of the points you made before, especially on Mr. Mahlangu, the allegations were that he was an enforcer. So I think evidence might not support that. So I think we shouldn't carry that forward unless there's evidence that demonstrate that he was. So just that use of language on how we deal with this. Any other views? Any other contributions? Okay, none. So we will then record those honorable members. And I think Advocate Mayosi was also agreeing with Honorable Heron that so that we don't package them in one unless specified. They could be in one if there's evidence that points that in each case this has happened, but we shouldn't just be generalizing around those. Your final remark, Advocate Mayosi?
No, Chair, my apologies.
Chair, in relation to this.
Yes, before you proceed, you can also ask Advocate Bauer not to whisper because I can hear her. So she has an opportunity to speak because the whispering is much louder than she thinks. Honorable Nkosi, before
I thought we were starting with Sekele and going to Mohaladi.
Mohaladi, yes.
Oh, okay. No, if that's the case, I'm covered. Second is that
we still go to Mohaladi.
Yeah, I think in the case of the splitting, I think when we discuss the final report, it should be clear whether the harassment emanates from the PP, in fact, whether intimidation, harassment, victimization in each case arises from either the PP or Mr. Vusi Mahlangu. So you may find that variously, both have been involved in harassment, intimidation combined, or individually in relation to the harassment, intimidation, and the victimization.
Okay.
I'll speak to that more maybe when we deal with the final report in draft.
That's fine. We'll go to Mohaladi now. Advocate Mayosi?
No, Chair, I'll allow my comments were really in relation to Ms. Baloy, so I think the committee needs to still proceed and deal with Ms. Mohaladi. I'll let that.
All right. Any specific contributions and comments in relation to Ms. Mohaladi, honorable members? Honorable Nkosi, I'll start with you.
I feel victimized, really.
That should be harassment, not victimization.
No, Chair, in relation to Ms. Mohaladi, I think the committee would remember that we spent a lot of time on Ms. Mohaladi, etc. And my view, Chair, is that in a nutshell, in her respect, one that I think she was harassed, and because in her explanations of why she's not meeting deadlines, she gives context to what I earlier referred to as Fordism. You know, that matters are not, will not simply follow from A to B up to Z, that there are circumstances that would impede on progress, so that the means towards the end should be justifiable, and that this is what she found the public protector not acceding to, her inflexibility in relation to the meeting of deadlines. And that comes across really as victimization in case you do not meet those deadlines. And the conduct of the CEO, Mr. Mahlangu, in relation to her also indicates the issues of harassment and victimization. And as I said, Chair, earlier, that it may help that when we finally deal with the report, we indicate in respect of each one whether there was an instance of harassment, or this constitute an instance of harassment, intimidation, or victimization. In my view, currently, I think I see all of them being positively answered. Thanks, Chair.
Thank you, Honorable Ngosi. As I invite other members, Ms. Mohaladi, just to remind you that we make use of your 8 memo. Some of these definitions are specified there on harassment, intimidation, and victimization. And this was for the purpose to assist us so that we will make proper connections. We don't mind, we could easily beam that up again, but I'm hoping that members have stayed close to that 8 memo. Any other members? Honorable Heron.
Yes, Chair. I hold the same view with regards to Ms. Mohaladi as I did with Ms. Sekelele, that the finding should be victimization and not intimidation, harassment, and victimization. And if you look at the evidence, Ms. Mohaladi herself used the word that she felt victimized.
Thank you. Thank you for the contribution, Honorable Heron. Any other member? Honorable Suela.
Thanks, Chairperson. I support my colleagues that Ms. Mohaladi was victimized. Thank you.
Thank you. Any other member? Honorable Maneli.
Well, thanks, Chair. I don't know what happened. I've been trying to raise the hand, but I still maintain what I would have raised earlier, Chair, because I tried to combine the two. That if there are also personal circumstances and you have to attend to emergencies, even if you have given an indication of why you needed to extend the time because we are attending to an emergency, you still get a direct text message that demands that certain things have to happen and you have to be recalled. I think at the time we deal with the final report, like Honorable Nkosi would have said, we may want to put that test whether that is still just victimization or harassment. Thank you.
Thank you. Honorable Van Minen.
Thank you, Chair. I don't want to dwell on this, but I do think we need to have a serious decision or serious discussion on the difference between victimization, harass, and intimidate. I mean, if you look at legal definitions, intimidation means compelling or deterring conduct by threat. It's an act or a course of conduct directed at a specific person to cause that person to fear or apprehend fear. Whereas harassment is engaging in the course of vexatious comment or conduct against a worker in a workplace that is known or ought reasonably to be known as unwelcome. I, in this particular case, favor intimidation over harassment, but I think that is a conversation we're going to need to have because I think there are legal consequences. Thank you.
Thank you, Honorable Van Minen. Maybe before we wrap up or summarize this, Miss Ibrahim and Tsepo, for 2 minutes or so, do you mind just, we'll come back to the next one to just remind members of those 3 categories. As we have it in the aid memo that was shared yesterday. Just to offer ramp in order to just make sure that we are on the right track. Ms. Ibrahim.
Thank you, Chairperson. It's on page, I think it starts on page 23 of the aid memoir. I'm just trying to quickly open it. Yes, that's right, on page 23, Chairperson. And so, Chair, we start with the definition of harassment. And in terms of the Promotion of Equality and Prevention of Unfair Discrimination Act, harassment is described as unwanted conduct in the workplace, which is persistent or serious and demeans, humiliates, or creates a hostile or intimidating environment, or is calculated to induce submission by actual or threatened adverse consequences. And then in terms of the Code of Good Practice on the Prevention and Elimination of Harassment in the Workplace, the purpose of that code is to eliminate all forms of harassment, and it recognizes various forms of harassment. And members will recall that I said to look at the footnote. So harassment either based on somebody's gender, on someone's race, for example, your religion, and so on. And then if you go down, Chairperson, harassment is understood in terms of section 4.1 of that code as conduct that is unwanted or unwelcome and which impairs somebody's dignity, creates a hostile or intimidating work environment, or is calculated to or has the effect of inducing submission by actual or threatened adverse consequences. It's related to one or more grounds in respect of which discrimination is prohibited. And it's that footnote at the bottom, the footnote number 6, which lists all of the grounds. So one would have to show which ground is the ground on which the harassment is alleged to be based. Then in terms of intimidation, Chair, that's also dealt with in the code as intentional behavior that would cause a person of ordinary sensibilities, and you submit that would be a reasonable person test to fear injury or harm. And we've cited a case there where the court held that to constitute intimidation, words need not be directed at particular persons, and further that words are intimidatory if they are calculated to terrify or overawe someone. Victimization, if we continue there. So victimization is not defined in labor law, but the dictionary definition of victimization is the act of treating someone in an intentionally unfair way, especially because of their race, sex, beliefs, etc. But in terms of statutes, Section 1862 of the Labour Relations Act deals with certain unfair labour practices that could amount to victimization. So, for example, unfair conduct relating to how an employee is promoted or demoted, their probation or training or benefits that an employee would get. So, for example, where you give one employee a raise but not another, but not somebody else without there being a valid reason for same. The unfair suspension of an employee or any other unfair disciplinary action short of dismissal. A failure or refusal by an employee to reinstate or re-employ a former employee in terms of any agreement, and then any other occupational detriment other than dismissal in contravention of the Protected Disclosures Act on account of that employee having made a protected disclosure defined in that act, because we of course know that employees have protections even if they were to blow the whistle, and they can't suffer any occupational detriment as a result thereof. Thank you, Chair.
Thank you, Ms. Bryan. Back to the Mohaladi slide, Tsepo. Thank you. So that was just the reminder to refresh as we go through this, especially in the light of what Honorable Van Minen would have said. But of the members that have spoken, I think both Honorable Heron and Suela are of the view that they think that victimization applies. Honorable Van Minen do introduce issue, intimidation, and both Honorable Nkosi and Maneli in dealing with the two, Sekele and Mohaladi, about the issues that would have applied to them, think that there's more than just one issue here, but when we get to finalizing the report, they would want to speak to emphasize on some of those issues. With that refreshing definitions having been done, if there's no change of mind or comment, I'm going to proceed to the next point with Advocate Mayosi. I take it there's none. Advocate Mayosi,
Thank you, Chair. Thank you, Chair. The next named individual in the charge is in 10.5, which is Ms. Basani Baloy. Members will recall that Ms. Basani Baloy was the COO from March 2019 until October 2019, when her her probationary period was not confirmed. So her contract was not confirmed and her services then came to an end. So she was not subjected to any disciplinary proceedings or disciplinary charges. She didn't face any of that sort of thing in the organization. What she then did, she challenged the failure of the public protector to confirm her contract. And she based that on the fact that Mr. Mahlangu and Advocate Mkhwebane wanted to purge her from the organization because of the stance that she took in relation to certain investigations and because of the interest that in particular Mr. Mahlangu had in some of the investigations. So she gave evidence in general also in relation to the environment that pertained in the office, the manner in which meetings were run, the manner in which Advocate Mkhwebane related to staff and wanted to be addressed. And yeah, that was the essence of her evidence. So her evidence was really in relation to the environment that she found in the office. She herself did not say that she had herself been intimidated or harassed, but the environment in general that she described in relation to the executive managers that reported to her and the issuing of Audi letters and how she had to issue Audi letters and how the executive managers even at some point told her that rather issue the Audi letters to us because you otherwise you are going to have action taken against you. Yeah, so the essence of her evidence really talks to the environment in the office of the public protector during the brief time that she was there.
Thank you.
And we'll discuss the environment more fully when we talk about the charge in 11.1, which relates to internal capacity and the management of the resources of staff.
Okay. Thank you, Advocate Mayosi. Honorable members, your take on Ms. Baloy. Anything you want to say in relation to what the journey we've traveled of this evidence, the fresh summation, the aid memo? I know you want to rely on your memory. I think you need to be referring to those whilst you have your memory helping you. Any comments? Are we all agreed on what has been said, with an emphasis on the environment, on Ms. Baloy? Honorable Suwela?
Chairperson, I think we need to agree with the sum up, because if the environment is not conducive for working, we can't call it victimization or harassment, but it's something which is what is a worrisome factor that anyone needs to be free in her own environment where she finds or he finds himself. So I think the summary is correct, and we are supposed to rely on it based on what Ms. Baloy alluded during her testimony before this committee. Thank you, Chairperson.
Thank you for your contribution, Honorable Suwela. Honorable Lothrit?
Thank you, Chairperson. I think if we look at the definition of victimization, it is quite clear from the evidence for me, specifically regarding Ms. Baloy's probation, that there was indeed an unfair conduct by the employer regarding to probation. If we read through this in terms of that she was it was 6 months, there was no assessment, then she had another 2 months. So I think there's definitely victimization in this regard. But there's also, to me, some sense of harassment in terms of how people were treated. But that's, yeah, so that would be my understanding of this, but definitely victimization. Thank you.
Thank you, Honorable Lothrich, for your contribution. Any other members? No other members. Any different views to be expressed other than what has been shared? Or should we proceed and take these so that we reflect them in our report?
Yes, sir.
Thank you. Thank you, Honorable Ngosi. We'll proceed to the next 10.6, Advocate Mayosi.
Thank you, Chair. The next named individual is Tebogo Kekana. He gave evidence before the committee. His evidence related in large part to his involvement in the CIX investigation. But he had also submitted a statement under the Protected Disclosures Act, where he wanted to bring to the attention of Parliament what he thought were the issues that he raised in his statement. And one of those in relation to this particular charge was he had a section dealing with what he thought was harassment. And that's one of the purposes on which he made the affidavit. He felt harassed. He was then subjected to disciplinary proceedings as a result of what was said to be a breach of confidentiality or disclosure of information that he shouldn't have had. And I think in his evidence, he felt that the charges that he was subjected to was as a direct result of his activism within the organization, and that's was the source of his harassment. He's not specific in his statement that it was specifically either Mr. Mahlangu or the public protector who he felt harassed by, but the gist of his evidence in relation to the harassment aspect that this charge is concerned with was that the disciplinary proceedings that he was subjected to were as a result of his harassment. He was found guilty, he was dismissed from the organization, and he ultimately litigated the matter in the labor court. So I think that's the gist of the evidence in relation to this particular charge. As I said, the bulk of his evidence related to the CIX matter, but he had aspects of harassment that he spoke to as a result of his being involved in the union and just his activism within the organization.
You're done?
I am done. Thank you, Chair. Sorry.
You. On Mr. Kekani, honorable members, can I invite contributions? I see Honorable Ngosi. Please go ahead.
No, Chair, I think that on Mr. Kekani, I will focus on two things. One is that he is the one who discloses under protection what he views as maladministration, unfair treatment, etc. And for that, he is immediately hauled before disciplinary processes and etc. So that for me is victimization. Two, or harassment. Two, he raises a thorny issue in a staff meeting and disclosed to the union that this person that is acting CEO or CEO variously actually doesn't have top secret clearance to work in that environment, but also to execute responsibilities assigned to the public protector. And that, I think, raises the issues in the ire of those that are in charge. And I think, I do find that he was intimidated, harassed, was victimized. Maybe intimidation, it's very difficult to prove, but in terms of being victimized and harassed, I think he fits the bill. Thanks, Chair.
Thank you, Honorable Nkosi, for your contribution and your elaboration on the matter. Any other members? Any takers? Or do we share what has been said? Is there any dissenting view? Honorable Siwela?
Chairperson, there is no dissenting view. I just want to support what Mr. Nkosi has said. The fact that the member or the official was also active in the union, and he revealed a lot of things. Hence, he was subject to DC. So to me, that was also a harassment and victimization in the at the workplace. So I'm in support of the summary as well as what Mr. Nkosi has said. Thank you.
Thank you, Honorable Siwela.
And so there is nothing wrong with an employee being part of unions. It's their constitutional right. It's there in the Constitution. There is completely nothing wrong with that. Thank you.
Thank you, Honorable Ngola. Any other member? None, and no dissenting view. So, as explained by Advocate Mayosi, harassment comes in. I think both Honorable Nkosi and Siwela raises the issue of victimization as well as harassment, and I'm agreeing with the summary that and the context painted by Advocate Mayosi. Thank you. We'll proceed to the next one. If you have no remark, Advocate Mayosi.
Chair, can we
can proceed to the next one, Chair.
Can you take a leg stretch? Or
we're about to we're almost there. On Advocate Mayosi.
Otherwise, if we don't, you will be the victims as well.
You are not being victimized or whatever. We just almost there. Advocate Mayosi?
Yes, Chair. Thank you, Chair. The next named individual is Advocate Isaac Makawi, and for reasons stated in the summation, he was not called as a witness. He was charged, he was served with disciplinary charges in relation to the same issues that Mr. Kekana was charged with, which was the leaking of confidential information. The evidence of Mr. Gelela, who's the human resources manager, was that Mr. Matlawe was charged at the instance of Mr. Mahlangu, but he resigned from the organization in December. The hearing, I think, his disciplinary hearing was set down for December, 21st of December, 2018. But it was never concluded. Nothing came of it because he then resigned from the organization and he left and joined the Johannesburg bar. There's scant evidence in relation to Mr. Makawi, and that is pretty much all that was stated before the committee in relation to him. He was charged, but the proceedings were not proceeded with or concluded because he left and went to join the bar. And that, in essence, Chair, is all the evidence that's before the committee in relation to Mr. Matlawe. He too was a member of the union, and he, as I said previously, was charged in relation to the same incident that Mr. Kekana was charged with, the leaking of confidential information. I'm done, Chair.
Thank you, Advocate Mayosi. Honorable members, your take, Honorable Lawthridge.
Thank you, Chairperson. I think that in this instance, we do not have sufficient evidence before us to make any conclusive finding on this. So I would say that we cannot express ourselves on this particular matter. Thank you.
Thank you, Honorable Lawthridge. Any other member? None. Are we agreeing with the sentiments as raised by Honorable Lawthridge? Is there any dissenting view? None.
No dissenting view, Chair.
Thank you. We then proceed to the next, Advocate Mayosi.
Thank you, Chair.
Yeah.
Thank you, Chair. I'm here. So, Chair, that brings us to the end of dealing with dealing with the named individuals. The charge clause also talks about staff in general, and I think the committee needs to deliberate about whether there was intimidation of harassment and victimization of staff in general. And in that regard, of course, the committee has the evidence of Mr. Samuel, Miss Mohaladi, Miss Mutsitsi, and Miss Tejane, who also described the environment in the organization, who described various aspects of what they considered to be an intimidating or harassing or victimizing an environment. All of them spoke about 4 issues really, with the manner in which meetings were run, the unreasonable deadlines, manner in which meetings were unreasonable deadlines, the Audi letters, and just the long working hours. They agreed upfront in support of the PP that the PP is hardworking. She requires high standards from her staff. They agreed upfront that the backlog is something that needed to be dealt with, and that the PP's efforts to doing so was laudable. They also agreed that Audi letters, in essence, are a good mechanism in order for staff to be heard. It was the manner in which these things were done that was problematic, how it was done. So I think that the committee needs to deliberate on the victimization or intimidation or harassment of staff in general, over and above the individuals that have been discussed. That evidence, of course, I say again, flows over into charge 11.1, and we may go into it in greater detail there. I'm done, Chair.
Yes, that's fine. We're still going to go to 11.1. And maybe we can hold that until then. But I think you're raising important points, members. If you want to comment, we have been dealing with the specific named individuals, but maybe also as a general point, want to raise, as we have done that in wrapping that up. Some members would have ventured into that, where you find there was a victimization, harassment, or intimidation, and whether those would have constituted misconduct on the part of the suspended public protector. Let me hear you. But you are saying, boss, now that we are finishing the paragraph 10, we'll go to, after the break, we'll take a break after your brief comments now. You still have, Honorable Milam, or should I start with you, Advocate Mayosi, before I go to Ms. Milam?
Yeah. Yes, Chair, thank you. I think, Chair, I'm remiss in not stating that there was contrary evidence, of course, from Mr. Futana Tebele, who said he's never witnessed intimidation or harassment or victimization of the sort that was described by the other witnesses, as well as the evidence of Mr. Lamula, who too said he has never witnessed such. Ms. Mvuyana also spoke of the same, as well as Mr. Rodney Mataboche. So the committee would need to consider that contrary evidence in its deliberation.
Okay, thank you. Honorable Milam.
No, Chair, before Milam, if I may ask, does that include what Mr. Vusi Mahlangu said to the in contrary to what the other witnesses indicated? The name being
correct, Honorable Member. Mr. Vusi Mahlangu also denied having intimidated or harassed anybody or having witnessed such in the organization.
Okay. Honorable Milam.
Chairperson, thank you. Chairperson, I want to just separate the victimization, which is the singling out of individuals and putting improper or undue influence over them. That would essentially be a way of looking at victimization, from the intimidation of staff more generally. And in that regard, I come back to my point that I made earlier about the weaponization of Audi letters, which in my view is a form of intimidation. It's one thing if Audi letters are part of a process that is transparent and fair and is part of a management process that encourages dialogue and discussion. But it's another thing entirely where they are used as an enforcement mechanism to ensure compliance. And I have a problem that the way that Audi letters were utilized in general was an intimidatory tactic utilized by the public protector and in Mr. Mahlangu's case on her behalf. Thank you, Chair.
Thank you, Honorable Milam. Honorable Sukas.
Yes, Chair. Chair, with your guidance, I don't know if this would fall under the general, and maybe if we need to go to, if this would fall under 11.1, but I just want to hook onto what was said by Honorable Milam in terms of Audi letters and the use of Audi letters, which in essence doesn't, in the way that I'm now contextualizing it, wouldn't specifically speak to victimization, but it would speak to mismanagement or management in general in terms of the organization. So I think my question, the issue with the Audi letters was, I think Advocate Mpofu asked Ms. Baloy during cross-examination if she was, and I quote here, she's saying there was an Audi environment, for example. In other words, there was an environment of obeying the rule of natural justice. The issuing of Audi letters is not a process that has been outlined or that is outlined in the Code of Conduct of the Office of the Public Protector. The evidence leaders can maybe confirm that for us as a committee. So if the Audi letters and associated process does not appear in the Code of Conduct, then it was a systemic failure to comply with labor law and is evidence of misconduct and incompetence. And I think previously, Doc, in the previous session, spoke on, the issue of labor law practices and such, but specifically when it comes to the use of Audi letters? Was it a tool of, is it a question of mismanagement and the way staff were managed, or was it a tool then of victimization? I don't know if it falls under, specifically under this, Chair, under staff in general, or if we move to 11.1 with that.
Yeah, thanks. We'll keep it, we'll flag that. Honorable Ngosi.
Yeah, Chair, I agree with what was said by Honorable Suka said. The other issue is what is flagged by Advocate Mayosi, that we need to objectively assess and test the contrary view of the other witnesses that appeared before us, Mahlangu, Makawi, and the others. And perhaps that we must do, because we must also subject that to our test and indicate whether we agree in full or in part with what they have said in the wake of what we have from the other witnesses. Thanks, Chair.
And you still want to hold that back? I thought you're getting into it.
Yeah, no. I think we can't do it generally. We should go to the specific evidence proffered by these. And I thought if we want to do it, we can do it immediately after lunch, or we can hold it to when we finalize the report.
Okay, thank you, Honorable Ngosi. You're already indicating about lunch. I don't know whether you will have lunch, but let's see when we get there. I think we're done with this. We can now take a 10-minute break. If you want to stretch your legs, do that, have tea or whatever, and then we come back and proceed to the next section. So please stay online. We'll just take that 10-minute break. Thank you. We'll be back at 11:30.
Recording stopped.
Thank you. Welcome back, colleagues.
Recording in progress.
We've been given extra few minutes in our extended break. Advocate Mayosi or Advocate Bauer, I hand back to you.
Thank you, Chair. Chair, are we? You're mute, Chair.
Yes.
Chair, are we now on 11.1?
Yes.
All right. So the charge in 11.1 is one, the preamble starting from paragraph 11 is that Advocate Mkhwebane has committed misconduct by and or demonstrated incompetence in the performance of her duties by failing intentionally or in a grossly negligent manner to manage the internal capacity and resources of management staff, investigators, and outreach officers in the office of the PP effectively and efficiently. I'll start with the issue of outreach officers, and there the evidence of Mr. Samuel and Ms. Motsitsi is relevant and is summarized for members from page 67, paragraphs 251, where Mr. Samuel, in his initial and second statement to the committee, where he set things out in greater detail, stated that due to what he described as rising litigation costs because of the increasingly litigious environment in the PPSA's office, he described it as reckless litigation. Essential programs such as the outreach program then suffered and had to be reduced in terms of the allocation of funds to them. And his evidence, as was that of Ms. Motsitsi, was that from the 2018-2019 financial year, outreach programs then reduced drastically. There were memos that were put out by the CEO at the time that due to funding constraints, programs could not be pursued. But he said in his evidence that it was not only just outreach programs that were negatively impacted by what he described as the reckless litigation that the office was pursuing, but in general, there was also prejudice to investigations and to the administration of the PPSA because vehicles were not available, budgets were reduced, investigations could not be conducted by going to the specific places to investigate, and investigations had to be reduced to desktop investigations because of the lack of funds. And again, he linked that redirection of funds away from essential programs to fund what he described as the reckless litigation in the office. Ms. Motsitsi then gave further evidence about the change in strategy about outreach, that in 2017, 2018, there was a change in strategy in performing outreach and doing a more district type of level kind of outreach in order to have a greater impact. Again, she also spoke about the funding constraints, the budgetary constraints, and how management then intervened to reduce, to respond to the budgetary constraints, as it were. The acting CEO, CFO at the time, who was Mr. Menzelwa, I think is the gentleman who had been seconded from the SSA to be the CFO at the PPSA, wrote a memo to Advocate Mkhwebane explaining the funding constraints. Some of the contributors were employment costs, but rising litigation was one of the contributors to the budgetary constraints. And one of the consequences was the reduction of outreach programs. So this charge really talks to whether or not resources, internal capacity and the resources of management were used efficiently and effectively under the tenure of Advocate Mkhwebane. And then, of course, the issue of internal capacity talks to productivity of human resources. And again, as I mentioned earlier when we were talking about paragraph 10, the previous charge, the evidence of the executive managers about how their time was used, the long meetings, the Audi letters, the environment that was ultimately created in the organization, which then the long hours, which affected their productivity, the short turnaround times, and so on, is an issue that becomes pertinent for the consideration of this charge. Again, Chair, the committee would of course have to also be aware of the contrary evidence in this regard, and that's the evidence of Mr. Futana Tebele, Mr. Lamula, Mr. Mahlangu, the Ms. Mvuyanas, and Mr. Mataboke, who gave contrary evidence that such issues were not necessarily there at the PPSA. Now, one of the people who gave evidence, as the committee will be aware, was of course Ms. Tejane. Ms. Tejane, the committee will remember, was cross-examined. There was a long time between her examination chief and her cross-examination, and she did not fare well under cross-examination. But what was not challenged under cross-examination was a report that she put before the committee, where a survey had been done in the PPSA by the Deputy Public Protector across the country in the branches, looking at the reasons why the backlog projects were not being met and why deadlines were not being met. And what was not challenged during cross-examination were the reasons that were given by staff, which reasons sought to corroborate, in a sense, or corroborate, if I could say, what the executive managers had stated about the unreasonable deadlines, the long meetings, the fact that Audi letters were found to be intimidatory by staff, and just how resources were not being used in a manner that sought to support staff in the achievement of their targets, and how deadlines needed to be changed, and to talk to the realities on the ground, the exigencies and the difficulties and complexities of investigations and so on. So this charge, in essence, Chair, it really talks about the environment within the PPSA and whether that environment was conducive to effective and efficient management of internal capacity and resources, as well as resources of management staff, investigators, and outreach officers. And I'll stop there, Chair.
Thank you. Thank you, Advocate Mayosi. As you would have indicated that from the paragraph 10, we go straight into this, and members in their own way would have started venturing into these issues of the culture and environment in that space. And I think it's now the time to invite members to respond to this summary, understanding what evidence we had, summation and everything else. I'm inviting you members to make your contributions. Honorable Sukas,
Yes, Chair. Chair, I've already in the previous segment referred to the issue around the use of Audi letters. And I want to make the point that we've had a number of witnesses that told us that about the Audi culture, and that they feared it, and that it had a negative impact on the organization. The question we have to ask is, what steps did the public protector take to formalize the process to ensure everyone understood and shared a view that this was a form of natural justice and a responsible HR practice? There is evidence that the reliance on Audi letters led to a culture of fear in the organization, and the creation of this culture of fear impacted the functioning of Public Protector South Africa, and is evidence of misconduct and incompetence. This is a second aspect of the problem with the Audi letters. The first is illegality or a gross failure to follow proper labor procedures, which I've spoken of. And then the second is failure on a management level to address it. The third point that I want to make is the problem with the Audi letters. It was used as a substitute for effective management. When this becomes a practice across the whole organization and is promoted, and when managers and staff start offering to accept Audi letters to protect their staff, then there is a dysfunction in the organization, and that in itself demonstrates then incompetence. So it becomes systemic in the organization, Chair. That is what I would submit. Thank you.
Thank you, Honorable Sukas, to that contribution in answering this question whether Advocate Mkhwebane managed internal capacity and resources effectively and efficiently. Honorable Ngola, followed by Honorable Dlagude.
Thanks, Chair. I think it is evidence even from the explanation, from the summation of evidence, that the resources and internal capacity was not managed effectively and efficiently. I think we all will recall that in a number of review applications, there's been a frivolous applications of on appeal up until to the Constitutional Court, and beyond that, an application for rescission of the decisions of the Constitutional Court. That, in my view, Chair, has been a reckless way of managing internal capacity and available resources. Chair, I think we all recall that one of the reasons we, as Parliament, always prefer or give a particular preference on outstanding legal professionals when we are to start the process of hiring public protectors is that the reasonable expectation is that they would have had a foresight of the prospects of the court changing its decisions, or rather deciding in the in the advantage of the institution. So it would have been expected that such kind of a caliber of a public protector would have reasonably seen that the prospect of winning some of the issues up front. I think I think we would have all witnessed some testimonies that speak unto how legal briefs were done in the office, to an extent of some having surpassing the normal procurement standards, some being chopped and changed, some being hired outside the actual panel of attorneys in the PPSA. So that in my view is not an efficient and effective way of managing internal capacity and resources. Chair, lastly, until today, there is no reasonable explanation on the employment of Kim Heller, Sipho Siepe, and what has been revealed as not advocate Paul Ngobeni. So from where we are standing, those appointments were an evidence that the internal capacity and the internal resource is not managed efficiently and effectively. Thank you very much, Chair.
Thank you, Honorable Ngola, for your contribution. I now proceed to Honorable Dlakude.
Thank you very much, Honorable Chairperson. I want to echo the same sentiments as my colleagues have already said. Honorable Sukerson and Ngola. Honorable Chair, there was serious dysfunctionality within this organization as per the evidence that was presented to this committee. The environment, the working environment was not conducive for any employee to perform to their optimal level. So it's like they were working under duress or fear of something. These Audi letters were also used as a mean of, as something to intimidate staff to do what they were told to do. They were not motivated positively to perform their duties as they were supposed to. Then also the resources were redirected from supporting staff to perform.
Just pause, Honorable Dlakude. Thank you, Honorable Mahlaule, for muting. Proceed, Honorable Dlakude.
I think he must manage his mic efficiently and effectively.
Thank you. Go ahead, Honorable Dlakude.
Thank you very much, Honorable Chair. I was saying that the limited resources within the PPSA was redirected from supporting staff to perform their duties exceptionally well, but to funding litigations and traveling expenses. So I think that is a call for concern, Honorable Chair, which form part of the evidence that was presented to this committee. By so saying, Honorable Chair, I support and agree with the summation of Advocate Mayusi. Thank you very much.
Thank you, Honorable Dlakude. Honorable Van Minen.
Thank you very much, Chair. I also want to agree with my colleagues and the Honorable Dlosi, particularly. I think that what we're seeing here is a culmination of a lot of things that have come up over the last couple of days. And I think that it's very much a case that she managed the internal capacity and resources appallingly and not efficiently and effectively at all. Thank you.
Thank you, Honorable Van Minen. Any other member? Honorable Sukas, is that your old hand that is still hanging?
It's an old hand, Chair.
Okay. Honorable Maneli?
No, thank you, Chair. I think most of the points would have been raised, so it was not a hand to dissent, but to still affirm the points raised with regard to, I think, what Honorable Sukers called in summary as being an incompetent way of running such an important office. I think as it relates to the other evidence given, I think I'm coming in just on that point, Chair, that we also acknowledge indeed that there were those who believed that the style introduced would have resulted in reducing backlogs and everything else that is said to be good. But that has been outweighed by everything else, which is also confirmed by the survey, as alluded to, that even general staff would have felt that these things were just unreasonable. In their argument, those that were for. One of the points raised was they learned from every case that would have been lost because there would be a sitting and a review process that takes place so that you make decisions on which case to litigate, which one not to. But clearly, when you look at the legal costs and how the matters would have been lost, in most instances, it will be like repeat findings if one were to use that, where you are still hammered on the same matter, having spent resources, and I'm talking both human and financial, because those who come together to review these cases that they get lost and make decisions thereof. It's a sign, as I say again, of that competence that's lacking, because it would not repeat the same if you understood that there's no basis to move forward, but you to move even to the highest, and the findings of those courts get to be the same as reports get reviewed. So I just thought, Chair, it shouldn't be like those have been ignored. We've taken into account, but they are overweight by the inefficiencies that are seen, and therefore do not hold in that regard. Thank you.
Thank you, Honorable Maneli, for that contribution. Any other members? Honorable Hendricks.
Thank you, Honorable Chair. Honorable Chair, I just want to make the comment that it has been before this committee that the previous public protectors adopted quite a benevolent approach to the employees, and it looks like when the present public protector was appointed, she was concerned about the long delays in reaching decisions on matters that has been sent to the public protector. So I think that she decided to crack the whip, and maybe she cracked it too harshly, because the idea was to have a public protector's office so that the decisions can be reached speedily. And I was shocked to hear that sometimes when a matter comes before them, it is put in a cycle that will take 2 years or more. And I don't think that was the intention of having a public protector's office. People could have gone directly to the High Court, which take that time. Having said that, it's a pity that the public protector did not put before this committee many of the successful cases that she had that went to the High Court, and the High Court exonerated her. If this committee had before it the dozens and dozens of cases where the public protector made decisions that was also endorsed by the High Court, and the committee weighs it against the 4 complaints of the Democratic Alliance, we may have come to a different conclusion. The problem is that before us are 4 complaints by the Democratic Alliance, and it is not weighed against the many successes that the public protectors had over the years. Because this is not a court. The public protector's office does not have the same high standards of a high court or an appeal court or a constitutional court. It's like a tribunal, like the CCMA. And I have a lot of experience in the CCMA, nearly 40 years of experience. The arbitrators that make decisions, they adopt a very informal approach. They think out of the box. They do things that sometimes you won't do in a high court because of the decorum. And I think that was the idea of setting up a public protector's office, so that the public can have easy access to redress the issues. So I want to conclude by saying that it is maybe disappointing that the public protector did not take this committee in its confidence and presented to it the hundreds and hundreds of cases that she was successful with, or her office was successful with, and the High Court, we even went to the High Court and they confirmed her decisions. And then one has to distinguish, Honourable Chair, whether the complaints that is listed, shouldn't those litigants have gone directly to the High Court instead of coming and to the public protector? So indigent people, people that were much more needy, couldn't afford it, will be dealt with and be more in front of the queue. And then, of course, the eventual decisions that the Democratic Alliance has now brought before this committee seems to be to favor big business, because most of the and also very senior employees in the public protector's office who have resources to take their matters to the CCMA and even to the Labour Court. So these complaints by the Democratic Alliance, whose name is in the box, obviously is the public protector because he's the boss, but one has to mitigate those decisions because there is so many checks and balances along the way, even a committee that does quality control. So can one really finger the public protector, because the idea of the public protector's office was to have an informal, a speedy resolution, yet legal people involved. We noticed that most of the applicants for this post are legal people, and I'm a bit disappointed because you need people that can reconcile, that strong in conciliation like they have in the CCMA. Thank you very much, Honourable Chair.
Thank you, Honourable Hendricks. Honourable Suka, is that a new hand?
Yes, Chair. Chair,
Please go ahead.
Yeah. Chair, we are still at 11.1. So my focus is on 11.1. I'm not responding to what has been spoken of by Honourable Hendricks in this regard. I just want to add the failure to establish appropriate corporate governance. We heard the staff being described as whistle inhalers in this committee. If a person worked in the public protector's office and believed that the public protector was abusing the office, it appears that they had no means to report that other than to Parliament. If a whistleblower line did exist, it only did for a short time. Without some system like that, there was no adequate protection of staff, the public and public funds against potential abuse of the office by a public protector. We may require some legal guidance in terms of if this is a failure to act can be seen as mismanagement and therefore incompetence. I think I mentioned it before. I would argue, Chair, that the public protector's role is one of a kind. It's as an apex guardian, and I think Mr. Hassan before this committee spoke in detail around how he viewed it or the ideal of that. Parliament is the upper guardian of the Office of the Public Protector. It appears that there were not adequate steps taken by the PP to ensure that methods are in place to allow staff to report abuse either internally or to a guardian institution. And if such measures were not in place, is it not a failure of the PP's duty and a failure to follow best practice as outlined in codes such as the King Code on Corporate Governance? I do concede that the public protector may not be bound by such a code, but that the office should set an example in light of what I said previously, to be beyond reproach. So my point, Chair, in terms of 11.1 is the failure to establish appropriate corporate governance to ensure that the office is effective and run effectively. Thank you, Chair.
Thank you, Honourable Sukas. Thank you to members. I have no further hands. Any final remark, Advocate Mayosi, before we proceed?
Chair, no, I have nothing to add, Chair. Sorry.
Thank you. Thank you. Can we then proceed to the next section?
Yes, Chair. Advocate Bauer is going to deal with the next paragraph 11.2.
Yes, now she's earning her presence. Thank you. Welcome, Advocate Bauer. Advocate Bauer?
You can't hear me, Chair. Are you hearing me now?
Only now, only now.
Oh, sorry, Chair. Good morning, Chair. Let me start again. My apologies. We're looking at charge 11.2, and the members need to bear in mind that the charge of 11 is a composite with subsections which are interlinked at various levels. So you can find something under 11.1 and then it will overlap into 11.2 and 11.3 in some way. But this component part leads to whether Advocate Mkabani had committed misconduct and to demonstrated incompetence in the performance of her duties by failing intentionally or in a grossly negligent manner to prevent. We need to look at to prevent fruitless and wasteful and unauthorized public expenditure and legal costs. Now, members, we took our guidance in some way in ascertaining how to deal with this charge by looking at what members had raised as some of their concerns during the hearing. And so we start looking at paragraph 11.2 at para 363 of the summation note to give you some idea as to what is fruitless and wasteful and what is unauthorized. 363 in coming to that. And for that, we took our guidance from the Public Finance Management Act as to what it defines as unauthorized being overspending of a vote of a main division within a vote, and expenditure not in accordance with the purpose of a vote, or in the case of a main division, not in accordance with the purpose of the main division. And then fruitless and wasteful expenditure means expenditure which was made in vain and would have avoided had reasonable care been exercised. And members must please bear that in mind: expenditure which was made in vain and would have avoided had reasonable care been exercised. Now, on the face of it, Chair, a Chapter 9 institution is a different kind of entity. It gets its appropriation through the Department of Justice. And so, in our view, if you take that within the letter of the PFMA, then you would have difficulty coming to a conclusion that it can be an unauthorized expenditure. And so we make that point, and then we come to this question of how then do you look at it within the context of a fruitless and wasteful expenditure, and how that can be prevented. And we must also at the back of our mind take cognizance of the fact that this office did get 3 consecutive clean audits from the Auditor General. And we mustn't take that away from this office, because that is indeed a laudable achievement. But then there has to be some cognizance of how does a clean audit weigh up against a fruitless and wasteful expenditure. And so you must then have an understanding as to what is a clean audit. And the Auditor General regards a clean audit as being a financial statements that are free from material misstatements. In other words, a financially unqualified audit opinion, that there are no material findings on reporting on performance objectives or non-compliance with legislation. So this is assessed with reference in the context of a public sector institution in the areas that they are required to be audited for, and in respect of which the Auditor General is required to provide an opinion, conclusions, and findings in the audit report in terms of the Public Audit Act. And so we summarize this up into saying that when for clean audit purposes in 370, it doesn't involve 100% audit of all transactions and account balances. It doesn't have a consideration of precisely how the money was spent within the organization. The Auditor General doesn't look at all the invoices, doesn't take into account the decision which underscores how funds are spent on legal costs. They look at how it's accounted for. And in particular, they do an assessment of what is the core business of the PPSA, which is its Program 2 investigations, which one sees from all the annual financial reports. So effectively, we point that out, that the Auditor General's function in respect of determining a clean audit is a different process to which this committee is looking at for purposes to see whether the public protector had prevented fruitless and wasteful expenditure. So that's the one aspect that we want you to take cognizance of. And the second cognizance is materiality. Materiality is important when the Auditor General looks at it in the context of the budget of the organization in its fullest extent, as opposed to whether particular funds had been fruitless or wasteful. So for example, the Auditor General may put a cap on it, and anything under that cap wouldn't be regarded as material. So we sum that up and effectively deal with that in paragraph 374 of that. The second aspect which becomes relevant is the extent to which there is an overlap between what is expected of an accounting officer and what is expected of an executive authority. And that has relevance, Chair, because in the ordinary course of a government department, the management of its internal resources is done by the accounting officer, not the day-to-day handling by the executive authority. And that is important for 11.1, 11.2 in particular. But the public protector, because of its independence, impartiality, and the need not to be interfered with in the carrying out of her functions, is not your ordinary executive authority. And that might be something we must look at on the lessons learned, because the head of a Chapter 9 institution is not defined as an executive authority, either within the financial legislation or within their own legislation. And so you cannot have a situation where the accounting officer can direct the public protector how to fulfill her constitutional functions, because that would be an anathema to the provisions of the Constitution. And so when you look at Chapter 3 of the Public Protectors Act, it says that the public protector shall, subject to his or her directions and control, appoint what is regarded as the Chief Administrator Officer in B, for the purposes of assisting the public protector in the performance of all financial, administrative, and clerical functions pertaining to the public protector. And I'm going to come in a moment to Chapter 4. So in other words, whilst the public protector is not the accounting officer under the PFMA, she's definitely the head of the organization who deals with in essence, decisions that affect the day-to-day running of the organization. And we know that when it comes to the question of legal costs, this becomes an important issue, because at the end of the day, whilst the accounting officer has to balance the books for purposes of the Auditor General, the decisions as to whether to litigate, whether to oppose, whether to obtain an opinion lies with the public protector and not the CEO. Mr. Mashlangu said he had nothing to do with it. Mr. Satoli indicated that it doesn't matter which course we take and who decides on what we do. It ultimately lies with the public protector when she takes that decisions, and we set out that evidence in dealing with that interplay. So if I take an example where an attorney's invoice has been signed off and the mathematics on that invoice is incorrect, then one would look to the legal services department who signs off on the invoice, the CFO and the CEO, for that kind of an error. There cannot be an expectation that it's the public protector that's got to check invoices. But when it comes to the big decisions as to, do we embark on litigation? Do we pursue appeals even though there aren't merits to those appeals? Then those are the kinds of decisions with financial implications that the public protector makes. And one sees that that if you look at, I think I've skipped it, but Section 4 of the Public Protectors Act in some ways assists in setting out those kinds of financial boundaries, Chair. So it's against that background that one has to consider the charge in 11.2. Now, from the evidence before the committee, there were essentially an acceptance that after the Nkandla judgment, the cost of litigation increased because the courts had found that the Public Protector's Office was binding, or remedial action was binding. And so as a consequence of that, more litigation occurred and it grew exponentially. The statistics show that even prior to the Nkandla judgment, there was an increase in the litigation on a lesser extent through the office. We then heard that the Zambian experience was of such a nature that Ms. Sakoni testified that what the effect of the Zambian experience was that once we started being taken to court, we upped our game and we made sure that we dotted our I's and crossed our T's. And hence we didn't have this burgeoning legal costs in Zambia. She referred to only one important case that had come up within the Zambian jurisprudence, as opposed to the multitude that has occurred in South Africa. And so the second basis upon which one can see from the documents that account for the increased litigation cost, other than decisions to litigate, or what causes the litigation, is that the decision to not submit provisional reports to complainants any longer, but to do Section 7(9) notices. So previously, when you submitted you gave everybody a provisional report that encompassed the remedial action. They would then make comments on that to the Public Protector's Office, and if there was any errors or mistakes or something had gone amiss, that would be fixed before the final report went out. But because of leaks after the ABSA provisional report was issued, the evidence was that that practice was changed and it went into the realm of submitting Section 7(9) notices only to certain implicated or affected parties, and it excluded the remedy, except in the Vrede matter, where it did include the remedy, because Vrede was in that interregnum period between where a provisional report did exist, even though it was styled as a Section 7(9) notice. So that takes us to deciding if you want to work out whether indeed there was a ballooning of litigation costs at the start, then one needs to look at what those costs actually were, and we've detailed that in table 1. And so you see what the legal costs in total was for the period in question. The first column reflects the total of professional and consulting fees, and the second column, the legal fees, purely because the evidence of Mr. Mashlangu was, well, you can't blame it all on legal fees because there was professional and other costs. And so the exercise was done and led to do that. One then looks at that in the context of what's in table 3 in the document, which sets out it's on page 120 for SEPO's purposes to do that, which then sets out, well, in the context of the total budget of the office, one takes out what its biggest costs, which is staffing costs, which remained a pretty constant percentage of the total cost, as you will see from the 5th column. And your last column reflects what is left over for the office after your legal costs have been incurred. And it obviously shows you what the cost would have been had those legal costs or a portion of those legal costs not been incurred. So there are 2 areas that one then needs to look at the question of legal costs, and it would be remiss of us to not deal with an issue that arose during the hearing, and that was a distinction that was made between legal fees and legal costs. Right up front, where it was raised that what the charge meant to refer to was not the litigation decisions taken at the PP's office, but the cost orders emanating from the court. And this came up during the evidence of Mr. van der Merwe. And so what we did in this chapter, Chair, we looked at both the costs from the courts, both the costs that the courts ordered against the public protector, as well as the costs in her favor. And then we looked at what it cost the organization to litigate, so that is both before the committee. So if we look at the first section, which is the costs from the courts, which start off at paragraph 414. And Chair, there is a table produced in the summation. There must be a distinction between the complaints investigated by the office, which runs into thousands of complaints, versus the number of reports produced, investigative reports. It is only investigative reports that go to court. The other complaints do not go to court. That distinction is an important one to make. And so when we looked at the issue of reports that give rise to litigation costs, right? We looked at what the total number of reports was that produced over Advocate Nkubani's office until she was effectively suspended. And it shows how many cases actually go to court in total that had been reviewed and set aside at the time. So at the time this table was produced, 36 reports had been reviewed and set aside. One was a closing report in addition. And then at that stage, there was another 47 that was pending. Right? We got an update subsequently to that. And you will know that attached to the questions and attached to this document again, we listed all the reports that were set aside in doing that. Now, during Advocate Mkabani's evidence, she referred you to an annexure BM 13, which was attached to her affidavit, in which she reflected that 17 reports during her tenure from October 2016 to February 2022 had been reviewed and set aside, that being an unaudited number to do that. So that was the one aspect that had come out of Annexure BM 13, which didn't correlate to the reports that we had concluded had been the case. So if you go to, and for that reason, so there's no dispute about it, we created what was Annexure 2B to the document, which is right at the end of Chapter 2. We listed all the reports that had been reviewed and set aside during her term of office. We point out that the ones you'll see a green highlight on the side of it are the ones that are actually reviewed and set aside outside of the BM 13 period. And we also point out, if you go further down in the document, the last 5 are those that come from the Madunsala period, where Advocate Mkabani takes a decision that these are not going to be opposed to do that, and which are then reviewed and set aside. So that's the context of the litigation, which must be distinguished from the context of the number of investigations done. So if you just click, Shepo, for clarity's sake, on CH2A, members would also be aware of the issue of new complaints or the amount of complaints. And we draw this distinction so that there's no confusion between what is investigated by the Public Protector's Office and not. One of the other factors that was looked at for purposes of determining this cost was, what was the workload of the office in that regard? And Annexure BM 13 points to close to 60 cases that had been finalized by the office. Now, there is a distinction between finalized and investigated. Finalized is a count of a complaint lodged and closed, and then it's ticked off, a tick box, that's done, right? Investigated is if some resource had been dedicated towards dealing with it. And the distinction is an important distinction to be made, because you deduct from, if you take the tick box exercise and you deduct the ones that the PP's office has no jurisdiction or referred to other institutions or was withdrawn or was resolved before an investigation could have been concluded, then the total that you come to in blue on the chart that's up on the screen does not reflect the same amount of cases that are actually investigated and closed. It comes to a lesser amount, and that total comes to 47. It comes to 40,117. So we take that lesser amount as being that which occupies the resources, but the manner of reporting on it has always been the total finalized, which in some ways inflates the workload of the Public Protector's Office, and that manner of accounting has preceded Advocate Mkabani's term of office. So if you take that count into a case, the total finalized, and bear in mind she is a year less than her predecessors in office, right? So if you look at her total amount for that period, she comes to a total of 47,400 in that period of new complaints. and her total finalized would be 54,334. Her predecessors of Advocate Madiba had 131,015, and Advocate Mushana had 1,010,663, and Advocate Bakwa had 36,669. Now, there's two, it is not, you're not comparing apples and apples, even though I'm making the statement to you. I must point out to you that Advocate Mkabani's statistics fall short because of her suspension period, and she had the formidable task of heading this office through a COVID pandemic, which had obviously made delivery in many respects much harder, but it also dropped the numbers of complaints that had been lodged with this office. The flip side of that is it made dealing with backlog a lot easier, or reducing the backlog, because you had so much less new cases coming to the office. So one does see that the backlog is easier to move because you have less new cases coming in. So let's look at the actual costs. The evidence before the committee was that austerity measures was imposed, which affected day-to-day operations across the board, and that one of the consequences of that, Shepo, if we pick it up at 406, page 109 of the document, was that certain cases or a position was adopted that we no longer giving an instruction to oppose matters because of financial austerity. And we then looked at, well, in the financial year in question, because it overlaps with the defense of financial constraints in the Vrede matter. In particular, members all recall that the Vrede investigation was not pursued because of financial constraints, being the answer in court. So we looked at what wasn't what cases a notice of opposition was withdrawn. We had the documentation and the evidence before that, and at that stage, 13 cases were said to have been withdrawn. The instruction was reversed on a number of those, and at the end of the day, 4 matters was proceeded with. Mr. Stoli's evidence was, well, on those matters that we proceeded with, we had won 3. When we looked at it, that was not the case. They'd only won 1. And the bulk of the cases on which a notice to abide had been filed related to matters that was left over from the Madiba period in that regard. Subsequently, Chair, a number of cases were not opposed, largely the run-of-the-mill reviews in the PP's office. A notice to abide was filed, etc., and it was dealt with internally by the office. If we go to, we had put up a summary, a table, which may have been quite dense when we did it before the committee. If you go to paragraph 421, paragraph 421 and 422, it answers the question that one of the members had just raised with the committee as to what were the wins and losses before the High Court. Chair, there were very few wins. There were, I think you can see in terms of cost orders, 421 deals with the ones against, and there were several personal cost orders, but there were innumerable cost orders of the ones litigated taken against the office, both in respect of High Court matters and then invariably in respect of appeals, applications for leave to appeal that go to the SCA and then go to the Concord, which we see listed here in dealing with these cases there. And so I'm going to take you specifically to 422, which becomes important because it shows the wins, the cost orders in favor of Advocate Mkabani in the various cases. And in some of them, the costs are in part because they've won an interlocutory aspect of the case. So, for example, the egregious comments made against the public protector in respect of which there was an application to strike out in the SARS unit matter. and in the dismissal of the counter application, which is sub 2, cost was ordered in favor of the public protector. And in the greater scheme of things, that was a small interlocutory order in the total cost of litigation in that case, which exceeded over 14 million. The cost in the Quinty matter, which was successful both in the review and the leave to appeal. Ms. Baloy's evidence in that was she had that report in hand nearly from start to finish, and they had won that case from start to finish in that case. The Motseneng matter, which was left over from the Madinsala era, the public protector won. The interlocutory matter dealing with the Minister of Finance, they won, but they lost the review. The Usasa matter, which was settled without a judgment, they got cost orders. It was an ordinary review. The case of the Minister of Arts and Culture was settled and they got costs without any counsel having been engaged. This will ring some bell with the members because it's the evidence of Mr. The arts guy, Mr. Nyatela, right? And then the Tembi matter is one that it's the one case that they did win after there was a changing of the minds to do that. But there were a number of matters that was set aside, reviewed and set aside, where there were no cost orders made, and the reports were set aside by agreement, bearing in mind that resources of the office would have gone into the compilation of those reports in the first instance, right? And so there were, at the time when this schedule was prepared, there were a number of cases pending in respect of which no external legal representative had been appointed and had yet been opposed. So that answers the question which was posed to us and which we've quoted in paragraph 423 by the Honourable Member Holomisa at the start of the proceedings, that there was a need to balance the reviews of those that had been set aside, albeit that this motion only dealt with a few cases. We then look at, well, what was the cost of own initiated litigation during the period in which there wasn't money to fund the Vrede litigation? We know that the two only own initiated litigations is the impeachment proceedings, and Chair, we don't deal much with the impeachment proceedings even under the section, because a lot of it falls outside the time period of the mandate, except for the initial 20 million, and it doesn't fall within the scope of the motion to be dealing with it. So we only deal with it in the context of the engagement of Mr. Ngubeni and peripherally in the question of fees. But you would have noted that the total costs, or the cost incurred in respect of the litigation against Advocate Breitenbach for the allegations that Advocate Nkubani had been labeled as a spy, was close to 2.3 million, and quite a bit of that was incurred during the period in which there wasn't money to deal with the Vrede matter. We then turn to the question on legal fees, which caused some acrimony in the public domain when on instructions the detail of this information was provided to the committee, and because that detail had already been provided, I don't repeat that at this stage to do that. But there was extensive cost incurred in respect of briefs. The matters that are before this committee cost fairly, or let's put it into it, made a dent into the budgets, or some of the highest costing cases that have arisen from that office. It is the biggest spenders other than the impeachment proceedings, and contrary to the evidence that was led by Mr. Satoli in this regard, almost all of them end up in some way or another with the brief having been issued by Senego Incorporated in the ABSA matter, although the litigation was dealt with by different attorneys, ultimately when the Constitutional Court proceedings is finalized, it is that firm that provides the instruction for a final opinion to be rendered at significant cost to the organization. We've provided the committee with the details of that. And then we deal specifically from 434 onwards with two cases, the ABSA matter and the Vrede matter. And we do that because of the relevance to the brief. We deal later when we look at the others. We'll mention the costs of the Gordhan litigation and the CR17 litigation, but because this is specifically referred to in the motion, we do deal with these costs and what these costs entailed. And we point out that the decisions to take matters on appeal, what the cost of those applications for leave to appeal are, including the decisions to change counsel. And the committee will also bear in mind that Mr. Satoli gave reasons, which is detailed into the note, as to why in some instances they were obliged to employ additional counsel, or they were obliged to change counsel to do that. One of the issues that is dealt with is this question on crowdfunding, where the cost of getting an opinion by the PPSA to ascertain whether Advocate Mkabani could actually receive this public contribution towards a punitive legal cost order against the was legally feasible, and the cost of the opinion comes close to the amount of the amount that she had to pay. Having said that, Chair, the flip side of this is that the ABSA judgment was the first time that the personal cost order had been made in such terms against the public protector. They may have warranted, let's get the jurisprudence in line, go up to the Constitutional Court, get a decision on what the Constitutional Court says about this personal cost order, which they then do. They get a majority decision which upholds the High Court decision to make a personal cost order, as opposed to the minority decision of Mogoeng that goes the other, then CJ Mogoeng that goes the other way. However, one then sees with the Vrede matter, and I must also say that at the time you take that decision to go on appeal, you have no way of actually knowing that your ultimate taxation cost is going to be in line with whatever opinion you receive. So one has to balance your consideration of that. The difficulty then arises is that when Judge Tolmay waits for the Constitutional Court decision before she makes a personal cost order, and knowing full well that the advices you had received from the inception of the matter was that you had no merits in the Vrede matter on the prospects of success to start off with. Once the court confirms that and makes an order against you, including a personal cost order, there's then applications of leave to appeal to the Constitutional Court, first to the SCA and then to the Constitutional Court, which ultimately then results in the total legal cost exceeding 4 million rand. And one then looks as to whether those decisions to litigate on applications for leave to appeal can be regarded as within the definition of fruitless and wasteful expenditure. And we set out the advices that was rendered for the steps taken in the Vrede matter in that regard, Chair. So that deals with the question of financial, legal costs on both levels, and the question of financial costs in that respect. Thank you, Chair.
Thank you, Advocate Bauer. That would have been a comprehensive update and the creation of that context, also to refresh all of us on this. I hope it's been helpful, members. And I'm now going to invite members to contribute in responding to the questions that you see highlighted there, having listened to what Advocate Bauer has really taken us through. As you can see, we want to check if Advocate Mkawi in care fruitless and wasteful on unauthorized public expenditure in legal costs, and in the event that it's so, then would it have been done so intentionally, and so on, as you see those three critical questions to start off. So I want to invite members to contribute in this area. Honorable Hendricks.
Thank you very much, Honorable Chair. Honorable Chair, the matter of wasteful expenditure is in the motion, and that's why we must thank the evidence leader for giving her take on the merits of the motion. I noticed that the evidence leader mentioned that there were 3 clean audits, and that mustn't be lightly discarded. I agree with the evidence leader, although she then goes on to rebut the auditors. If anyone is to blame for wasteful expenditure, it must be the auditors. In their first audit, which they gave a clean audit for, they should have picked up elements of wasteful expenditure, and in their management letter, asked the Office of a Public Protector to address that. But in the second audit, there was no reference to wasteful expenditure. In the third audit, no reference to wasteful expenditure. If this committee finds that there has been wasteful expenditure, they should report the auditors to their regulatory body. And as you know, the fines has been increased 50 times when auditors don't do their job. I can't understand how this committee can be told that the auditors only take a sample. Yes, they take a sample, but the sample is representative of what has happened during that financial year. Secondly, there is a margin of error, but it is acceptable. So now after the auditor has 3 years in a row, 3 different audits, and I can tell you, Honorable Chair, our political party has gone through very similar audits, and it's very stressful, it's very onerous. The auditors go to great lengths to identify wasteful expenditure. So if the auditors and the Auditor General and the other auditors involved and the accounting people haven't done their job, they can't come to this committee and tell this committee that there has been wasteful expenditure. That's why we have auditors. We pay lots and lots of money for auditors. And then I want to speak about fiduciary duty. I know that the CEO is not a director, but we've seen a recent court judgment, constitutional court judgment, where only the director was suspended and not the 6 other directors who claimed they were salaried people and they really didn't have the powers that the other director had. So I can't accept the position of the CEO to say that going to court has got nothing to do with him. It means he hasn't carried out something similar to a fiduciary duty. He can't duck responsibility. When the public protector decides to go to court, our whole management team takes responsibility. So if they disagree with her, then obviously this committee hasn't seen a minute of a meeting of where someone said, please note the objection. You know, we here in Parliament, please note the objection of the Freedom Front. Please note the objection of the Democratic Alliance. People object. So why couldn't, in the Public Protector's Office, there be similar objections? So Al-Jamaa rejects the position that that has been, and the evidence has been put before this committee. We lay the responsibility squarely in front of the doors of the auditors and not the Office of the Public Protector and not the Public Protector itself. Honourable Chair, if this committee is going to listen to what the evidence leader has to say, it throws all our audits into disarray. No one will ever respect an audit again, because the argument is, the auditor only looks at the sample and not the detail. So the DA has identified 4 cases out of the whole lot. They haven't put forward cases that shouldn't be under scrutiny. So I'm sorry, Honourable Chair, I don't accept the evidence leader.
Thank you, Honourable Hendricks. You just forgot that to make example about Al-Jamaa also objects in Parliament. So, but maybe before I go to the next member, just to quickly bring in Advocate Bauer, you wanted to clarify something?
Chair, yes, I must not be said to be understood that it undermined the clean audits in any way. I was seeking to draw a distinction to say that which this committee is asked to do is not an audit exercise. And that was the reason of pointing out how an audit actually goes about it. And this goes back to the question that came very early on in the proceedings about how do we determine fruitless and wasteful before this committee. And so I took you to what the definition was in fruitless and wasteful. You cannot disturb that audit. You are not being asked to disturb that audit, and that is not your job. And so that I must be clarified that I wasn't seeking to rebut an audit in any way.
Thank you. Thank you, Advocate Bauer. Honourable Lockridge.
Thank you, Chairperson. Yes, I think Advocate Bauer made that very clear, and that's also how I understood it. Chairperson, if I focus on the questions that we have to deal with, to me, regardless now of the clean audits, as has been explained, I am of the opinion, and the evidence does lead me to believe that there was indeed fruitless and wasteful expenditure. The unauthorized, I'm not so sure, because it was also said that the final decision in terms of incurring legal costs and litigating was that of the public protector. And in many instances, as all the examples we have been presented with, it led to a fruitless and wasteful expenditure. I'm just thinking, one of the last ones now was where the public protector, in fact, the question of being a spy, that is a very personal litigation, but this incurred some costs, and it is the taxpayer's cost, or it is their money, in fact. So I think we have been presented with overwhelming evidence in terms of unsuccessful legal actions, appeals, etc. And I would therefore, from my side, say that there is indeed evidence here that the public protector incurred fruitless and wasteful expenditure. I also believe that she did so intentionally, because she took the conscious decision to embark on the litigation. And I would also, perhaps gross negligence is a bit of a stretch. However, she did not take due care in terms of dealing with the taxpayers' money in a way that she should. Money was, in fact, then, or there was less money available for her to fulfill the actual function that she has to fulfill, namely protecting the public. Thank you.
Thank you, Honourable Lockridge. Honourable Sukas.
Thank you, Chair. Chair, I'm going to come at it from a slightly different angle, or maybe the same. It is the focus on failure to establish proper corporate governance in terms of the aspects raised. The pattern of the appointment of lawyers appears to indicate a degree of favoritism. There appears to have been no system to ensure the fair distribution of work. A panel existed, but work was not distributed to that panel fairly. The problem in particular relates to decisions to pursue appeals. Did the PP seek or obtain unbiased advice from lawyers who had no interest, either financial or professional, in vindicating their legal theories in court? It is not primarily needed here to establish if favoritism was practiced or bad decisions made, but rather what mechanisms were put in place to ensure that appeals with very little prospect were not pursued. So the failure to establish such mechanism points to incompetence in managing the resources of the Public Protector South Africa. Thank you.
Thank you, Honorable Sukus. Honorable Mailam.
Thank you, Chairperson. Chair, I want to highlight two issues. The first is that the Public Protector is the accounting officer for the entity, or the Public Protector of South Africa. So the individual is the accounting officer for the entity, and as such is ultimately responsible for the financial conduct of the entity. Furthermore,
did you say the PP is the accounting officer?
That's correct, Chair.
Yeah, she's regarded as the executive authority, and the accounting being the CEO.
Okay. Okay, fair enough. I accept that correction. The executive authority. That's you are correct. But ultimately, the person responsible for making the decisions and the person who decides whether or not to proceed with litigation or otherwise. Chairperson, the further point in this regard is that the issue of fruitless and wasteful expenditure, or let's focus on fruitless and wasteful, is that it prioritized expenditure on issues that were not within the core mandate. In other words, it prioritized expenditure on litigation. It prioritized expenditure on fighting political battles. It prioritized expenditure on fighting reports that clearly the entity had no case to make, or no real chance of winning. And as such, it then took the focus away from other areas. It took the funding away from other investigations and other activities that were within the core mandate of the Public Protector. And as such, I think the incumbent needs to be held responsible for that. Thank you, Chair.
Thank you, Honorable Mailam, for your contribution. Honorable Nkosi.
Thank you, Chairperson. I agree with what the three previous speakers has indicated, and particularly so because during evidence placed in the committee, it was clear that one, there was a shift of funding from other programs to particularly outreach to legal services for whatever, whether it was for costs or for whatever. But shifting funds from one program to the other, for me, requires permission from Treasury and the assent of Treasury in that regard. So you can't just do environment simply because there are pressures. Remember that the budgeting process it's law, and therefore to change that, you needed to go back to Treasury and change it, and even come back to the portfolio committee for it to sanction you or agree with that approach. So in my view, yes, Chair, overall there was incurrence of this fruitless and wasteful expenditure, and that it was done intentionally. Or if we can't say intentionally, can we say was it negligent? I think it would be difficult to say it was negligent because of what we know, that she went in, she said, we have litigation to contend or to institute. We don't have the kitty to do that. Therefore, shift these funds from here to here, and in fact, shift this fund from other programs like outreach into legal services. Thanks.
Thank you, Honorable Ngosi, for that contribution. Honorable Maneli.
The last point, Chair, is that we do agree that in her period, she did have clean audits, But if you look at the evidence of particularly Mr. Masangu, certain information was not disclosed both to Treasury and to the auditors, that clean audit was obtained against practices of doing environments without seeking permission.
Thank you, Honorable Ngosi. Honorable Maneli.
Thank you, Honorable Chair. I want to start maybe on the last point once again to make the point that we are indeed not discussing the audit outcomes of the PPSA. So it's not the matter of the audit, but Chair, we are looking at what is presented before us, actions taken, whether they do pass that test, that as you incurred the costs could anything been done to avoid incurring those? Now, I would not repeat what other members would have said, but just to add the point, because this would have also come up on Friday as we looked at one case.
Yep.
And its timing thereof. That you are able to leave an investigation that seeks to defend the poor and the public, and that's a further case. And the reason cited is that financial constraints are an issue. Whilst you pursue cases on the other side, where it has been clear that repetitively you are found to be on the wrong. And the words I've used, Chair, at the time, and I want to use that to further clarify what has been raised by another member before. That's a failure to defend the poor that are referred to, which is what the office is about, public protection. And that's why I'm a public protector. Chair, if you have got one case of Friday and there are many parties in that score, whether you say CASA or TA on the other side, the mere fact that you will go with different senior counsels on the same matter, it's a matter that could have been avoided, and that's fruitless and wasteful. Because it's the same matter. And in the evidence led, Chair, there was nothing convincing from a point of rationality why you've gone that route, looking at the resources that you have available. So I just thought it's important that it doesn't sound out like the committee has put the AGSA on trial on whether you did a proper job or not. That's not the matter. It's appreciated that from what is expected from HESA, everything else could have been proven. And in my own way, Chair, of simplifying the matter, I usually say, yes, indeed, these are the processes I followed, these are the receipts I have. But here we're looking at the value derived from these actions, where you could have avoided going a particular route, but you can still prove that you procured well to get there. But you could have avoided doing the same thing in a way that makes those resources that are scarce to disappear. And I'm sure we have been given a lot of other examples. Like I said, I don't want to repeat. You cancel investigators from going out, and they work probably more off desktop. And then you also cancel other outreach programs that seek to give access to the same public on the basis that they can access this through maybe your radio outreach programs, right? But you are not afraid to spend money in that scope. From the passage itself, it's clear that there were decisions taken to withdraw cases, Chair, because of that money that we do not pursue. But later on, you decide that, no, I will still do it even if there's no money to do it. Surely it can be correct. So I just thought I should emphasize that point, Chair, in agreeing with the other speakers that indeed there is a case of fruitless. It could have been avoided, and therefore it makes it intentional that you move in that direction. Thank you.
Thank you, Honorable Maneli, for that contribution. Honorable Mananiso.
Thank you, Chairperson. I think one is very comfortable with the emphasis of Honorable Boyce Maneli. And indeed, she intentionally incurred fruitless and wasteful expenditure. And the other thing, Chair, that one would want to emphasize is the fact that with the testimony that came before us and testimonies led by the evidence leaders, it really indicates that she failed to use the resources of the institutions in an efficient and effective manner, as expected of the holder of a public office in Section 195 of the Constitution. So therefore, Chair, answering all these three questions, it really shows that the PP intentionally incurred fruitless and wasteful expenditure. Thank you.
Thank you, Honorable Mananiso. Honorable Siwela.
Thanks, Chairperson. I think I'm covered by Honorable Mananis that we don't deal with the outcome of the audit, but we are basing our facts on the report which is given. So I'm really covered and I'm in support. Thank you.
Thank you. Thank you, Honorable Siwela. Any other member? And is there any dissenting view except Honorable Hendricks, who has expressed himself? None. Any final remark on Advocate Bauer before we proceed to the next?
No, Chair, sorry, nothing from my side.
Okay, thank you. We wrap up this one in the manner I think members have comprehensively spoken. We proceed to the next. Over to you, Advocate Bauer.
Chair, we're going to jump in the way our summations are done at the moment because we want to go on to 11.3. And if you look at the charge sheet, just to remind you on 11.3, you would know that at the end component of our chapter 2 of our summations, we deal with certain aspects on 11.3, but we think it's more important to take the committee to the SARS matter first and then come back and the CR17 matter and then do the bits and pieces to complete on 11.3. So I want to go to the SARS matter, which deals with the misconduct or incompetence, failing intentionally or in a grossly negligent manner to conduct the investigations and or make decisions in a manner that ensures the independent and impartial conduct of investigations. And then the second part of 11.4, or the part of 11.4, deliberately seeking to avoid making findings against or directing remedial action in respect of certain public officials, but deliberately doing so in respect of others. Now, Chair, this charge of misconduct and incompetence is specifically linked in these paragraphs to an independent and impartial conduct of investigations. So that must be borne in mind, the back of your mind, as to whether there was a lack of independence or impartiality in that which was found. Now, the SARS matter is dealt with right at the end of our summations in chapter 3, part 2. And effectively in dealing with this, we took the cue from manner in which the PP herself led evidence before the committee, because this is one area in which you've got over and above the court records which show you what Minister Gordon's position was. You had the evidence of Mr. van Lochenberg, Mr. Pillay. You had the evidence of Mr. Mataboge, Ms. Mvuyani, and you had the PP's written statement as well as her oral evidence in that regard. And we know that there was 2 complaints, one from Mr. Shavambu and one from the anonymous whistleblower. And we know that the subject matter of the 6 allegations, or 6 of the 14 allegations fell into this report. The remaining was held over for a later date. And so what we further know from this, Chair, is that extensive remedy emerged as a consequence of this report, and this report based part of its remedy back on the what I'll call the IGI report. The Inspector General of Intelligence had earlier on furnished a report, and then in paragraph 5 onwards we set out the extensive litigation that had ensued in this matter in a table for the members to be familiar with it. The courts found against Advocate Mkubani on the merits on just about every aspect of it, and had then set out 9 grounds on which they found her to be biased, which you see in paragraph 6. And it's to those 9 grounds that the public protector's evidence before the committee was geared, because those were the grounds on which the court found her to have been biased and had dishonestly dealt with some aspects of it. And it is also the basis upon which some of it formed the basis of the independent panel's conclusion that there was prima facie evidence of incompetence, which we detailed in paragraph 7, and the independent panel's prima facie evidence of misconduct was premised on the 9 aspects justifying the finding of bias against Mr. Gordon and Mr. Pillay, listed in paragraph 290 of the High Court judgment. And it's that paragraph of the High Court judgment that becomes important in this matter. Now, just to bring the committee up to speed, that High Court judgment was appealed right up to the Constitutional Court, and the application for leave to appeal was refused. So there's no higher court judgment than this, right? So the first ground, Chair, would you want me to do each ground in turn for the committee to deal with rather than all 9, because it becomes quite extensive to do it as all 9? I'm in your hands, Chair.
Let's take it piece by piece. It might be smoother that way and quicker.
Okay, so the first ground, Chair, is based on a jurisdictional issue. Bear in mind that much of the facts in this matter had arisen more than 9 or 10 years previously. And as a matter of law, in order for the public protector to investigate it, she must establish special circumstances before embarking on an investigation thereof. That means special circumstances must show that Advocate Mkubani rationally exercised the discretion in respect of all of them, and the court found that she had not. Now, we must also take care in knowing what Advocate Mkubani said to the court, but what was also relayed to the at the time of our investigation. And so I'm going to deal with both as we go along, so that one can see, and there's a third element to it, sorry, Chair, is the explanation that is then provided to the committee. And in some instances, they are not precisely the same in doing that. So initially her explanation, Minister Gordhan's attorneys from the outset asked and said, you've only provided generalized grounds, you need to provide us with specifics of what these special circumstances are that you rely on. And so in paragraph 13, you see that Advocate Mkabane writes to the minister's lawyers, and she says she had been reliably informed that the surveillance equipment illegally acquired at astronomical cost is still being used to intercept communications. Now, Chair, we want the committee to be familiar with the phrases of reliably informed and on good authority, because they become materially relevant in the SARS unit reform report in instances where the actual source or evidence is not disclosed. And we make the point because when Ms. Umvuyane came to give evidence, she had no clue as to where this information came from, that the actual interception of communication was still happening. She knew about the costs, but not that it was still happening. There's then two further instances when explanation is asked of her in her response in her section 7.9 notice, where she asks implicated parties to comment, and in her report. And in both of that, she goes back to the generic explanation where she doesn't set out any specific circumstances in doing that. There is then the court proceedings that happens in which the explanation is then provided as to what those circumstances are, and they differ. We deal with that in paragraph 20, where it is said that the nature of the complaint involved conduct of a serving member of cabinet, and the issues raised for investigation were sufficiently grave to warrant exercising discretion in favor of conducting an investigation. That is the explanation the court rejects as not being sufficiently special. Advocate Mkabane then came before this committee to provide an explanation as to why that happened, and the reasons provided to this committee is reflected in paragraph 28 of the note, where it was told that as a responsible public protector, there was a complaint of an incident that was still ongoing. People's lives were being under threat. People were being monitored without the knowledge, without the approval of a judge. She had seen a video of cameras that were still operational at the Director of Public Prosecutions. And then she said there was information that was sent to her. She referred to the email that we had put up that said Mr. Gordhan was a threat to democracy. And she indicated that she had forwarded that to the investigators to take note of, because others were saying that people were being killed and there was all this information coming forward. And she felt that responsibly she had to look at this and do that. And Chair, one of the difficulties is that the 30, we point out what the investigator didn't know, and we point out that in the greater scheme of things, this information wasn't put before the committee. And in paragraph 31, we have a note from the investigator which reflects that some of the source of this information was initially given by a person identified as in the note as JM, and later on is referred to as Malema in the note. And none of this is disclosed in the Rule 53 or in the key sources of evidence before the committee. And so there is no mistake about that. We provide the committee with this note as C3F to our note. which Shepa will see, which is the handwritten notes of Ms. Mvuyana before the committee to see where it goes down. And if you go down further on the draft, on the first page, you saw the EFF reference. And then if you go down to the next page, next page. Go down, Shepa. Go. There we go. Information received SARS bugged the house in Cape Town as being the only evidence that we had before us to do that. So if we read the note in its entirety, we see the source, which is not disclosed in it. So that is charge the first ground, Chair.
You done?
Yes.
On the ground one.
On the ground one.
Yeah. Okay. Let's thank you, Advocate Bauer, so that we can just bring in the members to interact before we proceed to the next. Honorable members, hopefully you followed the brief context and summary. Let me note to you. Honorable Hendricks.
Thank you very much, Honorable Chair. Honorable Chair, I know I'm a respondent in the Supreme Court of Appeal with grabbers under the DA and Accent SA in the city of Joburg. Having said that, the Minister of Police has been very open and said, yes, we do use the grabbers to gather information unlawfully. So he's taken the nation into his confidence. As far as this particular matter is concerned, allegation is that the public protector uses sides of political parties and of factions in political parties. I would like to urge the committee carefully read her explanation. I'm going to do it for her. She has given a thorough explanation, and I accept the explanation. Thank you very much.
Thank you, Honorable Hendricks. Honorable Milan.
Thank you, Chairperson. I think that the issue here is the reliance of the public protector on unsubstantiated allegations, on unprovided evidence or information that has not been included in the report or the Rule 53 record. And as such, there is no basis on which to make a finding. If you have an allegation, it is not factual. It's someone saying that this is the case. And here we've heard from what Advocate Bauer has just shown us that a lot of the so-called facts in this matter rely on emails and on allegations made by political parties, not on evidence. And that is unfortunate. And it goes to the incompetence of the public protector in this matter. Thank you, Chair.
Thank you, Honorable Milam. Other members, may I also check with members, are you comfortable with the way I've ruled that we do it ground by ground, piece by piece, or you want everything else? Honorable Nkosi?
No, Chair, I'm comfortable with that. We do it ground by ground.
Okay.
Otherwise, we will not be able to cover everything, all 9 grounds. On the first ground, Chair, I think the question we need to answer is whether there was exceptional circumstances that permitted her to investigate the matter. And I think, as demonstrated by the summation and the evidence for us, it's clear that the court was correct that there were no exceptional circumstances that gave a jurisdiction on a matter on which she had no jurisdiction to investigate. And then we can speak about the reliance on emails and other information, etc., that has not been tested and that could not be tested or could not serve as a ground for her to do the investigation. But the cardinal issue is whether there were exceptional circumstances, and I think that there were not.
Thank you, Honorable Nkosi. Any other contributions from other members? Thank you. Any remarks, Advocate Bauer, before you proceed to the next one?
Sorry, Chair, I get muted. I need to.
No, that's fine. Let me hold you back. Honorable Maneli.
Thank you, Honorable Chair. Don't know why the budget is slow, but my hand was really up. Yes.
Yeah, when we're physical, there's no slowness. So
There's no
paying
slowness.
the price of
I would
the
have raised my
virtual.
hand. Okay. No, thanks, thanks, Chair. I think one also agrees that on this point, both what the courts would have said, but also the independent panel in terms of the prima facie. Indeed, from evidence led before the committee, Honorable Chair, we still cannot get the special circumstances outlined. As Honorable Kosi would have said, the reliance on whether it is from good authority or not, it gets to be another issue. But the issue at hand now is that there's not been articulation of those special circumstances that would have led to going back there, even when there was an indication that the predecessor would have not moved in that direction and the advice thereof, but still proceeded along those lines. Thank you, Chair.
Thank you, Honorable Maneli. Any other member? Is there any different take or different view? None. Advocate Bauer?
Chair, on ground 2, it gives rise to the issue of...
Okay, you're proceeding on ground 2 now. Okay,
yes.
Go ahead.
Yes, Chair, the issue on ground 2 is whether the reliance or whether in giving a notice on YouTube and relying on the media. Let me give you the reference in the summations as we go along. It's paragraphs 48 to 75 of the summation. But the question is if there was misconduct, incompetence arising from the manner in which she gave notification of a Section 7(9) notice publicly disclosed on YouTube that Mr. Godan was implicated without giving him prior notice thereof, and telling the public of all the other complaints that had been lodged against him, even prior to giving him a chance to respond. Our Chair will be aware that this was one of the issues.
Just a pause. Honorable Maneli, is that an old hand hanging, or you want to have a bite?
No, Chair, it may be an old hand. I just hope you got the last point made by that old hand. That the point I was emphasizing was that the independent panel point is substantiated. Thank you.
Okay, I didn't get that. I'm getting it now. Thank you. Proceed, Advocate Bauer.
Okay, Chair. So the first issue was in disclosing that you are issuing the 7(9) notice. In other words, the 7(9) notice gets issued to somebody who you say is implicated or in some sort of wrongdoing that you are investigating, and the fact that she has publicly disclosed that she's issued the 7(9) notice against Mr. Godan, and telling the public of the other complaints that has been lodged against him even prior to giving him a chance to respond. And the question then arises is, does she exercise her powers constitutionally without fear, favor of prejudice, and impartially in giving a first-time notification to the public that the person has been implicated and investigated? Now, Chair, you will know that the defense that was raised in this matter was effectively that the court got it wrong, and that in the court's judgment, it had misconceived this notice as not being a notice that I'm issuing a 79 notice, but having said that, she actually issued the 79 notice itself in the public domain. And they referred to a paragraph in the judgment which said that. There is another paragraph in the judgment, which is paragraph 43, which says precisely that, that's talking about the notice. So there's two paragraphs in the judgment, one Advocate Mpofu relied on and not the other one. But the issue before this committee, Chair, is whether it was appropriate to first release media releases saying that Minister Gordhan had effectively been found an implicated party. And there were a few reasons as to how this came about. Firstly, there had been a meeting at SARS, and the PP then issued a media release saying that Minister Gordhan had colluded with SARS and other implicated parties to construe answers for her. And she put that out in the media domain. Minister Gordhan had not been at this meeting. And so in response to that, his lawyers then put out all the correspondence which had ensued with the public protector asking her for special circumstances that they then said was not forthcoming. Thirdly, she then indicated when she made this presentation on YouTube that she was investigating a rogue unit, and the interpretation put to that was as if it was a fait accompli, that it was a rogue unit. In other words, she was not investigating with an open mind. And then by telling the public that people had lost lives and had been threatened, when this neither appears in the report nor in the Section 7(9) notice. So the explanation that is given to the committee for doing it is not what she says in her report. And her motivation for doing it is because she says there was this extensive negative media campaign, and it was retaliatory. We know, Chair, because the committee has emails which the court doesn't have, that in an email on 20th of May, she attributes the public protector's removal to have been at the instruction of Minister Gordhan. She says that in an email dated 20th of May 2019. We also know that that the position adopted in respect of this was informed by advices which she received by Mr. Nkubeni, who says that she must put out into the public domain the information as she did. And we, during evidence, had displayed that email. So that was what informs this leg of the inquiry, Chair.
Have you landed?
Yep, I've landed.
Okay, thank you. There you are, honorable members. Let me invite you to interact with this. Honorable Nola, followed by Honorable Hendricks.
Thank you very much, Chair. Chair, without many explanations. I mean, it is common cause that it was inappropriate for the public protector to issue a Section 7(9) notice through public platforms and not to the affected parties, and that from onset had constituted a misconduct. Thank you very much.
Thank you, Honorable Ngola. Honorable Hendricks.
Honorable Chair, our take is that there was no rogue unit. However, we haven't heard the last of this particular matter, we feel that this is one matter that the Office of the Public Protector must take responsibility for, and not necessarily the Public Protector alone. And we cannot then impeach the Public Protector because our office decided, according to what is before the committee, to put it in the public domain before informing the lawyers. That I personally lay in front of the door of the CEO and also the spokesperson who released that particular media release. Thank you, Honorable Chair.
Thank you, Honorable Hendricks. Honorable Maneli.
Thank you, Honorable Chairperson. I rise to agree with Honorable Mola that from what has been presented, it's quite clear that you have something unprecedented that would have been done. As releasing this to the media without engaging with the affected person would have not been the way the Public Protector would have worked in other investigations. Of course, before this committee, we were also made to understand that she would have done other things to ensure that there's no leak. But it doesn't remove, Chair, the fact that procedurally, this would have been interacted with the affected person first. And that person would not hear this from the media in that regard. And therefore, would have not been the right manner of ensuring that this investigation is done properly. Again, as it relates to what the passage refers to as the rock unit and so on, it does affect, as I say, the way of being a person with an open mind. And this committee has been reminded of this by the legal representative of the Public Protector. The Mail and Guardian was quoted many times. That you need to have an open mind and so on. And in this case, this didn't apply. And we're placing this chair because it's a matter of competence. We're placing this to the Public Protector, given what we've dealt with in the other sections, that at the end, the buck stops there on whether to release or not release. It gets signed off that this is the route we would take. I submit, Chair. Thank you.
Thank you, Honorable Maneli, for your contribution. Honorable Mailam.
Thank you, Chair. I just want to add one point to this, and that this is the first time in our deliberations over the past 2 days where we've seen the direct involvement of Mr. Ngubeni and his advices to the Public Protector. And we know from the evidence that we've seen that Mr. Ngubeni is not entitled to practice law in South Africa, and that the Public Protector should not have been using those as legal advices or even for communications purposes. So I think we need to just note that it was brought in this particular matter. Thank you, Chair.
Thank you, Honorable Mailam. Honorable Dlakude.
Thank you, Honorable Chairperson, and thanks to the evidence leader for that information, which reminded us of what exactly transpired during the evidence that was given. Honorable Chair, I want to echo the same sentiments as Honorable Maneli, that in any investigation, the implicated party is notified In this one, Mr. Gordhan only came to know about this in the media. He was not informed by the PP of her intentions. So she decided to publicize that in the section 7.9 without even notifying him notifying the Mr. Gordhan of the consequences thereof. So I think this is not acceptable. In this way, she didn't conduct herself in a manner in which she's supposed to do so. Thank you.
Thank you, Honorable Jagude. Honorable Nkosi. We're losing your network.
Just to point out that
just reposition yourself.
Public protector should have realized that I'm on load shedding now. I'm whatever. So
Yeah,
you can know.
Yeah, we can't hear you properly. You're cutting. I'll come back to you. Let me come back to you, Honorable Sukas. Honorable Sukas.
Hi, Chair. Chair, I think my point is at the next point because I think we.
Okay. Yeah. No problem. Honorable Manel, is that a forgotten hand or a forgotten point?
Sorry, Chair.
Okay. Can you reposition yourself, Honorable Ngosi? I now come back to you.
I've done that, Chair. Am I audible now?
Yes.
No, I was saying I agree with the views of the committee members who contributed, but just to add that the public protector should have realized that she wields enormous power in relation to people that she investigates, and therefore she has a responsibility to take adequate care that people don't receive notices such as a 7.9 publicly or not directed to their legal representatives. And in this case, she failed. Thanks, Chair.
Thank you, Honorable Ngosi. Any other member? Any further dissenting point? None. We proceed. Advocate Bauer, can you go to G3?
In the next section, we take two of the grounds together. We look at what is 3 and 6 together, and we do so because members will recall that during her evidence, it was indicated to Mr. van Lagenberg precisely what Advocate Nkabani took into account in reaching a decision, and this ground is that the reliance on the KPMG report, despite it having been disavowed, the Sikakane report, despite it being widely discredited, she had also failed to engage with the findings in the Nugent report is part of ground 3, and ground 6 is that she had disregarded the Sunday Times apology and the Kroon apology. Now, Chair, you will know that this was disputed during the oral evidence, and information was put before the committee, which was not precisely the information which appeared before the courts in the affidavits, nor based on what was contained in the report necessarily in that regard. And you would know, Chair, that there was a issue about whether the documents upon which was relied was actually submitted within the Rule 53 record. And ultimately, what it boils down to is whether there was an independent investigation done by Advocate Nkabani by the investigator Mvuyana and Mr. Matabogo, independent of what other reports had to say in that regard. And before this committee, it was said that they did independent investigations, but and these reports were simply corroborative of her findings, which they came to independently. This is not necessarily what is borne out in the report, in that there was direct reliance placed on certain parts of the evidence of those reports in that. So if we possibly take them chronologically as to what came first in the line of thinking, so one goes to the Sunday Times, because this whole notion of a rogue unit is introduced by the Sunday Times, and it's on the basis of what is contained therein, that the Sikakani report, or the Sikakani panel, then says we would be remiss if we didn't look at what the Sunday Times had to say, and then they made certain recommendations, which was elevated to findings. But the Sikakani report made certain prima facie findings, and then made recommendations that it needed to be considered further. Sikakani report was relied upon by Advocate Nkubani in her findings and conclusions, and even in a summary in the SARS unit report. So, given that the preface of the Sikakani report was the Sunday Times articles, which was then essentially withdrawn by the Sunday Times. One of the complaints was that she had not taken that into account, even though it was raised by Mr. Pillay in his submissions to her. I think before this committee, she said that she didn't read the Sunday Times, but it was there. The second thing was the reliance placed on the Sikakani panel, including the interpretation as to whether the Intelligence Act was contravened or not. And we know that as a matter of law, the court has now ruled on that. And indeed, it was a case of where neither the Act nor the Constitution was breached. And that's a binding finding in the country. We also are aware that the panel that compiled the report was 3 practicing advocates. That does not constitute administrative action that would that can be subjected to a court of law to be set aside. It's an opinion, it's a recommendation. It's not a decision of such nature that you can actually go and review. SARS on its part had made it publicly known that they were not placing any reliance on the contents of that report afterwards. So the difficulty remains is whether there was an independent investigation done, whether there was witnesses interviewed afresh, whether documentation obtained was effectively authenticated, whether recordings relied upon was authenticated, and in respect of the findings of the Sikakani report, whether to some degree it was overstated. Before the committee, there was no dispute that the Sikakani report was relied upon to make a finding that Minister Gordhan had knowledge of, in particular, the issue of recruitment. Okay, so and so we detail a number of instances where there are difficulties in that regard. And then the third one is the reliance placed on the KPMG report, and the fact that there was no verification done of what was a desktop exercise performed by KPMG, and not ignoring the disclaimers by KPMG specifically, or not having due regard to Mr. Pillay's submissions as to why the KPMG report should be rejected. There was confirmation by Mr. Matabogo that they had looked at the KPMG report as evidence, And then some Vuyana then referred later to tape recordings that they had used that I'm going to come back to in a bit. That their findings was more than just corroborative, that they used it as actually evidence for purposes of the report. The third issue is the Kroon apology, which the SARS unit report doesn't mention directly, but it mentions it in the context of the Nugent Commission report. Again, Chair, the issue was that the SARS board had almost unconditionally accepted the Sikakane report and then repudiated the reliance on the Sikakane report and apologized. Judge Kroon apologized for that. And the issue is less one as to how you view the apology, but whether you investigated what was the implication of that policy. Did you speak to the SARS board? Did you engage with Judge Kroon? Did you make sure that what they did was actually correct in that regard? And the fact that Mr. Pillay says to you on affidavit, this was an apology after the board had deliberated subsequently there too, and this retraction was done. The committee heard evidence that this was effectively an apology of the judge and not the board, because they hadn't said anything. But the actual evidence before, at the time of the report and before the litigation, was effectively that it was that of the board, without that having contravened. And then we come to the Nugent Commission report, which was not listed as a key source in the SARS unit report, and there was some contradictory evidence as to whether they relied on it or whether they only referred to it, but it's not reflected in the Rule 53 record. And there are a number of passages within the Nugent report which also refers to the unit and the investigation thereof, and the fact that Judge Nugent endorsed the opinion of Advocate Strengrove and Malo, who actually finds that the unit is actually lawfully established. So there is this opinion which is in her possession, which effectively says, on the one hand, that SARS unit was lawfully established, and the nub of this is, did you, as enjoined by Mail & Guardian, properly investigate all the evidence before you to come to the conclusions you did? And if not, is that the basis for misconduct and incompetence? Thank you, Chair.
Thank you, Advocate Bauer. Whilst it's fresh, thank you, honorable members. Your responses, please. As you can see, some of the relevant questions you need to respond to, but let me leave it to you. I will start with Honorable Hendricks, followed by Honorable Ngola.
Thank you, Honorable Chair. The evidence leader went out of her way to explain the different considerations for the public protector. And I come to the conclusion that she needed to have the wisdom of Solomon with so many diverse opinions that has been put before her. I think under the circumstances, Honorable Chair, it is my view that the final decision by the public protector does not merit consideration for her to be impeached, because she was confronted and guided by decisions of the best legal eagles, I would say, in the country. Advocates are all respected. Their views cannot be easily discarded. And when three of them come with a position and is put before the public protector, what would you do, Honorable Chair? I'm just worried, Honorable Chair, that those applicants for the new public protector posts, if they hear all this, they will also withdraw their nominations. We're making it very difficult. You need to have the wisdom of Solomon. Thank you very much.
Thank you, Honorable Hendricks. I hope they also understand the importance of that office too. Thank you. Honorable Ngola.
Thanks, Chair. Chair, Mr. Pillay, in his response to the Section 79 notice, it does go to an extent of making serious comparisons in the Sekakane Commission report, the KPMG report, and the Najan Commission report. Detail on what are the differences and how the other ones are discredited reports. But that was not taken into consideration in the final report. Mr. Pillay, Chair, further goes to an extent of submitting the apology of the Sunday Times in the articles that they've been writing, which were misinformed, which the public protector placed reliance on in some of her investigations in this matter. So Chair, this feeds to the narrative that the public protector would enter an investigation with a predetermined outcome. It really feeds to that. So from where I'm sitting, Chair, the Najan Commission report was completely ignored in the matter, and it was inappropriate for the public protector to do that. So Chair, for now, I think that's my contribution. Thank you. Chair, lastly, I think we must note that both Peter Rampedi and Mzilegazo Africa are not journalists. They're just hired guns to a particular cause. Thank you.
Thank you, Honorable Ngola. So when you say she had predetermined outcome, so you would argue that she was not of independent mind and impartial?
Yes, Chair, especially to the fact that the incident was 10 years old. And in terms of Section 6(9) of the Public Protector Act, it must not be more than 2 years at the time of the complaint. And the special circumstances Advocate Bauer is talking about were neither explained in court nor in the committee. So there was no open mind at all. Thank you very much.
And would the action be an intentional one?
Completely intentional.
Thank you, Honorable Ngola. Honorable Maneli.
Thank you, Honorable Chair. I think with points having been made already, I would then, and when I say already, I mean just as I come after Honorable Ngola. Just to say, Chair, that indeed if the investigation is open, you'd see at least some attempts that get made to follow up on the articles on the Sunday Times, including engaging public editors and so on. You'll also see an interest in looking at the reports that are relied upon, whether it's KPMG's Kakani. And once you engage it without just taking what is there, you would have then followed it up to a point of understanding that some of these reports could not be relied upon anymore. Let's take the KPMG situation where they themselves were taking money that they took to do an investigation back because of it was not worth the paper it's written on. Then you rely on that. And then when there's a Newton report, no, you can't even use it because it's not a binding report, because it doesn't really speak to what you want to see as the ultimate outcome. What Honorable Ngola said is predetermined. So there's no impartiality in that, quite clear. And the intentions are clear, so it makes it intentional in that score. I think it makes the point that even when, from a Section 79 point of view, play raises these issues, you still ignore them as though they've not been raised. And I'm saying, then, Chair, in that score, the investigation would have not been done in a proper manner. There's no independent conduct because you want to see a particular outcome depending on the people you are dealing with. And already I've spoken to it being also intentional, and then there's no impartiality in that score. And therefore that's a real failure closely in that way. Because there was no way that you could ignore, as I say, the Huchan report when you have accepted other reports. But I think that's also going back to some of the things were raised Friday, where there would have been evidence before the committee that makes this understanding that you may know the legal side of things, probably as a lawyer or attorney, but the actual practice of the law gets to be also important because there's a reasonable assumption that if the Skakana report was done by practicing advocates, you would know that it would not need another process of court review in that scope, just from that understanding. And therefore, you would not expect other people to have done something else in that regard. So I just thought, Chair, that's my contribution to all those questions as I've responded based on evidence before the committee, which even in the evidence led, whether it is the advocate Mpofu as the legal representative or the PP in what has been compiled, there is no objection to this thing that this is actually how they approached the investigations on this matter. Thank you.
Thank you, Honorable Maneli, for the contribution. Honorable Ragude.
Thank you, Honorable Chairperson. Just to add on the information given by Honorable Ngola and Honorable Maneli, is that Mr. Pillay, in his first affidavit, paragraph 7.1.7, he also made mention of the investigation by the public protector in 2014, August 2014, where he directed that the PP can get that information from SARS. But this was also ignored by the PP. It is clear that the PP had plainly refused to have regard to any of these records and evidence, and seemingly made no effort to obtain any records from SARS. So maybe if that was taken into account to check other records, then she wouldn't have relied on this Kakane report to come to her conclusions. So that's my addition, Honorable.
Thank you very much, Honorable Lagude, for that contribution. Honorable Mailan.
Thank you, Chairperson. Chairperson, much has been made throughout this hearing process of the rules of natural justice, and in particular, the rule of audi alteram partem, or hearing the other side of the debate or the discussion. And I feel that in this particular case, this rule of natural justice has been ignored by the public protector, in that she has only really considered one side, and that talks directly to her impartiality or lack thereof. I'm also concerned, Chair, that the misunderstanding of the legislation and the constitution talks directly to her lack of legal capacity in this regard. And it goes directly also to the quality control that has not been implemented on all these reports that have been taken on review. So throughout this process, we've had a number of reports, and we heard that the quality controls were shortcut, that reports were written late into the night, that the public protector would instruct people to make changes, and that those changes would not be quality assured. And so I think there's a bigger issue in terms of the management of the investigative process. And so my position on this whole thing is that the investigation that was conducted on the rogue unit was not done in an impartial manner. It was not done in a manner that ensured independence. It was not done in a manner that sought to obtain all the information available. And it certainly did not look at the most up-to-date information, which differed fundamentally from the initial reports, the Sekakani report, the KPMG report, the Nugent report, etc. And so I find that the public protector is in the wrong in this regard. Thank you, Chair.
Thank you, Honorable Mailam. Honorable Sukas.
Thank you, Chair. Chair, my contribution is just when asked about how the investigation of Mr. van Lochenberg was conducted, the PP stated that the investigators did nothing wrong. Now, it is clear that these investigators did not act competently, especially in ensuring they contacted Mr. van Lochenberg. Now, it would be speculation to determine why she thought this, as she has not appeared to answer our questions. But we can conclude that if she believes this was a well-conducted investigation, then we need to doubt her judgment in this case. And it would lead to the conclusion of incompetence in terms of the investigations. Thank you. I have concluded, Chair.
Thank you, Honorable Sukas. Thank you, Honorable Gondwe.
Thank you very much, Chair. I agree with previous speakers around the fact that the manner in which the investigation into this so-called SARS rogue unit was conducted was far from being independent and impartial. So much so, Chair, that we heard evidence that supported the idea that the PP was selective in the evidence that she used. And I tend to agree with Honorable Ngola when he says there was a predetermined outcome. And that is very clear because we have the KPMG report, we have the Nugent Commission report, and as previous speakers have already stated, KPMG even backtracked on their findings, desktop findings around the report, and the PP ignored this or ensured that this didn't come across very clearly in the investigation. But also when looking at the investigation, we heard evidence from Mr. van Lochenberg saying that he submitted reams of evidence that was not taken into consideration. So, Chair, all of that, clouds the manner in which the investigation was conducted and suggests that there was a particular outcome that the PP would have liked to arrive at in terms of this investigation. And we also had evidence that she was also referring to that unit as a rogue unit, even prior to the conclusion of the investigation. And that already cast aspersions on the lawfulness of that unit, and also her reliance on the report of the Inspector General of Intelligence. I mean, a report that was classified at the time, and we're not even
sure to this day where exactly she obtained that report, but she placed, it is clear from the evidence that we've heard that she placed a heavy reliance on that report. Thank you very much, Chairperson.
Thank you, Honorable Gondwe. Honorable Ngosi. Honorable Bekizo Bo.
I agree with all. Yes. Am I audible?
Yes, I can hear
Chair,
you.
can you hear me?
Yes.
Okay. Yeah, I'm saying I agree with what members are saying. It's safe to say that, you know, the public protector, both because of her office, but also because she is an admitted advocate, to ignore all information that is available and relevant to decision-making is a serious dereliction of duty. And in this instance, in my view, she did so because it was contrary to what she believed or what she wanted to do in terms of findings on Honorable Godan and I mean on the SARS unit, on the SARS unit and whatever its activities were. Thanks, Chair.
Thank you, Honorable Ngosi. The last sentence, Honorable Suela.
Thank you, Chairperson. Beyiqalile le nkinga le yekuphakamisa ngabonakali. Chairperson, I happen to support all the speakers, most especially the first and the last speaker, Honorable Ngola, when he said that the outcome ibe khona before even the investigation started. So the manner in which the investigation has been conducted, ayibonisi independence here. So we don't know whether it was done intentionally or it was just a negligence on the part of the PP, but the investigation inama flaws lamani. So I'm in support with the other members as well as the summary by the advocate. Thank you, Chair.
Thank you, Honorable Suela. With there being no other member, we proceed, having recorded all the views of the members into our report. Advocate Bauer, the next ground.
Chair, the next ground is a bit more complicated. Well, the next two, but let me deal with the IGI report first. We dealt with it quite extensively in our summation note as the fourth ground, because the court made a finding of dishonesty against the public protector with regard to this report and her insistence in the remedy to order the Minister of State Security to implement the report. And members will recall that the issue was whether the court judgment had effectively got it right or wrong in saying that she had indicated to the court whether she had regard to it or not. So let's look at what's the evidence before the committee. In that regard, there was evidence. She had received information that there was this report, and I'm taking you to the summary of what is above in our report, although there's quite a bit more said above. She had received this information about the report. It had apparently been anonymously dropped off at the PP's offices in early January. Advocate Mkabi had been aware of it being a classified report that had been dropped off. When it comes in a moment to the question of its authentication, she then writes to the IGI and says she's been reliably informed of this investigation. There's no mention in that letter that she's actually sitting with a copy of the report. She seeks a copy of the report. IGI tells her the Minister of State Security's got it. Go and ask the Minister for it, and confirms that there was such a report done in respect of media allegations against branches of the SSA that had been finalized, not SARS, Chair. Noticeably, that's the communication that comes. Advocate Ngubane then issues subpoenas against both the IGI and the minister. And they are supposed to be on the 31st. There's a bit of a delay with the minister, but the IGI comes with Advocate Govender. And the date is wrong in the summary, Chair. That date should be the 31st of January. And at that meeting, they explained to her that it's classified and how she should go about getting it classified, and they offered to some assistance. At no stage in that meeting, Chair, is that report, which she has in her possession, provided to the IGI or Advocate Govender. So they don't physically see the report that she has. They just get told she has it. She then, when asked by the committee about it, then she says it was authenticated because the dates were exactly the same, and she had been told by the IGI and Advocate Governor on the 31st of January about this report, and she was satisfied that they authenticated it because the dates were exactly the same. There's then a dispute which arises with the Minister of State Security. There is initially a meeting. Advocate Mkabane says she promised to give her a copy of the declassified report, and they get into a spat about this, and they go and they take court actions against each other. And the Minister of State Security's version in court is that they did not agree that she would give Advocate Mkabane a declassified copy. She had indicated that Advocate Mkabane must surrender the classified possession document to her, and she would commence a declassification process. On the 20th of February, a few days after that, she then writes this letter to Advocate Mkabane, and she tells her she must surrender this report. At no stage does Advocate Mkabane surrender this report. The minister does tell her that the IGI didn't have a legal mandate to investigate SARS in terms of the Intelligence Services Act, and that falls by the wayside. I pause here to point out, Chair, as you would know, there are key resources listed in the report to which is referred, and all the correspondence with the IGI and the minister is reflected in that key sources of documents and are repeated in the Rule 53 record, except for three things: the IGI report itself and the correspondence which ensues on the 22nd of February and the 27th of February is not disclosed. Now, on the 22nd, Advocate Mkabane writes to the minister and tells her that she didn't know, and she doesn't know if the document in her possession is indeed the IGI report, and she wants the minister to cooperate with her, failing which is going to start proceedings of contempt against the minister for not cooperating with the Public Protector's Office, which indeed happens. The minister responds on the 27th, and she notes that Advocate Mkabane admits to being in possession of a secret document, which she's not entitled to keep. She must return. She's not the lawful custodian, and that her continued unlawful possession is a crime. The minister then goes and opens up a crime docket in this regard, and she lays charges, and there's charges laid against each other, which they then both withdraw and they resolve the matter afterwards. But the point being raised is that as at that date in February, Advocate Mkabane tells the minister, I don't actually know whether this report I have is the authenticated IGI report. This committee was told that the IGI had actually authenticated the report on the 31st of January. You will recall that you received written responses to questions from Advocate Mkabane in respect thereof. So now if we move forward, we now have, and we know, Chair, that you'll see it's in greater detail in I note that effectively she goes to senior counsel to get legal advice after the minister tells her, you must return this report and you must give it back. And the senior counsel's advice to her rendered on the 25th of February is to the effect, well, nobody's actually yet told you that this is the genuine item of the IGI report, so you can't be said to be breaching the law because it's not yet been authenticated. We then know further that Advocate Mkabane is in possession of the Noseweek article because it was sent to her by Mr. Shavambo, and that effectively Ms. Mvuyana, who's the investigator on the matter, is never given the IGI report. She never sees it, she never relies on it, and whatever instruction she's given to put into the document emanating from the IGI report is either done by Advocate Mkabane or Mr. Matapogo. Mr. Matapogo, on the other hand, does have top secret clearance. He was provided with the report. He was told to put it in a safe. He denied ever opening up this document to even read or glance at it. He says whatever went into the report came from Advocate Mkabane, and that she instructed the remedial action relating to the IGI report, which she then confirmed. Advocate Matapogo, Mr. Matapogo, as we know from conglomeration of his evidence, reads very little of what's provided to him. So we questioned comparing the competing documentation as to whether there was a disclosure that the IGI report had actually been provided, and whether there was a disclosure at the time of the report in respect thereof. But what is of importance, both in respect of the IGI report and the Noseweek article, which they both have, is that the intent of all of that is that certain findings are made against Mr. Johan van Lockenberg in that report, and the remedial action which is ordered is that that report's recommendations, including the criminal proceedings, must be pursued against Mr. van Lockenberg, is then incorporated into the remedial action of Advocate Mkabane in the Public Protector's report without having given Mr. van Lockenberg any hearing. The declassification process is not awaited for, and reliance is then placed on the IGI report, regardless of any authentication in respect thereof. Go down, Sepo. And the phraseology in the report is taken such as reliably informed and on good authority. And eventually before the High Court, there is then a concession made by her counsel that yes, actually at the time she had the report, at the time she compiled this report, she did have the IGI report in her possession. One can, and we've done that exercise, we've gone through the versions of what's placed before the High Court on affidavit, where that is not stated in exacting terms. And we can see from her report that some of the information that was placed before her, or which informs the findings in the SARS unit report, emanates directly from the IGI report. And it wasn't simply corroborative of an independent investigation. So we see that several invitations offered, and this becomes important when you look at the CR17 matter as well, because the litigants in the High Court asks Advocate Mkabane in terms whether she's in possession of the classified IGI report, and there's no direct answer given in the review application in respect of that. There is a response taken that it's not up to them to come and ask her whether she's in possession of a report or not. So, Chair, those are essentially the basis upon which the findings of dishonesty is to be found. And for this committee, the test must be, was there misconduct or incompetence in the manner in which the IGI report was dealt with, and does it reflect a lack of independence and impartiality?
Thank you. Thank you, Advocate Bauer. I come back to you, honorable members. I will start with Honorable Ngola, followed by Honorable Dlabude, followed by Honorable Hendricks, Lothrit, Gondwe. In that order, you kickstart, Honorable Ngola.
Thanks, Chair. Chair, let's first concede that in respect of the IGI report, there has been a lot of inconsistent and incoherent statements. And it points to the fact that we have been misled about the IGI report throughout. The first misleading statement was the fact that the report was just dropped by an anonymous person. That's the first misleading statement, whereas the public protector
Honorable Ngola, you cut out, I can't hear you. It seems to be frozen. Okay, he's gone. We'll come back to him, Honorable Dlabude.
Thank you very much, Honorable Chairperson. To take from where Honorable Paula left off, we all know that IGI that report was a classified report, and it can only be the Minister of SSA who can declassify that report to allow it to be handled by anyone. So, Honorable Chairperson, it seems that the PP was determined to use and rely on the IGI report regardless of the obstacles in a way. So she was advised to return the document to the to surrender the document to the SSA. But what is problematic is that she stated that she had the report's findings on good authority and used the phrase apparently in her reference to its existence in a report. So, Honorable Chair, like Honorable Ola was saying, I found it the evidence that the report was dropped off by an anonymous person to her office. I couldn't believe that, because she had it on good authority that the information that is in the report, she could use it. And that's why she relied mainly on that report. So while the PP told the IGI that the classified report had been dropped off at her office, just to quote paragraph 73, she stated in a report that she had it on good authority, what its findings were. So the IGI legal advisor, Jay Govender, has stated that the PP never provided their office with the report. So it could not be authenticated. This is contrary to what the PP informed the committee, that the IGI informed her that the report she possessed was the correct report. There was no basis in law for the PP to use that report that was illegally obtained by whoever gave her the report. or by whoever dropped the report in her office. And in the evidence that was led before the committee, we learned that the report was dropped off by Honorable Shibam. So it can't be anonymously obtained. It was dropped off by the person whom the public protector knew dropped the report. Hence, she relied on its findings to make her own conclusions. Thank you, Chair.
Thank you. Thank you very much, Honorable Lagude, for your contribution. Honorable Hendricks.
Thank you, Honorable Chair. Honorable Chair, the evidence leader informed us that there was an agreement between the minister and a public protector to settle. And also, we have heard that the public protector had before her the advice of a senior counsel. This matter was put before Parliament by the Democratic Alliance to impeach the public protector. And after now listening to the evidence before us, I don't think it's an impeachable matter. Thank you very much, Honorable Chair.
Thank you, Honorable Hendricks. Not impeachable. Thank you. Honorable Gondwe.
Thank you very much, Chair. Chair, I agree with Honorable Lagude that the PP's assertion that the report was dropped off by an anonymous source is really it's hard to believe, because you will recall that Mohaladi informed this inquiry during her evidence that the complainant in this matter, Mr. Floyd Shivambu, is the one who sent her the copy of the classified IGI report. He sent it via WhatsApp and he sent it via email. And you will recall, Chair, that in her evidence, she stated that as soon as she saw that it was a classified report, she then closed the email. Now, coming to the public protector, Chair, it's worrying that as soon as she received this report, knowing full well that it's a classified report, that she never even reported the possession of her report to the relevant authorities and indicated that I'm in possession of a classified report. Instead, she went on and placed reliance on this report. And Chair, this then makes one wonder, to what lengths is she willing to go to in order to reach a particular conclusion? She's even willing to break the law because she was in unlawful possession of a classified report. And as a public protector, we are expecting her, Chair, to be the first person to uphold the law, to be mindful of what the law says around, the possession of classified documents and unlawful evidence. But here she is, she went ahead and relied on this report. And that's worrying, Chair. That's extremely worrying that she didn't even make an effort on her part. Instead, she went so far as trying to correct her unlawful possession of the report. We heard her counsel tell us that she tried to correct this unlawful possession of the report by then requesting a meeting with Advocate Dindwe and Advocate Govender. And during the course of that meeting, we heard the recording. I recall there was a part where Dindwe explained to her that the Office of the Inspector General of Intelligence has no jurisdiction over SARS and the operations of SARS. You will not share that the Office of the Inspector General of Intelligence has jurisdiction over your police intelligence, your crime intelligence, and then your SSA, and then your defense intelligence. And he correctly pointed out to her that, look, my hands are somewhat tied at this point, because she was saying, why are you allowing this unit to continue with its operations, etc.? And that's worrying, Chair. That's extremely worrying because despite Advocate Dindwe trying to explain to her that, as the Office of the Inspector General of Intelligence, ideally speaking, we have no jurisdiction over SARS and its operations. And she was going on about the fact that you should have not allowed, why are you allowing this unit to continue with its operations? Because she was insisting that despite the unit being disbanded, it was carrying on with its operations. And so, Chair, I think it's very important that we emphasize that she did not uphold the standard of a public protector in terms of ensuring that, number one, the evidence that she relies upon, she's obtained it lawfully. Number two, she also ignored the law, disregarded the law, and went ahead and relied on a report without even informing the relevant authorities that I'm in possession of this classified report. And I want to say this again. I tend to suspect that she got the report from Floyd Shivambu in the same manner that Mohaladi got the report. And when she got the report, she went on to share it with certain people in her office, including Nyembe. And I tend to think the gentleman who's the legal advisor, because we saw an email where she then confirmed with them whether they had a top secret security clearance. So not only was she in possession of that report, she went on and shared it with some in her office. Without her being, not that the fact that whether or not they had top secret clearance would make their possession lawful or not. No, the fact of the matter is that you're not allowed to be in possession of a classified report, whether you've got top secret security clearance or not, in terms of the law. Thank you very much, Chair.
Thank you, Honorable Gonde, for your contribution. Honorable Lotrit.
Thank you, Chair. I think Honorable Gondwe covered exactly what I wanted to say, and I think that we do have evidence in this regard of acting impartially, or rather not impartially, and that there was a clear evidence of gross negligence, especially because the public protector did not submit those classified documents. So yes, I can only agree with my colleagues. Thank you.
Thank you, Honorable Lotrit. Honorable Laguda, is that a comeback hand?
Yes, Honorable Chair. Thank you very much.
Go ahead.
Thank you very much, Honorable Chair. I think we've been treating this issue of the leaked classified report with a kid's gloves. I think as this committee, we should recommend to the House that this matter be referred to the SSA for further investigation. We cannot have this as a country. We don't need something like this. It was illegal, it's unlawful. And this is even some of the members who serve in the Joint Standing Committee on Intelligence cannot just get these kind of reports into their hands. So there are processes to be followed. So I think we must recommend that this information, this matter of the unlawful, of the classified report be referred to the SSA for further investigation so that whoever is leaking these classified reports must be taken to account. Thank you very much, Honorable Chair.
Thank you, Honorable Lagude. Honorable Suele.
Thanks, Chairperson. Let me join other colleagues here, Chair, on this matter. Firstly, the issue of the document which has been dropped in the office by an unknown person is also worrisome and is highly questionable. Secondly, I believe the PP fails to uphold the Constitution. My belief is that she needs to lead by example. I happen to support Honorable Dakude on the issue of referring the matter to the SSA for further investigation, because we must really condemn this behavior. So I'm in support of what other members have said. because the documents were unlawfully received and unlawfully perused. Thank you, Chair.
Thank you, Honorable Siwela. Honorable Tolangola, are you back?
Yes, Chair, I'm back.
You had just started, so let's allow you to continue.
Apologies, Chair. I don't know what kicked me off. I'm not even on load shedding. I suspect some intelligence forces are trying to deal with the problem. Chair, I was saying the committee and the court were misled by the public protector on the manner of receipt of the intelligence report. And it was a deliberate misleading until testimony in the committee alarmed us that actually not only was the report dropped, it was even sent electronically by Mr. Floyd Shibambo. I think we need to agree with Honorable Lagude that there must be an entire a comprehensive investigation by SSA on this matter. How did the report land into the hands of people who do not have a top secret clearance? But I think it's not far. The answer is not far, Chair. The second in command of the South African intelligence was part of the festivities of the EFF until yesterday. So the answers are not that far. But I think let's leave that for the investigation. It will be investigated properly. So, Chair, true, we've been sent from pillar to post by the public protector that no, I did not see the report, no, I did not set my eye to the report and all those things, which was the deliberately misleading of Parliament, which constitute gross misconduct from the side of the public protector. Because, Chair, the use thereof is quite in the extremes. The public protector ought to have known that you can't legally use a report of the intelligence without the concession of the Inspector General of Intelligence and the declassification of such. So this constitutes, Chair, alone, gross misconduct from the side of the public protector. But it equally feeds to the narrative that the public protector is just a hired gun of some factions within political parties and some political parties. This actually feeds to that narrative because this actually tells that the public protector, when she entered investigation on SARS and the Rogue unit, she already had an outcome in mind. So there was no an open mind approach in the investigation as she should do. Thank you very much, Chairperson.
Thank you, Honorable Ngola, for completing what you've started. Honorable Gondo, is that an old hand?
No, it's not, Chair.
Oh,
Chair,
okay, go ahead.
Chair, I wanted to also agree with Honorable Dlakude, but I think we also have to involve the Office of the Inspector General of Intelligence to, I think that will be the better body to actually investigate how their report, ended up in the hands of Mr. Shivambu, and eventually then, and how the PP, got her copy as well, Chair, because it's very concerning. And Chair, maybe I'm jumping the gun here a bit, but also they would also need to look at, the general involvement of the SSA in the operations and the affairs of the Office of the Public Protector. And here I'm talking about the involvement of Mr. Fraser, Mr. Moodley, Mr. Ramabulana, and the gentleman that was, seconded to the Office of the Public Protector. The involvement of all these SSA officials in the Office of the Public Protector, because it's very concerning. You cannot have an institution of that nature and that stature securitized and actually, under the conduct and the check of the SSA. I mean, that's exactly what was happening. I mean, when you look at the scenario of Fraser, but maybe I'm jumping the gun here a bit, but I'm just saying that when we do refer these matters, we should couple them all together. Thank you very much, Chair.
Well, thank you, Honorable Gondwe. I would not jump the gun with you. It's fine if you jump it, but it's recorded, whatever you put. Thank you very much. I think there are no other members. I think we have contributions, fair contributions, or comprehensive contributions from members in this regard. Advocate Bauer, can we proceed to the next?
Chair, I'm going on to what was ground 5, which I'm going to deal with as 3 components to it, because we had summed it up a little bit beyond what was in the court judgment. And members will recall that twofold what was before the committee and the court was the public references to the unit as a rogue unit in comments that was made in the meeting with the IGI on the 31st of January in relation to the unit being referred to as a monster, which contributes to a finding of bias contained in the SARS unit judgment. Secondly, the general pandering to this rogue unit narrative, we've already dealt with what she says on the YouTube video and in the manner that the investigation was conducted in relation to the alleged unlawful activities such as interception, procurement of equipment, and unlawful recruitment. I'm going to come specifically to the equipment and the recruitment at the end because it's 2 of the things considered in the report without special circumstances. And I'm not going to deal with this aspect of it insofar as it links to what we've already set up above in the summation note relating to the reports that were or were not before when she considered it. And so on the public comments of the rogue unit and the monster, Advocate Mkabani had put up the full transcript. She had also indicated to the committee what had been said in the YouTube video, as well as what has been said at the meeting of the 31st of January. And the defense was effectively that this is not a phrase I coined, but one that was out in the public domain already. But it went a little bit further because members of the unit was implicated in murder, money laundering, poisoning, threats to her, without any basis other than historical recording she had in her possession, the classified IGI report, and the fact of its conduct, which was everywhere for anyone interested to see. That was the phraseology used before the committee in that regard. And when I'm referring to those comments, I'm actually referring to an email which we provide you as CH3K, which Seppo can flight while I continue to take you through the grounds to do that. And so we find that that was one of the reasons, and now the defense was that she didn't refer to individuals in the unit, but to the operations, and that the monster comment was magnified. It was a comment made in passing, and it must be taken in the context of a discussion that had been held with the IGI. The second issue, and members will be aware that during the proceedings, we were referred to an affidavit from Mr. Moyani that was put before the Zondo Commission, and reference was made to the recordings of the conversations Mr. Moyani had with certain Messieurs Lombard and Duval, and recordings made with Mr. van Rensburg, which was listed in the key sources of information in the SARS report that said recordings related to the intelligence unit. Now, in the oral evidence, Advocate Mkabani in passing said that she had telephoned Mr. Moyani. The full details of that telephone conversation has never been disclosed. It's not relayed in the SARS unit report at all. It's not referred to in the High Court. I think first time that's come out is before this inquiry. But be that as it may, Chair, what did come out before the Rule 53 record was these recordings. Some of these recordings was put up and disclosed, and we explained to you in the summation that we do a comparison of that recordings and compare to the transcript The recordings is transcribed and it's in the Rule 53 record. And we compare those transcripts with what is attached to Mr. Moyani's affidavit, and they don't correlate. One or other of them is not correct. We don't know which. But we also know from having followed up leads that at the time these recordings were disclosed, and what appears to have come out is that this was not the only recordings of conversations Mr. Moyani has with members of the SARS unit at that stage, and that there were other recordings because they have had subsequent meetings. And if one has regard to the excerpts of those recordings, then they contradict some of the findings which has been made premised on these recordings, and we take the committee to some of that in the summation. And in summary, the difficulty of all of it is that there was a reliance on unauthenticated recordings. These recordings are incomplete. They appear to be spliced or other recordings from other recordings and are hence unreliable. You find duplicates on the recordings, which means they couldn't have been copies of the originals, if not the originals. The persons who were in these conversations were not interviewed. They didn't give evidence under oath before the public protector. So Messieurs van Rensburg, Lombard, de Waal is no endeavor or an attempt to communicate or speak to them. And there's hence a selective reliance on these recordings. And we know from Ms. Mvuyana that it was the recordings on which they placed reliance in the report, apart from the other reports. The second part of the investigation component of that is the failure to find Mr. van Lochenberg, which we know that that he was not received a subpoena. The difficulty with all of that was that he was an eminently traceable person, and if the investigators didn't do their job in finding him or issuing the subpoena properly, unlike in the FCS matter, there was no steps taken against the investigators for their inability to do that. Moreover, there seems to be a difficulty in that SARS is not directly asked for the information. There's no official attempt to even ask SARS for an address. Where's Mr. Van Lochenberg to be found? What they do is they have what we told is a senior person within SARS as a whistleblower. And they take a shortcut and they ask this whistleblower, and this whistleblower comes back and gives them incorrect information. There is a dispute as to who actually makes contact with this whistleblower. Ms. Vuyani says she doesn't. Mr. Matabogo says he has no recollection. And so it was either the public protector or Mr. Matabogo, according to Ms. Vuyana, and that's not addressed in either the public protector's oral or written statements. So we don't even know if the address actually came from anybody credible in doing that. Certainly, basic ABCs, he would have actually been found. So it gives rise to the questions whether you're conducting an independent, impartial investigation and whether you were reasonable or negligent in not doing it in that regard. So that's all part of pandering to the rogue unit narrative. We've put all of that under the same category. Thank you, Jay.
Thank you, Advocate Bauer. Honorable members, there you have it. Your take on the issues that have just been raised. And your responses help us with your contribution. In responding to these questions from 129.1 to 129.6, issues of independence, impartiality, and so on. Let me see. Is there any member who wants to take a bite? or we just want to agree with what is there? Honorable Mailam?
Chairperson, thank you. We've already covered a lot of what has been discussed here in earlier elements of this particular matter. But I want to highlight the fact that the public protector did not fully investigate this matter. She did not, or her office did not interview all the people involved. They made findings against people without ensuring that they had an opportunity to respond, and that has severe consequences in terms of her independence and impartiality. So I think that this investigation was flawed in that regard. Thank you, Chair.
Thank you, Honorable Mailam. Honorable Hendricks.
Thank you, Chair. I lost you for a while. However, Chair, I want you to give us some guidance. Is this committee allowed to make unilateral decisions like referring matters to the security authorities? I thought that we will submit our findings. It will go to Parliament. If 60% of them vote in favor of it, then it is acted upon. So I just need some guidance, because earlier on there were suggestions by two honourable members, and I respect their opinions, that the letter allegedly watched up by Honourable Shivambu should be referred, to other authorities. I just want to know if that is the work of this committee, or isn't our job to write a report that could be included in the report, but it will only be effected when Parliament votes on it and 60 members of Parliament support the findings of this committee. Thanks, Honourable Chair.
Thank you, Honourable Hendricks. Members were making their own, as you say, you respect their views, contribution, as we are doing the report drafting, so that these matters go into our report, as we'll be signing it off. But if there are matters that, because we're lawmakers who are an institution, if there would be a matter as we meet here today that there's crime committed here, there are processes of how you deal with that, and that gets done. It might not be subject to whether the majority vote for it or not vote for it, but they were making their own contributions to the report that will be tabled to the National Assembly. And so those matters, we expect them to be recorded in our report. Honourable Lagude.
Thank you, Honourable Chairperson. I think you have responded to this matter. The committee reports to the National Assembly, but we cannot ignore the fact that a report was obtained, a classified report was obtained unlawfully. So that is the recommendation that we will make. We are not yet into whether the report is accepted by the House or not. But as a committee, as lawmakers, as you have stated, Honourable Chairperson, it is our responsibility to recommend the matters to the House, and the House will decide. Thank you.
Thank you, Honourable Lagude. Any other members?
I raised my hand. You may not recognize the new gadget. I've switched gadgets, so.
Yeah, no, your gadget is not showing a hand, but you are allowed to speak and alert the chair. Go ahead, Honourable Ngozi.
Yeah, no, my apologies, Chair. I think in answer to these questions from 1 to 9, I think if they can be lifted, somebody can just move there. I think they relate first to impartiality.
Yes.
Independence in relation to the investigation. I think we must answer in the affirmative that yes, she was impartial. She didn't act independently in conducting the investigation. And in relation to the decisions, indeed, that flowing from that, the decisions would not be impartial. I mean, the decisions would be impartial.
Would be partial.
It would be partial, yes. And that overall, my view is that it was intended. So in answer to all 8, I think it's in the affirmative. Sure.
Thank you. Thank you, Honorable Nkosi. That helps. Honorable Suela.
Thank you, Chairperson. I just want to emphasize on the issue of recommendations. As the committee, I think it's our responsibility to digest what is before us and to come up with our views to assist, because of course, this is for the first time that we are dealing with such a matter. But where we feel we need to recommend, we need to do so, because it's something which came across our way. So I'm trying to support what Comrade Honorable Dakoda has indicated, as well as Honorable Nkosi, Chairperson. I don't think that there is no limit that we must not recommend certain things which are coming across us. As mandated by Parliament itself, we need to do such recommendations and forward them to Parliament as a package. Thank you.
Thank you. Thank you, Honorable Suela. Honorable Lagoda, is that a comeback hand?
Thank you very much, Honorable Chair. I want to support Honorable Nkosi on the issue of independence and impartiality when it comes to investigation. My take is that for anyone to be impartial, Honorable Chair, you must consider all the material facts that are availed before you. That's how I would say, yes, this investigation was impartial. But if there is information that was not taken into account, and also there are people who produced maybe those reports or who have information, and these people were left out without being interviewed, then I wouldn't say that the investigation was impartial. I would say there is information that was left out. So that shows that there was already a decision that was taken, that a view that was taken that this will be decided this way. But impartiality, no. Thank you.
Thank you. Thank you, Honorable Lagode. Any other member? Any dissenting view? Honorable Hendricks, is that a new hand? Okay, it's down. Thank you. We proceed to the next. Honorable Hendricks, is that a new hand? No. Let's proceed.
All right, Chair, I did try and lower it.
Okay, bye, Danki. Let's proceed to the next, Advocate Bauer.
Okay, the next 2 are shorter ones, but the one fits into more than one heading. So the first thing has got to do with the unwarranted and slanderous attack on Judge Patrol. Chair, we're going to come to that in a moment, but this has got to do with the interpretation of the Executive Ethics Code on which Advocate Mkabane gave evidence, and the belief effectively that the judge got it wrong. In contrast, you'll see in paragraph 630, the judge got it right, and Advocate Mkabane on the various advices got it wrong. But what then transpires is that in the context of having lost the matter before Patrol J, she gives an instruction as to who must be briefed in the matter going forward, and the council gets appointed on condition that Mr. Ngubeni is also engaged for purposes to assist counsel in the matter. And that instruction then goes out that he has to provide support in the background. In the course of that, Chair, we'll see from 236, go down, 237 of the matter, that there is some misapprehension as to whether he's an SC or a council or not, but put that
Is that
aside.
237 or 637?
637, sorry, Chair.
Okay.
He then provides an argument on appeal, which he submits directly to people in the office of the public protector, the late Mr. Niembi, Mr. Satauli, whom you will recall had no recollection of any of this. And he provides significant heads of argument, which Ms. Haller then provides a comment on, in which they deal with the judgment. He also then provides an article in the media, which sets out in 642 a number of statements about the judge. And we know from 644, Advocate Mkabani endorses the article and issues an instruction that in 647, she herself forwards the email and article which he had written with an instruction that this must be incorporated into the arguments for purposes of the court, presumably the heads that had been drafted. This was also raised through the evidence of Mr. van der Merwe, and it's not dealt with by the PP during the evidence. So that was the attack on Judge Potterell. Although the court asked her to apologize in respect of what she had said in her affidavits, it appears that the article that had gone out into the public domain had gone out notwithstanding. Chair, can I just deal with the next one in the same breath because it's very short?
Go ahead.
In ground 9, Chair, it's this issue about whether Mr. Pillay has a matric certificate or not. And essentially when the section 7(9) notice goes out, the public protector's office does accept and indicates that he's got the matric certificate. And when the report comes out, it shows that he doesn't have a matric certificate. And effectively, it got changed the night before the report was issued. We can't obviously see from the drafts who changes it, but it's signed. And so Advocate Mkabani, I think, testified correctly that what was under consideration by the office was his formal qualifications and not specifically his matric certificate, which is correct. But the second part of our evidence was during an interview with Mr. Pillay in the context of another complaint, which had to do with the pensions matter, they had discussed whether he had a matric certificate or not, and he had provided her with the requisite information. And the evidence before the committee was, well, that complaint was in 2016, and this was now in 2019, and it was different investigators, and hence that wasn't taken into account. The difficulty one sees, Chair, at 672 of the summations is that whilst the pension matter complaint was lodged in 2016, the interview with Mr. Pillay takes place some 2.5 months prior to her finalizing a report in respect of which she says he didn't have a matric certificate. And this was one of the, and this transcript of this meeting gets put up before the court, and it's one of the bases upon which the court says that Advocate Mkabani was biased in the outlook in which she dealt with the matter. And there's no concession actually that I'm wrong, I made a mistake. But that it had to be dealt with differently. So during her evidence, Ms. Mvuyana was agreed that there was many, if they were not sure about it, there was other independent avenues that could have confirmed the existence of this matric certificate or not. Thank you, Chair.
Thank you. Thank you, Advocate Bauer. Slow tempo, go to the questions that we must respond to as I invite members to speak. So those five cluster of questions that we must focus on. Did Advocate Mkhwebane conduct investigation in a manner that ensured impartial conduct of investigation, independent in the investigation? Did Advocate Mkhwebane make her decisions in a manner that ensured impartial conduct of investigation itself? If she did not conduct an investigation in a manner that ensured independence, was such failure grossly negligent on her part? And also whether these actions were intentional. Let me invite members to give their responses. I'll start with Honorable Nkosi. Honorable Mailam. Honorable Hendricks, is that an old hand or a new hand?
New hand, Honorable Chair.
Okay, donkey. Honorable Hendricks.
Yeah.
Honorable Ngola, let me quickly take all of you. Honorable Maneli. In that order, go ahead, Honorable Nkosi.
No, Chair, I think that in relation to all 8 questions, that on the investigation, that there was no independence, that there was partiality, flowing from that on the decisions the same. And I do think that, yeah, here, even if I will venture into it and say that it was intentional. Thanks, Chair.
Thank you, Honorable Nkosi. Honorable Mailam.
Thank you, Chairperson. Chairperson, this is the second instance of now Mr. Ngobene's involvement with the Public Protector, and it goes directly to the impugnment of the character of judges. Now, Advocate Mkhwebane directly authorized she commissioned and authorized the release of the article penned by Mr. Ngobeni, which was harshly critical of Judge Pottrell. And that is unacceptable in somebody who is in the office of the Public Protector. It is unacceptable for someone who is an admitted advocate of the High Court. And as such, she needs to be held accountable. It is gross misconduct on her part. And it was intentional misconduct on her part because she authorized it. Thank you, Chair.
Thank you, Honorable Mailam. Honorable Hendricks.
Thank you, Honorable Chair. Honorable Chair, the Public Protector has addressed all those issues, so I'm not going to go into defense. I'm not saying that all these things are frivolous, but it is my view that it is not gross enough to be matters that you impeach a public protector. And with regard to criticisms of judges, it happens all the time. The judges take it on the chin. Sometimes their decisions are overturned by higher courts. They don't have a quarrel with it. And so I can't see how we can use these incidences to impeach a public protector. Honorable Chair, you're scaring off all our applicants that have applied for the post because, if they've got to take all these things into consideration, I don't think they'll be able to do their job. And then the Public Protector's Office will then not be a Section 9 committee, but it will be a specialist court in terms of the Superior Courts Act. I think we're moving in that direction. Thank you.
Thank you, Honorable Hendricks. Worried about the new appointments. We take note of your issues that you are raising. Honorable Ngola.
Thanks, Chair. We've made a lot of submissions in respect to the manner in which the investigation were carried out in respect of this report. So my answer would be from 1 to 4, it's no. From 5 to 8, it's yes. And Chair, I think it is quite important to note that the subject on the table now is the suspended public protector, Advocate Busiswe Mkhwebana, no one else. And if there are people who ought to be scared, they must be scared of doing wrong things in that office. Actually, they really must be scared. This must be a lesson to everyone that this is how the office must be run. Thank you.
Thank you, Honorable Ngola. Honorable Maneli.
Thank you, Honorable Chair. I hope you can hear me. I'm on the side of the road now. Chair,
yes,
I'm covered by Honorable Nkosi and Honorable Ngola on the specific responses to the questions as they are put. Save to add the following, Chair. That one, indeed, it should be concerning that the public protector would have an open mind and still agree to putting up an article that now she owns, because now it's more from her as having taken this advice of attacking a judge, unnecessarily so. Unnecessarily so, Chair, in the sense that it is now proven from the passage we've looked at that necessarily she's the one who has misinterpreted the law in terms of what is applicable for members of the executive. Again, Chair, like I'm saying, it then gets to be intentional, like Honorable Nkosi, as I said, I agree with him, in that if you would have realized that you are wrong, you will accept the wrong. But if you insist that you are correct, even when it's proven that you are not correct, you have clear intentions of where you want to go. And anything that seeks to stop that becomes a problem. So I'm saying, Chair, that with that in mind, it's not just about knowing the decisions, but you have clear intentions that I would not listen to anybody. I read the same, but I come to a different conclusion that this is the one that's correct when it's incorrect. Now, the danger about that, which is what leads to real gross misconduct and incompetence, is that if you use this wrong law in application, it therefore says that you prescribe remedial actions that are outside of the law, and that people would have to implement those remedial actions. In that score, that is at the core of the public protector's work. And I agree, therefore, as I said, even with Honorable Ngola, if there's any fear about those that are coming, will be to prescribe wrong remedial action based on unlawful means. That should be worrying. And therefore, if you do it accordingly with an open mind as expected of a public protector, you'd know that the actions have to be lawful, Chair. Maybe just the last point on the Ngobeni question. I think what comes out here, Chair, is that the instruction indeed is from the top, that you have to get this one, because he'll probably deliver what I want. Maybe in terms of procurement processes, I would not be able to engage directly. I'm sure you understand what I'm dealing with, Chair.
Yes, I do.
That yes, you may not be engaged directly, or you'll be engaged by another firm, but this is an instruction from the top that cannot engage you directly because you may not qualify to do so. and then use other means to get that. But at the ultimate end, as the passage would have said, you make a direct submission, and that submission gets looked at in that score. I submit, Chair. Thank you.
Thank you for that submission, Honorable Maneli. I now recognize Honorable Sukas.
Chair, mine is just to underscore the importance of the Office of the Public Protector to be above reproach, and the context in which the issues of impartiality, fairness, in terms of the powers that is conferred to that office, the importance thereof. I think this is just in response to what was mentioned. So it is important for the office to be above reproach, and the office must be able to withstand scrutiny. And if it is then within that context, all the more that the importance of following the proper processes, ensuring the correct systems, following corporate governance principles becomes all the more important because of that. So mine is just to underscore what was said and to add those principles that was highlighted right in the beginning of this inquiry by both the Zambian Public Protector and then also by Mr. Hassan.
Okay. Thank you very much, Honorable Sukas. I have all of those members, and there would have been a different take from Honorable Hendricks, which is also noted and recorded. We now proceed. Advocate Bauer, I want to respect the wishes of Honorable Nkosi. Just indicate, I think there's one or two that is left. I'm thinking that we can have a 30 minutes or so break so that we will come back and finish. But I want to hear from you first, because Honorable Nkosi would have proposed that when we started.
Chair, there's two areas that I will deal with in two paragraphs effectively. One is dealing with procurement and the other one is dealing with recruitment, and then we're done with SARS, except for the EMEA, which I'll deal with CR17 next. So we could actually then finish off this entire section if I'm permitted to finish that.
That's in order. Let's finish those two, and after those two, we'll take that 30-minute break and come back with the CR17. Is that in order, members?
Yes, Chair. Agreed.
Okay.
Right. So this is dealt with in the latter part of the notes, but I'm only going to highlight one aspect of it because we got different evidence on this. But it's pretty well dealt with in the High Court judgment. And the issue is that the proper procurement processes for the acquisition of intelligence equipment used by the unit for gathering intelligence was not followed, and hence it amounted to maladministration. And the reasoning was as follows. You could not dispute that there was a COVID unit. And because you're now not disputing there's a COVID unit, it had to carry out surveillance. And in order for it to carry out surveillance, it's extremely unlikely that they didn't have equipment. And because I wasn't given any paperwork to show that there was such equipment, it must have been unlawfully procured. That in a nutshell was the argument. And the response by Mr. And the public protector had a list of equipment involved. And so what the evidence showed was that actually it was a different unit, SARS, headed by a Mr. Collins, that used this equipment. And the version that Mr. Pillay and Mr. Lochenberg puts up in the High Court is undisputed. So the point is, she didn't follow the investigation to go and check this version to see, well, was this the equipment with Mr. Collins or not? So that's the equipment issue. The second issue deals with recruitment, which is along similar lines. The reasoning being that I wasn't given a policy that shows that you could recruit on a particular basis. This is a policy that would have existed more than 10 years ago. And because I wasn't given this policy, I can't actually ascertain what the whether you were permitted to headhunt or not. And I find that in accordance with that and the evidence in relating to that, he found that there had been non-compliance with the policy. Chair, you will also know that from this, there was the issue of special circumstances as to going back and checking what Mr. Pillai's qualifications were and relying on evidence that emanated from the previous investigation without calling those witnesses or subpoenaing affidavits in respect thereof. Those are the two issues, Chair, and the SARS judgment deals with this quite comprehensively.
Okay. Thank you, Advocate Bauer. That those two issues would conclude this section of the SARS unit. Members, your brief or quick comments and contributions. I see an old hand of Ms. Sukas. Should I note it or it's down? Any further contributions to conclude this part, honorable members? You have no view, indifferent, or you agree with the summation and the summary? I need that on record.
I agree with the summation and summary, Chair. I'm not sure if you can see my hand, but I'm just jetting in.
I can hear your voice. Thank you. Honorable Nkosi, followed by Honorable Mailam, followed by Honorable Hendricks.
Yeah, Honorable Chair,
I'm noting still. I'm noting. Honorable Maneli, Honorable Mananiso, and Honorable Lakode. In that order, Honorable Mailam.
Thank you, Chair. I agree with the summation.
Thank you. Honorable Hendricks.
Honorable Chair, I don't agree because remember I told you earlier on, we have some special experience about grabbers. In fact, the grabber in the city of Joburg, I am a respondent, although I didn't lay the complaint. And when we took over the executive position in Joburg, I wanted to go and check this grabber, but then the person with the key ran away and we couldn't check it out. But now we have found that there is a grabber. So this grabber thing is very complicated, you know, with intelligence and with the spooks. You don't know where you stand. So we don't agree with the position of the evidence leader.
Yes, I hear your fear about grabbers. Don't go closer to them. But thank you, Honorable Hendricks. Honorable Maneli. Honorable Maneli.
No, thank you, Chair. No, I was also rising to agree with summation, and I want to state this, Chair, that necessarily that is a summary of what has been presented before us, as opposed to being a position of the evidence leaders. Because if we allow that to continue, it will be like we are agreeing with the position of evidence leaders, but necessarily it's a representation of the summary of what has come as evidence before this committee at different levels. So I just thought I should raise that point, as I agree that necessarily that's the correct understanding we have. Thank you.
Thank you, Honorable Maneli, for that redirection. Honorable Mananiso.
Thank you, Chairperson. I think one agrees with the summary and as well noting the emphasis of Honorable Maneli. It is very important. Thank you.
Thank you, Honorable Lakode.
Thank you, Honorable Chairperson. I agree with the summation made by the evidence leader as a true reflection of what was presented before this committee. Thank you very much.
Thank you, Honorable Jagude. The last hand will be Honorable Gondwe and followed by Advocate Bauer. Yeah.
Chair, mine is to also say that I agree with the summation, not as a summation that the evident leaders want to put forward, but as a reflection of what actually transpired in the inquiry. And Chair, I think we also have to remember the letter, I think, that was written by Commissioner Kisvita. I think it was 18th February 2021. He had written it to the Office of the Public Protector, indicating that, just reminding them that they're in possession of equipment that form part of the SARS investigation. And then that SARS would be relocating, and they wanted to know what to do with this equipment. And then I recall Advocate Mpofu showing Mr. van Logenberg this letter, and I think trying to infer that Commissioner Kisvita is saying that that equipment belonged to the so-called rogue unit. And Mr. van Logenberg, disagreeing with him, and then Commissioner Kisvita later writing to us to explain that, no, he wasn't trying to say that that equipment belonged to, and you will recall that amongst that equipment, there is what you would call surveillance equipment. Then Commissioner Kisvita clarifying that he wasn't trying to say that that equipment, specifically belonged to the rogue unit. So I think it's important for us to also bear that in mind. But that being said, I do agree with the summation. Thank you very much.
Thank you, Honorable Gondwe. Advocate Bauer?
Yeah, I just want to be very clear. I gave you a very brief summary of snapshots to remind the members essentially of what the subject matter was, the summation that we did, and we acknowledge that we put in quite lengthy documentation to the members precisely because we didn't want to be seen to be representing only one side of an argument. And so our summaries or summation or presentation to you today must be read in context of the summation that we gave you that sets out the evidence in detail. Else we're going to be blamed for only putting one version before the committee today, which is certainly not our intention. The reason why we're raising something with you is to just give you a snapshot to remind you what it's about, on the assumption that all the committee members have indeed got the summations and are familiar with it. And if there's any queries on that particular, that they'll raise it with us.
Okay, thank you. Thank you, Advocate Bauer. Colleagues, before we get to the next, hopefully the last section or sections, you agreed we'll take 30 minutes break and be back at 4:05. Is that in order? Just to do the walkabout, refresh, and fill up?
In order, Chair.
Okay.
In order.
Thank you. We'll resume at 4:05. Thank you.
Recording stopped.
Welcome back, colleagues. I hope everybody is back. Thank you. We now proceed to deal with the last section, and Advocate Bauer or Mayos will just explain to us what's outstanding, what they're going to take us through. And it should not be much longer from now. So thank you for your patience up to so far. Advocate Bauer or Advocate Mayosi, we in your
Chair, where we are, we having connectivity issues. I am connected, but Tsepo and Nazreen are not connected. And it's important for Tsepo to be connected so she can do what she does. If you could give us 2 minutes, please, Chair.
Fine, I'll make it 5. We'll start at 12 past.
Thanks, Chair. Thanks.
Oh.
Okay, we seem to be not connected.
Is Slow Tsepo and Advocate Bauer connected?
Okay, problem solved.
Okay, thank you. Over to you.
Chair, we completed essentially the reliance, if you look at the chart on the SARS unit / done case for the issue relating to the executive members
Recording in
ethics
progress.
code.
Recording stopped. Recording in progress. Recording stopped. Recording in progress.
Okay, Chair. So we had completed the issues relating to the SARS matter, the SARS unit matter, except for the issues to the executive ethics code, which we will deal with simultaneously when we deal with the issue in its entirety under the CR17 matter. So in brief, Chair, if I take you to the summation, just to give you an idea of where we at, Chapter 3, Part 1 deals with essentially the SARS matter in the context of Charge 11, and will show you down the view on the side of the margin the different aspects of it, and I'm going to use that as a sort of a guide of where we're going through. So this is the report, which is essentially titled "A Report on an Investigation into Violation of the Ethics Code through an Improper Relationship to the President and African Global Operations AGO, formerly known as PATA." And the report is signed on the 19th of July 2019. Members share that date in mind because it is relevant for two issues we come to in a bit. The independent panel concluded there was prima facie evidence in respect of the findings that was made on both the grounds of incompetence as well as misconduct. And members will recall that this arose in the context of a donation of 500,000 that was made when and it was represented to Parliament that this was a donation made to the President's son and to his trust fund. And so the complaints lodged, there were two complaints lodged with the Public Protector, one from Mr. Maimane and one from Mr. Shavambo. And the CR17 report identified 3 issues for investigation, which you see in paragraph 11. And it's to those 3 issues that I'm going to turn in broad terms, that the President had deliberately and inadvertently misled Parliament, that he had failed to disclose donations to the CR17 campaign, and the 3rd issue was that he supported the prima facie suspicion of money laundering. And the question then arises whether in the context of the investigation, there was a lack of impartiality and independence in how that was to be conducted. So let's start on the first issue, which is what I'm going to call mere complaint, right? And in order to deal with the mere complaint, it's of the same nature as the complaint made against Mr. Gordon in the SARS unit matter. And the reason I put them together is because there's an overlap in evidence. The question arises as to whether the Public Protector had used the wrong code. The concession was made in oral and for the committee that she accepts that she used the wrong code. The argument for the committee was slightly different. In the context of the Gordon matter first, it took up less than 5 pages of the report. There's no reference in it to either the 2007 code specifically or 2000 code in the report. It simply states in paragraph 5.1.11 of the report what the provision of the Executive Ethics Code is. And the only findings made against Mr. Gordon was that it didn't seem to be a mistake, and that the Public Protector had found it rather impossible in one
just try to reposition yourself. There's just continued break-up. Unlike before, you were very clear throughout the day. It's only starting now. Try and reposition yourself. I don't know why it's breaking up.
I went on my different.
Okay, let's try again. Go ahead.
Right, I should be connected via that connection, which
Okay.
should make it easier now.
That's better.
To do that.
Thank
Right.
you.
Okay, that problem is solved. Okay, so Chair, the findings against Minister Godan was not based on any independent investigation. Mr. Magujani or the staff of Mr. Godan's office was not interviewed. It was based on Mr. Godan saying, I have no recollection of any of the family members of the Gupta family being at this meeting. Mr. Mogajani says he recalls them being there. And then there's a conclusion made that I wouldn't have expected him to have forgotten this. It doesn't seem to be plausible. And then a finding is made that Mr. Godan misled Parliament. That was the essence of the entire case. So if you look at the contrast with the president in respect of the code, the first point is that the code is the wrong code is used, the wrong test is used, and there's then an admission that there is initially not an admission that the wrong test is used. That is then occurs to come up only later. Throughout the report, there are, I think we counted something like 5 versions of the code located in the report at the time. And we then concluded that that there wasn't simply one version. It wasn't just the 2000 code or the 2007 code. And then we know that, Chair, when and this was the reason why we linked the 2 cases together, is because the litigation in the 2 matters ran almost side by side. And what had transpired in the CR17 matter in the High Court, Advocate Mkabani filed an answering affidavit on the 14th of November in which she admitted that the 2000 Executive Ethics Code was the correct code, but that the use of the incorrect code was actually immaterial to her findings because she was basing it on deliberate misleading and not inadvertent misleading. But 2 days later, on 16th of November, in her answering affidavit in the SARS unit matter, she persisted in relying on the incorrect version of the Executive Ethics Code. And that was one of the difficulties one found on that reliance. When argument gets made before the High Court, there is a reliance on the 2007 code in the CR17 matter, but on the application for leave to appeal, there's a concession that is wrong. And the concession says it's wrong. The 2000 code is the correct code. And an explanation is then provided that at that stage of the proceedings, there was a reliance on the ministerial handbook, which was incorrect in doing that. And so one finds that that's the position as it is. And then what transpires is the Constitutional Court judgment gets handed down on the 1st of July 2020. And it then finds that the public protector had used the wrong code. And sorry, Chair, and advice is then received the following day from Mr. Ngubeni, and you see that the advice, if SHEPA goes up, we have previously referred to it as CH3D, Go up. It's linked to the SARS unit section. There we go. 3D. So, oh yeah, sorry, it's at the end of, so at the end of parts 1, 3, and 4 go down. Sorry, Shepherd. All right, I'll continue in doing that. And as a consequence of that advice, click on that. After 3, I'll just click on that one. After 3, right? Go down. See if you can find it. There's a 3D, right? Chair would know from the evidence that we led through Mr. Satauli that the original advices and reliance was placed on an opinion from Mr. Ngubeni, in which reliance was placed on the 2007 Ethics Code. In this opinion, which informed the report, and we had led that evidence before the inquiry. What transpires after the Concord hands down judgment is that there's an application for rescission brought a few weeks later, seeking to rescind the decision because the Constitutional Court had made a patent error in its interpretation of the Executive Ethics Code. And what preceded that, Chair, is this email from Mr. Ngubeni sent to Mr. Satauli's private email address, his work email address, and the Public Protector's private email address, in which he advocates for the bringing of the rescission application, and he sets out the basis upon which such application should be brought, being a patent error being made that the court had relied on the wrong ethics code, and he points to reports that he says Advocate Madunsala had handed down, and the Nkandla judgment, which you will know the Public Protector led extensive evidence on in respect thereof. And Chair, we extensively address in the summation why the reliance on the Nkandla judgment is incorrect, and how it's a misconception of the whole principle of stare decisis, in saying that the judgment is binding because there's a reference in the footnote on it. We deal with that in the summation at length. And we also deal with this issue about whether what's called touchstone decisions form the basis of the decision which was made. The affidavit before this committee and the court was essentially that in the state capture report and in the secure and comfort report, Advocate Madunsala had relied on the 2007 code. We had put before the committee the extracts to show that effectively that is not correct, that Advocate Madunsala in those reports had not relied on the 2007 code. We also point out that it is so that there are reports in the Public Protector's Office that does rely on the incorrect Executive Ethics Code, but it is not the case as was represented, that consistently from 2009 the 2007 code was relied upon. So the reliance on the 2007 code is essentially the first ground, which is a material error of law, and the question of the committee must find whether that's sufficient to show misconduct and incompetence, and in the manner in which that was dealt with during the investigation. Chair, the committee will also know that from the written statement put before the committee, it has been alleged that Advocate Mkabani alleges that the 2007 code had since repealed the 2000 code. And for that reason, there had been reliance put on it, and that Advocate Madunsala had consistently applied the incorrect code. The second aspect is that in the report, the Code of Ethical Conduct and Disclosure of Members' Interests for the National Assembly and Permanent Council Members Act, I think it's you would know it as the parliamentary code was invoked for purposes of this aspect, but it wouldn't have applied because the president was already a member of executive at the time he had made his representations to Parliament. So it's against that background, Chair, the concession is made to the committee that she had not complied with this. The minority and majority decisions of the Constitutional Court was in agreement on this issue. I then move on to the second ground. I'm going to deal with all three grounds, Chair, and then the committee can deal with the CR17 judgment in one go, if that's in order, Chair.
That's in order. Please go ahead.
All right. So the second issue was whether there had been a, what was the second issue? Whether the president had an obligation to make disclosures of the donations and the CR17 campaign. The two things I must point out here is that one of the issues that arise in the CR17 campaign is that in respect of the Shavambu complaint, his complaint was unsubstantiated, as the court found, because his complaint was twofold. Given that the 500,000 had not been paid by AGO to Andile Ramaphosa, which the public protector confirmed, and that the EFG2 account was not a trust or foundation of the son of the President Ramaphosa, the public protector having confirmed that both of that was incorrect, whether as such the president wasn't entitled to a finding that the Shavambu complaint was unsubstantiated. So if you then turn to how this expanded into a CR17 campaign investigation, Chair, the Constitutional Court found that the public protector had no jurisdiction to be investigating the CR17 funds, and that the factual averments which was contained in the president's response to the Section 7(9) notice was not, did not find its way into the report. And in particular, one has regard to what the allegations were in respect of how much money the CR17 campaign had effectively collected and what was told to this committee versus what the president had represented, which didn't find its way into the report. And that was one of the issues that had been raised. So the one was a question of V-Rays. Can the public protector investigate it? The answer was no. The second point is, did the public protector correctly reflect what was being investigated? And thirdly, if not, did the public protector show that there was a, and the reason for it not being eligible for investigation was because the political party's internal affairs did not constitute state affairs. And hence the public protector had no jurisdiction under either the EMIA, the Act, or the Constitution to so investigate party affairs. The third aspect of it was that the president was not given audi in respect of a number of those issues. And the motivation that the public protector gave for wanting to investigate this issue, Chair, was premised on what the public protector said was the emails I received and the dinners and the public protector's evidence himself. Now, if I just in 2 sentences deal with the emails was a few emails, Chair, that was shown to this committee, and we deal with it quite extensively. It was suggested to this committee that there were numerous emails that had been sealed, and we explain in the summation why that could not have been so, given that the emails had been discovered, and the only emails that was discovered constituted 7 pages, which made its way into the Rule 53 record. The sealing had only happened in respect of the private bank accounts and the information that were obtained through the Financial Intelligence Center. Much later, after the Rule 53, not much later, but after the Rule 53 process had been completed. And we take you through how that comes about from roughly 205 of the documents. And so the question is, does the emails reflect that the president was constantly involved in the process and kept up to date with it? The Constitutional Court found that was not the case, because it was no indication of such being so with the 3 or 4 emails that had come out. Chair, you were also referred to newspaper articles and some of the investigations that the journalists had conducted to verify the information on the emails was not conducted by Advocate Mkabani, and appears to, on the face of it, not confirm what's on the emails to the extent that it was taken as to that effect. Advocate Mkabani takes the view in the litigation that the president is not open and transparent. He doesn't share with the court the ambit of the emails. The president takes the view that Advocate Mkabani, who tells the court that she got these emails via an anonymous source who dropped a hard copy at the offices, and hence they couldn't trace it because there was no metadata. And so the president refuses to respond to what he regards to be illegal emails in contravention of the Regulation of Interception and Communication Act. And Advocate Mkabani takes the point that the president raises technical defenses because he's refusing to be open and transparent with the court as to what the emails has to say. The court effectively concludes that that the emails don't make out the case that the public protector seeks to make out in respect of that. And we detail in the summation some of the investigations. We accept that it's newspaper articles and that we're not relying on it for the truth of the allegations, but we're pointing out that had the public protector conducted an investigation into this, the information might well have come out through the public protector rather than the media outlet. The second issue is the question of the dinners. Chair, there's the evidence that the public protector puts in the report is effectively that there was at least one dinner that Mr. Watson was at that the president attended. Mr. Watson goes under affidavit and effectively says that the dinner he attended was a fundraising dinner of a different nature, and that he had not gone into any CR17 fundraiser dinners, and you see that at paragraph 231. So although the submissions from Mr. Watson is repeated, it's sort of a cut and paste of the whole affidavit into the report, notwithstanding what Mr. Watson said. The detail in the report says that Mr. Watson attended one dinner with the president. The dinner that he says he attended was a different dinner. If you go further up, just go up to paragraph 230. The dinner he attended was in 2016 or 2017, which was a back to school dinner, which he then confirms in his response is the dinner that he had attended to. So those were the two bases, and then the third basis was whether what the president had effectively said, and the court came to the conclusion that there was undisputed evidence before the High Court which contradicted the public protector. The third ground related to this issue of money laundering, and on Friday we pointed out to the committee that the public protector's position in respect of the Vrede matter was that money laundering did not fall under her jurisdiction and she could not investigate money laundering. In the CR17 campaign matter, the position is adopted that if I find something wrong, I was compelled to investigate it. Chair, you will know that although Mr. Mayamani makes a reference to money laundering in his complaint, there is no reference to the CR17 campaign in either complaint. The reference to money laundering stems from the fact that the payment was made from Mr. Watson via the an account called Miyoto Trading, and then into the CR17 bank account of EFG2. And the important part to note about this is that the court says, and in the founding papers of the High Court application, the elements of the charge of money laundering is set out and effectively confirms that you've erred in your definition of money laundering, because money laundering is not bank accounts. You put the money into. It's about the source of the funding. So you could have had 10 intermediary accounts and it wouldn't necessarily constitute to give rise to prima facie finding of money laundering. In contrast, what the public protector does is she refers to the PRECA Act, the PRECA Act being the Prevention and the Combating of Corruption Activities Act throughout, and there are numerous references in a report, as opposed to the Prevention of Organized Crime Act, the latter being the one that deals with money laundering. And effectively, the court then concludes that not only is there a material error of law, nor is it an innocent reference to the incorrect act, because it's the report is replete with representations or references to that act. And so the question then comes from, was it a deliberate effort to try and make this finding and an act in which she had jurisdiction to make a conclusion against the president? And that would be a difference as to whether it's where the court would make a finding. So, Chair, in essence, those were the three things. And then it came to the question of remedy. There were certain remedies issued, Chair, and those remedies related to interference with the prosecutorial independence and interference with the speaker in the way the remedy was crafted, and both the fact that there was not only was the remedy crafted in a manner that made it binding on the on the prosecutor, the National Director of Public Prosecutions, to take steps, but it would have been under the aegis of the public protector that was done. And in respect of the speaker, it set out precisely what the remedy the speaker was supposed to undertake, and that was regarded as an infringement of the powers of the speaker. Chair, this is not a case in respect of which a personal cost order was made against the public protector. Instead, a punitive cost order was made against the office of the public protector in this regard. So this was not a case as which the committee was told was an instance of double jeopardy, not that double jeopardy applies in doing that. The litigation cost, inclusive of legal opinions obtained, approximated to something like 6.5 million rand in this matter, and both in its appeal to the Constitutional Court and in the rescission application in totality, that was granted. Chair, just give me a minute to see if I've missed anything in summation. Yeah, so the one point that the courts noted, Chair, was that the President's response to Section 7I notice as to the movement of donations was completely ignored. Advocate Mkabi made a finding that because funds was transferred to the Cyril Ramaphosa Trust, him and his family had personally benefited without actually ascertaining who the beneficiaries to this trust was, and it wasn't them, and they were not ultimately in control of the day-to-day running of the trust. And there's an explanation in the 7I notice as to how it comes about that funds are transferred to the Cyril Ramaphosa Trust In other words, there was a failure to investigate and a failure to consider the evidence provided in the Section 7I notice. I think that covers the gist of it, Chair. The members would be aware that we've extensively set out the evidence in Chapter 3, Part 1 of the summations that has been made, which deals with these aspects in more detail and also sets out what the Advocate Mkabani's evidence was in respect of each of them. Thank you, Chair.
Thank you, Advocate Bauer. Colleagues, that's the last presentation on those matters. I'm inviting you to respond to what has been presented, the summation, and everything else that you know, as well as responding to those 3 questions, which relate to issues of impartiality, independence, and the nature of the investigation itself, and the conduct of the PP. May I invite you to make contributions? If you are still here.
We are, Chair.
Okay. Is that a hand, Honorable Ngozi? Honorable Milam? Honorable Moda?
Okay.
Honorable Gondwe? Honorable Maneli? In that order, thank you. Honorable Milam?
Chairperson, I'm less concerned about the actual investigation itself and more concerned about the report. And
sorry, Chair, I raised my hand. I don't know if you can see it from my gadget. I think it's after Gondwe.
Okay, thank you. Thank you.
So
I see it now. Thank you. Sorry, Honorable Milam.
No problem, Chairperson.
Go ahead.
Thank you. So I'm less concerned with the conduct during the investigation and more the report and remedial actions that were recommended. And in particular, I think that the position of the public protector with regard to the EMEA matter, both in CR17 and in SARS Rogue Unit, as well as the Precker finding and her finding that there was prima facie evidence of money laundering notwithstanding, her reliance on Precker and her remedial action in referring that to, in fact, not referring it, in ordering the National Prosecuting Authority to take the matter further. I find those both to be bad in law and an overreach by the public protector. And as such, it goes again to her incompetence in performing her job. So I believe that she is incompetent in that regard. I don't want to talk to the actual investigation itself. It's rather focused on the report and the remedial actions. Thank you, Chair.
Thank you, Honorable Milam. Honorable Ngola.
Thank you very much, Chair. Chair, it's a big no in all. The fact that there's been a serious misapplicability of law, the difference between POCA and PRECA, the application of wrong laws, suggest that it's a no in all the three. The use of a wrong executive ethics code, and beyond that, tampering and impeding into the independence of the prosecuting authority was beyond reproach. So it's a no, Chair. Thank you.
Thank you, Honorable Nwala. Honorable Gondwe.
Chair, I agree with previous speakers. She relied on the wrong code, on the wrong legislation, and honestly speaking, that doesn't bode well for someone in her position and for the Office of the Public Protector. We would think that they would be able to rely on the correct legislation. But that having been said, Chair, I'm not sure if any of the members have raised this earlier today, but the involvement of Mr. Ngobeni has once again, reared its ugly head in this particular investigation. And Chair, I also think that we shouldn't take his involvement lightly, and the role that Sianaho attorneys played in roping him in to the business of the Office of the Public Protector. And I'm not entirely sure how we should ensure that that matter is also investigated and looked into, because, Chair, it cannot be right, it must not be right that someone who's not authorized to practice law in the country is able to give advice, provide advice on such, sensitive and high-profile investigations at an institution such as the Office of the Public Protector. So through you, Chair, it's just a plea that that matter also needs to be looked at into, and also the role that Sianaho attorneys played in procuring his services. I don't know whether that matter then needs to be channeled through the Legal Practice Council or how we're going to handle it, but his constant, how could you say, the role that he continued to play in some of these investigations, insofar as the advice and the opinions that he used to provide is worrisome. And more so because, as I indicated earlier, some of these investigations are high profile and sensitive. I mean, this investigation involved the president of the country, and you wouldn't want to think that someone who's not not allowed to practice in the country and is a fugitive from justice is actually providing opinions on what is possibly the fate of the head of state of this country. So Chair, please, if you can note that down, that is another matter that needs to be investigated. But like my previous colleagues, I agree. There was material errors of law. She relied on the wrong legislation, as Honorable Ngola pointed out. She relied on the PRECA Act and not the POCA Act, and she also relied on the wrong code. Thank you very much.
Thank you, Honorable Gondwe. Honorable Maneli.
Thank you, Chair. I think the points have now been covered to justify the no's on those questions. And that I think the points made in relation to law also with regard to the issue of personal benefit in this regard without any basis. I think it's safe to say, Chair, that once again, the issue of the independent panel gets to be substantiated in this regard. Thank you.
Thank you, Honorable Maneli, Honorable Nkosi.
No, thanks, Chair. I'm covered. I just want to emphasize what Honorable Gondwe has indicated around a specific. We need on the basis of what has been presented on the role of external people impairing the impartiality and independence of the public protector to express a view, and I agree with her that and we need a specific recommendation on that, particularly him as a non-practicing attorney or advocate.
Thank you. Thank you, Honorable Nkosi. Honorable Lagude.
Thank you, Honorable Chairperson. Let me say that I echo the same sentiments as my colleagues, and also to bring this to the attention of the committee, that the PP, notwithstanding these glaring errors, litigating the matter up to the Constitutional Court, and further lodged a rescission application, only for her to admit to the committee after state resources were wasted when she knew she had erred. This, we believe, is not a genuine admission. Had she considered this in the review application when the President pointed it out, the wasteful expenditure in legal fees could have been avoided. So I'm adding this for the committee's consideration with regard to her using the wrong act, and also for continuing with litigation, even though she knew that she made a mistake. Had she had avoided that, state resources wouldn't have been wasted. Thank you very much, Honorable Chair.
Thank you, Honorable Lagude. Honorable Suela.
Thanks, Chairperson. Let me join my colleagues. Chairperson, I think here we're dealing with a matter which affects the head of state. It needs to be considered. We all know that there is no one who is above law, but it is good for our leaders who have been given a responsibility to act according to law. The issue of employing people who do not have relevant qualifications is highly questionable, Chairperson. So I agree with my colleagues that in our recommendations, we must also indicate that this matter needs to be investigated, because we're trying to correct the situation in future, and also to learn lessons that given a responsibility, you need to be yourself and you need to play the ball, not the man. Here, when we check the issue of a reviewal to courts, etc., it leaves us with questions, because once an outcome has been given on a particular matter, one will have to think twice before you continue with those litigations. Hence, the PP failed to avoid issues of waste of resources. And to me, the use of wrong legislation also is also questionable from her side. So I'm really in support with those other members who are saying that we need also to make a special recommendation that it be investigated why external people who are not evenly competent or relevant to that particular job were given powers to execute such execution. That's my submission, Chairperson. Thank you.
Thank you, Honorable Swela. Is there any other member? Is there any dissenting view? Honorable Dana?
Thank you, Chair. No, Chair, I think I was largely covered, but I do think that mention should be made of fruitless and wasteful expenditure of public resources with unnecessary court battles where wrong legislation was being used in investigation. So I would support that we make mention of that. Thank you, Chair.
Thank you, Honorable Dana. Maybe as we then summarize it so that on those three questions, I'm with you. You are saying in 130.1 that the suspended public protector did not conduct investigation in a manner that ensured impartial conduct of the investigation. Is that agreed?
Agreed.
Agreed, Chair.
2, you are saying did Advocate Mkhwebane conduct investigation in a manner that ensured independent? You're saying the investigation did not show that there was independence in the investigation. Is that agreed?
Agreed. Correct.
3, did Advocate Mkhwebane make her decisions in a manner that ensured the impartial conduct of the investigation? Is that so?
No.
You say
Said
no?
no, Chair.
No, Chair.
No.
Great. Thank you. And if you look at all of those three questions, would you then say she would have then committed misconduct and incompetence?
Yes, Chair.
Honorable Gondwe?
Yes, Chair. Agreed.
Agreed.
In all of it, okay.
Yes.
Any other member?
No, Chair, it's misconduct and or incompetence because the two are intertwined on this aspect. Thank you.
Okay.
Chair,
Thank you.
is misconduct and incompetence.
Thank you. All right.
Misconduct and incompetence. Agreed, Chair.
Thank you. Now,
Misconduct accompanied by incompetence.
Okay. Now that you have done this exercise, we'll just, as we summarize, try and do it in the others. Can we do the others, Advocate Bauer and Tsepo?
Sorry, Chair, I'm lost with you. Are you asking us to go on to the two other cases that is referred to in the section? The James case and the subpoena case.
You still have that to do.
Yeah, but that's quick, Chair.
No, please go ahead.
Okay. So if you see on as part of the motion, there are two further cases that are referred to, which we deal with in parts 3 and parts 4. They are referred to in chapter 3, part 3 of it. And this is the case you will recall during the evidence was, I'm first going to part 3, Shepo, where there was an agreement between the public protector and SARS in getting an opinion as to whether the public protector can issue a subpoena for private information. The High Court found against her, and the High Court found against her because on the merits, but then also made a personal cost order against her because there was a deal entered into between the Public Protector's Office and SARS that effectively said they would jointly obtain this opinion. SARS would pay for it because the Public Protector's Office was suffering from financial difficulties. They set out the instructions, the officials picked the advocate, and when the opinion came from the chosen advocates, the opinion was rejected, and the High Court said that that was, and Advocate Mkawi then went out and got another opinion, and she instructed the office to get an opinion from a counsel which will contradict that opinion. And we deal with that in the evidence. And this evidence of what we obtained from the emails of the instructions is not before the courts. The matter then goes on, application for leave to appeal to the Constitutional Court. The Constitutional Court then finds that on the merits, the original opinion obtained from SARS was correct. So on the merits, the public protector can't issue subpoenas for private tax people's information. But on the question of costs, there's a judgment of Justice Madlanga, which was referred to at length during the argument, where he sets aside the personal cost orders against the public protector, and he cautions courts not to be as, not to hand down cost orders as easily as personal cost orders as it seemed to have occurred in that case. And that was used as a stepping stone to saying, well, by not giving a personal cost order against the public protector, she cannot be found guilty of misconduct. And the independent panel report then agreed that they were not going to make a finding that there was a prima facie finding of misconduct against her, on the basis that the court said she was entitled to seek another opinion. And we set out in the summation those aspects of it. The only issue that we raise in addition to that, or one of the issues we raise in addition to that, is that in paragraph 402, during the period in which SARS is told that the Public Protector's Office doesn't have funds to solicit it, to get its own opinion, they are effectively paying Mr. Ngubeni sums of money to do other work, and we detail that in paragraph 402 and 403. Whether the submission was then correctly made to the courts and to SARS that effectively we couldn't have funding to do what was core business of the Public Protector's Office. So, Chair, can I just take you quickly into GEMS, and then the committee can deal with both together or separately? Up to you, Chair.
Oh, go ahead.
Okay, so this is a complainant in a dispute relating to the government employees medical scheme, and we set out in the summation the facts that give rise to it and the findings of the Constitutional Court, and the court finding that the approach was regrettable, that they hadn't complied with constitutional values of professional ethics, accountability, transparency, etc. And the independent panel found that there was prima facie evidence of incompetence and prima facie evidence of misconduct. There is one difference that does come up when we didn't hear evidence on this, Chair, and we didn't have anything that came directly from the witnesses in respect of GEMS. But we do want to point out that what makes GEMS a slightly different case to the other cases, if you see in paragraph 416, Advocate Mkawi doesn't deal with this investigation and judgment either to the independent panel or in anything before the committee. And I think we can't take issue with it because we didn't put up any information in respect of GEMS. So that's the first thing. There wasn't anything for her directly to respond to besides the judgment. And although she signed the subpoenas in the matter, which she would ordinarily do, she didn't depose to the affidavits in the litigation, nor did she play, nor is an explanation of her role in the investigation or any direct instruction given or direct involvement in respect of the early stages of the investigation. There is a delegation given by her to another investigator to act on her behalf. And so we were not able to secure the cooperation of the investigator who is no longer in the employ of the people, say, and he did speak to us, but was not amenable to providing information on the record. And so we did not put what in our view would have been complete evidence before the inquiry. Thank you, Chair.
Thank you, Advocate Bauer. Is that it? You don't have any other after this to present?
Chair, Advocate Mayosi needs to deal with you on two aspects dealing with Ngubeni and the appointment of Mr. Niembi.
Okay.
If you just want to deal with subpoena matters and gems, and then Advocate Mayosi can just deal with those two aspects in the context of charge 11.3, which would then complete it, Chair.
All right, thank you. Let's then, honorable members, respond to these two that have been presented here now, gems and etc. Let's just go back to the questions, Tsepo, as I invite members.
Chair, there's no specific questions on gems, but it's the same questions that was asked in respect of the impartiality and independence insofar as applicable to the CR17 matter.
No problem then. Thank you. Honorable members, your responses? You're almost there. You can't get tired now. Do I have any hands? Honorable Maneli.
Thank you, Chair. I think on the latter matter of gems, I think matters that have not been canvassed and evidence led in the committee. I still want to suggest, Chair, that it's difficult for us to express a specific view on the matter.
Yeah.
Except to note, of course, Chair, that yes, it may have been a matter that would have been looked at by an independent panel if it has been through the independent panel and made a finding. But from a committee point of view, because this we have not tested, I want to submit that we do not express a view on the Chair.
Thank you. Maneli, suggestion that we have no view to express. Honorable Klape.
Thank you, Chair. Chair, I support Honorable Maneli on this one. And the evidence leader, she's indicating that there are no questions on this. But safe to note, Chair, on her introductory part on that court judgment, where they pick issues of incompetency and everything. I'm just finding a golden thread, Chair, on all the investigations that has been done, as alluded by my colleagues, as and when they were deliberating, that whether it's intentional or it's issues of incompetency, you find that golden thread of not being really, I don't know if you rushed into taking decisions or it was intentional decisions has been taken or what could have been the issue, but it borders allowing issues of incompetency and really wanting to reach such conclusions. So even if we don't have anything on this one, Chair, I would say the golden thread remains throughout all these investigations. Thanks.
Thank you, Honorable Klape, for that consistent golden thread of incompetency. Thank you. Any other member? Is there any dissenting view?
No.
Okay, thank you. Summary that we express no particular view on those issues that will not have come to the committee, but we also, I think, note, as Honorable Clapper makes the point, that there are consistent patterns and issues standing out throughout this, as you would have mentioned. Let's proceed, therefore, from that, colleagues, and get to invite Advocate Mayosi and Advocate Bauer for the next deliveries.
Yeah. Got it. I've got it. Thank you, Chair. Can you hear me?
Yes, I can hear you, Advocate Mayosi.
Yes. Chair, issues relating to the appointment of Mr. Nyembe, first as a special advisor, and then thereafter as the chief of staff, and the appointment of other services of Ms. Kimhela, Professor Siepe, and Mr. Ngobeni, impact on the determination of charge 11.3, issues of impartiality, independence, and so on in the conduct of an investigation. And here the impact on the Friede investigations, as well as the SARS unit investigation and litigation. So Mr. Niels van der Merwe was asked to give evidence on the dates of appointment of Mr. Nyembe. And it seems from the evidence that was presented by him that Mr. Nyembe's appointment dates, discussions around it occurred the year before, in 2018, early 2018. So on the 8th of February, Mr. Nyembe, as a director, a sole director of an entity called Lawyers for Radical Economic Transformation, followed up on discussions he had with Advocate Mkhwebane in relation to his appointment. He set out in that letter of the 8th of February what Lawyers for Radical Economic Transformation would offer, the services that would be offered. He was then appointed on the 15th of February, 2018, rather more accurately, on the 15th of February 2018, Advocate Mkhwebane wrote him a letter and confirmed his appointment as a special advisor with effect from the 1st of April 2018 for a 3-month period until the end of June 2018. What then occurred on the day before Advocate Mkhwebane's letter of the 15th of February, on the 14th of February, she approved a policy on the appointment of special advisors to executive authority. So this was approved on the 14th of February, 2018. Mr. Nyembe then assumed his position as special advisor on the 1st of April. In March 2018, Advocate Mkhwebane addressed a letter to the Minister of Finance, who at the time I think was Mr. Nhlanhla Nene, because in terms of the Act, Section 3 of the Public Protector Act, she was required to have consulted with the Minister of Finance prior to the passing of the policy for the appointment of special advisors. So she addressed a letter on the 22nd of March to the minister. The minister responded to her in early June 2018, and the minister said to her that it appeared that she had already adopted the policy that she was seeking to consult him on, and he proposed that the policy be retracted so that consultation could occur. There was also an additional requirement that the policy had to be presented to the National Assembly 14 days after the Public Protector had adopted the policy, having consulted with the Minister of Finance. But earlier in May, an internal advice had been obtained, legal advice from Mr. Nemasisi, who was the legal manager at the time, relating to, amongst other things, the legality of the appointment of Mr. Nyembe. Mr. Nemasisi's advice was that due to the fact that consultation had not occurred with the Minister of Finance prior to the adoption of the policy, prior to the appointment of Mr. Nyembe, the policy was invalid. Mr. Nyembe's appointment should be terminated. The matter ultimately went to the Portfolio Committee in June, was considered by the Portfolio Committee, and the Portfolio Committee also expressed concerns around the appointment of a special advisor. It expressed concerns around the approval of the policy, but it also noted that the term of Mr. Nyembe was about to come to an end. What then occurred is that his term as special advisor came to an end at the end of June. Mr. Kelela testified that he then left the organization. After that, the position of Chief of Staff was advertised. He applied, he was interviewed, and he was then appointed as Chief of Staff with effect from the 1st of January, I think January 2019. And that appointment was to was for a fixed term contract of employment, which was linked to the term of office of the public protector. So in other words, that appointment would start from the 1st of January 2019 for a fixed term until October this year. As we know from the evidence that's been led, Mr. Nyembe passed away, I think sometime in 2020. So the various roles that Mr. Nyembe then played in his position as Chief of Staff were testified to by Mr. Muntu Sitole, as well as to some extent by Mr. Van der Merwe. He played a role in, for instance, the SARS subpoena matter, where he was copied in on correspondence by Advocate Mkhwebane. For instance, the correspondence where she rejected the advices of the opinion of Advocate Maneji, and she instructed that another counsel be sought to contradict their opinion. Mr. Nyembe was party to that correspondence. He was also involved in the SARS unit matter. He would advise, he would be copied in on a correspondence. For instance, as members will be aware, in April, on the 23rd of April 2019, Advocate Mkhwebane issued a media statement where she granted Mr. Godan an extension that he had sought for submitting his affidavit in response to a subpoena. She also, in that media statement, alluded to some kind of collusion between the implicated parties, Mr. Godan and SARS, in framing a response to her. What she then did was the following day, Mr. Matabuche, on the 24th of April, drafted a response that was to be sent to the attorneys of Mr. Godan. Mr. Nyembe contributed to that response. And that appears on paragraph 477, Mr. Nyembe's proposal to that response is reflected in paragraph 477. The second sentence of that proposed response, he says, "We warn the attorneys and their principals to desist from conducting themselves this way against a constitutional institution as our office." 478 is also a continuation of Mr. Nyembe's proposed response, where he says that the public protector wishes to draw PG being Minister Godan's attention to the fact that despite having directed that a postponement could only be had via personal appearance before her at the PP's office, they violated the subpoena as they didn't present themselves. And he says in the last sentence, I guess the point the PP wants to bring to PG's attention is that concretely, he has already shown signs of being unruly. So this proposed response was in April 2019, during the time that the SARS unit matter was being investigated. Members will be aware that the report only came out, I think, on the 5th of July, 2019. The sentiments that are reflected in this proposed response of Mr. Nyembe's, members will be aware, reflect those shared by Advocate Mkhwebane, in the sense that she described in her court papers what she perceived as hostility in the attitude of Mr. Godan and his attorneys. So Mr. Muntu Sithole then testified that the appointment of Mr. Ngobeni to offer the services that he ultimately did came at the recommendation of Mr. Nyembe. Mr. Nyembe, the evidence was a big admirer of Mr. Ngobeni's intellectual prowess, and so it is he who then recommended that he be appointed to perform various services for the organization. And the services that he performed really ranged from, according to the evidence of both Mr. van der Merwe and Mr. Sithole, drafting opinions, research, drafting media articles, and so on, in relation to the various matters. And perhaps those services are best described in, go to paragraph 521, Tsepo, in an invoice that Mr. Ngobeni submitted to CNEHO. The mechanism for him to invoice the organization was that he would not invoice the PPSA directly, but rather his invoices would be sent via CNEHO. So his services and his attendances would be reflected on a CNEHO invoice. Yeah. So the services then that are stated there are a good reflection of what he provided at that time. And I'll just really focus on the ones that are underlined in the period from May 2019, June 2019, the dates reflected there. He received papers in the CASEC DA Friede judgment and provisional and final reports, final notice of appeal, all DA CASEC papers researched and drafted preliminary argument on the 6th to the 10th of June. He received and researched direct access, leave to appeal, amended the notice of motion and supplementary affidavit and amended notice of motion. Members will see that on the 11th and 12th June 2019, he drafted a legal opinion on the controversy on the PP's social media section 79 notices. Just to take you back, the context of that was on the 3rd of June, Advocate Mkhwebane did the YouTube appearance where she announced her intention to deliver a section 79 notice to Minister Godan in the context of the so-called rogue unit investigation. And that advice there on the 11th and 12th of June appears to be an opinion in relation to that. And as we know, his advice was that there was nothing wrong with these matters being done in the manner that the PP was doing, because it was important to counter the narrative that was out there at the time. If you go down, Tsepo, on page 146, just for members to note the services that Mr. Ngobeni was rendering at that time. On the 19th of June 2019, correspondence on Judge Tolmay's proposal for stay until Concord decides costs. That was in the context, I think, of the Friede matter, and then further research and so on. But Mr. Ngobeni was not the only service provider whose services were used by the organization at the time. On the 18th of February, go down, Tsepo, paragraph 529. Oh, just wait, Tsepo. Go back up. Just before we, that's right. Just before we leave this invoice, members, I omitted to bring your attention to the attendance of the 19th to the 20th of July 2019, where he says, Mr. Ngobeni's invoice, PP report on President Ramaphosa and researched legal challenges, CR raised, jurisdictional and factual issues. Members may recall that in her affidavits in the High Court, Ms. Fasani Baloy mentioned that in the SARS unit and CR17 investigations, external consultants were used. That entry there would seem to corroborate the involvement of Mr. Ngobeni, at least in the CR17 matter at that time. Going down to paragraph 530. So Mr. Ngobeni then wasn't the only service provider. On the 18th of February 2019, Ms. Kim Heller of Kim Consultancy addressed an email to the personal assistant of Advocate Mkhwebane requesting a meeting that ultimately then resulted in her sending a proposal of the services that she and Professor Siepe were going to offer to the organization. And if you go down, Tsepo, just for a snippet of what those services would be, on page 150, just go down, page 150, where a portion of the proposal is reflected. The services that they were going to offer were strategic communication services to counter the total and unwarranted onslaught by media. Further details of their communication posture and program were provided in that proposal. Go down, Sepa, and look at the part that's underlined. They recommended that the office must not be seen to be preoccupied by the onslaught. Rather, it must use this time of heightened publicity to showcase those interventions that benefit the most disadvantaged and the voiceless majority. Put differently, there's a need to defocus the obsession with complaints involving Pravin by talking about the impact the office has had on ordinary people. It's about putting out there what the media will not cover. Over this period, we will write and publish a series of articles and social media communications which correct misperceptions, as well as offer a convincing portraiture of the good works of the office. If you go further down, the key thought pieces are reflected there, and those key thought pieces will focus, amongst other things, on judicial prejudice, to the lynch mob mentality of the media, judiciary and civil society, and the deliberate unsteadying of the PP, unpacking the Pravin Gordhan saga, the undone matter of the rogue unit and CIX, profiling the People's Public Protector. So in essence, the services were described there, and the costs for these strategic communication services for the period was reflected there. So in response to this proposal, if you go to, members will see at paragraph 542, that in response to Ms. Heller's proposal, Advocate Mkhwebane addressed that email to Mr. Nyembe, who was the Chief of Staff, and she says, Chief of Staff, this should include Advocate Ngobeni, and she requested a cost breakdown so that, she continued, so that all can be accommodated. Ask Theo, that would be Mr. Theo Serejo, to advise. Cost per article, per interview arranged, etc. That answer, paragraph 551. So the evidence leaders wrote to Professor Siepe and Ms. Heller, who responded in various ways in describing the services that they rendered. Their response is part of their response, I must say, is captured there. For reasons that have nothing to do with incompetence, that proposal was not concluded. Subsequently, in mid-2019, and for a period of 3 months, strategic communication services were provided on an ad hoc basis, a part-time basis, to Advocate Paul Ngobeni, who was assisting CNEHO attorneys on matters of legal services and opinions. No services were provided beyond the 3-month period. The invoices to support services rendered were duly submitted through Wekunene Business Services, registered in 2016. In their letter, they further stated, they confirmed that we provided our services. It was confirmed that we provided our services this time to Mr. Paul Ngobeni, who was contracted by the Office of the Public Protector. We had no direct working relationship with CNEHO or CNEHO Attorneys Incorporated, except for the email communication recording regarding meetings, amongst others. We were engaged by Mr. Ngobeni. So that is part of their response to the evidence leaders in the description of their services and the nature of their appointment. So as members will have seen, then Mr. Ngobeni performed a range of services. He also advised on the USA petition for the removal of Advocate Mkhwebane. I think Business Unity South Africa addressed a letter to the Speaker seeking the removal of Advocate Mkhwebane. Mr. Ngobeni advised on that issue. He drafted a response which he forwarded to Advocate Mkhwebane. However, the evidence of Mr. Van der Merwe, in his evidence, he was not certain whether that draft response was ever sent. But we've captured the snippets of what of the draft response that Mr. Ngobeni prepared. So Ms. Heller then reported on the services that they provided. It go to paragraph 567, Tsepo. She sent an email in June 2019 to Advocate Mkhwebane, amongst others, Professor Siepe, Mr. Nyembe, which reflected a report that was to be tabled for discussion at a meeting that they were going to hold. In the last paragraph of the report, it stated that our work has been orientated around high impact initiatives and interventions that influence and shape desired outcomes. We have sought and secured prime space and audience on radio and television and in newspapers. We have also pursued and delivered a high presence social media campaign. Our media interventions have been coupled with advisory notes to the office and briefing of key influences behind the scenes. We believe we've managed to cause some disruption of the master narrative and succeeded in spearheading multiple calls by others for attacks on the public protector, for, I think, attacks on the public protector to seize. So in essence, the report described their interventions during the period that they had been performing the services, and they proposed their next steps. We're looking into the feasibility of public televised colloquium on the deliberate manufacture of discontent and partisan eyes wide shut approach of media to the truth by advocating decisive legal action against those who trade in propaganda. Without evidence and harm, the reputation and standing of the public protector is recommended. In May, I think Advocate Bauer may have alluded to this earlier when she addressed the committee in May 2019, after the judgment of Tolme J in the Frede Dairy matter. Mr. Ngobeni had authored an article entitled "Mobilizing the Judiciary for Political Attacks on the Public Protector. Can Justice Be Done Amid Efforts to Intimidate and Remove Our Public Protector?" So in the article, it contained criticisms against Judge Tolme, which included, but are not limited to what is listed in paragraph 574.1, that is a wide paragon of judicial virtue. She's committed a plethora of legal errors in her judgment. It continued that her judgment was biased. She's no stranger to utilizing court judgments to advance populist causes untethered to the Constitution and the rule of law. After he drafted the article, Mr. Ngobeni then presented the article, the draft, to Advocate Mkhwebane on the 23rd of May, and she responded that the article is good and it could be published. So what the evidence showed of Mr. Van der Merwe was that Advocate Advocate Mkhwebane expressed a desire for Mr. Ngobeni to be appointed on more than one occasion, as will be seen in paragraph 581, Tsepo, where in the Mostert application, she said, please contact Ngobeni SC to check his availability, and in the DA and CASAC matter, she requested the papers, which she then sent to Advocate Ngobeni, as she called him, and she asked him if he could assist the senior junior to prepare papers for the appeal. Advocate Ngobeni also responded to a number of questions that were sent to him by the evidence leaders. Some of his responses are reflected in paragraph 582 and its sub-paragraphs. Notably, he denied that he referred to himself as an advocate in his invoices. He's neither an admitted advocate nor an admitted attorney. He submitted that he's eligible to practice law in South Africa by virtue of a ministerial exemption in terms of the Recognition of Foreign Legal Qualifications and Practice Act. And the remainder of some of the salient features of his response are reflected there. He also stated that he, Ms. Hela and Professor Asiepe had an agreement with CNEGO attorneys. He denied that he'd ever received payment on behalf of Ms. Hela at any time in respect of services provided by her directly or indirectly to the public protector. Chair, just on this issue of impartiality in general in investigations, we also touch upon the issue, I think, that was raised in Mr. Samuel's testimony about Advocate Mkhwebane having socialized with Mr. Zwane, who was the MEC that had primary responsibility at the time for the Fruitless project. He was one of the politicians against whom the PPSA made findings in the Fruitless 2 report. We bring this matter, Chair, because it is, as we state, also an issue that this committee needs to consider insofar as Advocate Mkhwebane's ability to conduct or display impartiality or independence in the conduct of her investigations. Her evidence to the committee was that she hadn't invited Mr. Zwane to the 50th birthday, that he had come there with an invited guest and she could not turn him away. There's no other evidence before this committee that is available. The committee will have to consider the sufficiency of that explanation. So Chair, can I take a minute, Chair, just to look at my notes before I conclude? Right. So, Chair, all of these appointments and these services that were being rendered in relation to the media interventions and the services of the strategic communication services, the publication of the articles, all of these matters were occurring at the time when the Fruitless litigation was underway. They were occurring at the time when the SARS unit matter was being investigated. And as we say, we raise this as an issue on which the committee ought to deliberate when it decides on the impartiality and independence of Advocate Mkhwebane, as is raised in 11.3 of the charges. Chair, I must also point out that we don't have evidence of all the payments for all the invoices that are related to Mr. Ngobeni. Some of them were paid by CNEGO. Mr. Ngobeni said in the Godan matter, he was paid by counsel. So in essence, Chair, we don't want to create the impression that we had an entire paper trail of evidence in relation to all of the invoices, and some he indicated he never received payment for the services that he rendered. Thank you, Chair.
Thank you, Advocate Mayosi. I see that whispering has improved. Thank you. That was a comprehensive presentation on those last issues, starting with Mr. Nyembe. Members, may I invite you to comment on these as we go towards the end. Honorable Mailam. Honorable Mailam, Honorable Klapper, is that an old hand or new hand?
That's old, Chair, thanks.
Okay, Honorable Bonde. In that order.
Thank you, Chairperson. Chairperson, I think that the way that the evidence leaders have laid the summation out joins a lot of dots for us, and it creates a clear picture of a pattern of behavior on the part of the public protector. And that pattern of behavior, as I see it, as having been laid out by the summation, is the appointment of Sianejo to act as a front for various persons and companies to provide a propaganda machinery for the public protector. So it's quite ironic that Mr. Ngobeni and Ms. Heller say that they need to counter the propaganda of the other forces. I don't know quite where that sits or who that might be, but when the public protector, is utilizing their services to do exactly that. That's the first point. The second is that if we go back to Mr. Nyembe, he tweeted, and you will recall that there was quite a bit of controversy when that tweet was flighted, that one of his functions at the Office of the Public Protector was to jerk up the office politically and legally, and to provide socio-economic inputs to the public protector. Now, it appears that the public protector was pursuing a political agenda and that she was lining up resources that could help promote that particular political agenda. And thus she used the services of a particular communication consultant, a particular, I don't know quite what to call Mr. Ngobeni. I don't want to call him a legal advisor because he's not. But Mr. Ngobeni, Ms. Heller, Professor Siepe, and then Sianejo were employed to act as a front to channel funds to them in a manner that they were not employed directly by the Public Protector's Office. So I have some real concerns that this is blatant misconduct on the part of the Public Protector. Thank you, Chair.
Thank you, Honorable Mailam. Honorable Gondo.
Chair, I agree with Honorable Mailam that Sianejo attorneys, and I would like to implore the committee to please take the issue of the involvement of Mr. Ngobeni and Sianejo attorneys being used as a conduit for procuring his services, as well as those of Ms. Kim Heller and Prof. Sepe. We should take it in a very serious light because it also has cost implications in the sense that, you know, you have the Office of the Public Protector paying for services that would ordinarily not be permissible when you look at you know, what is permissible in terms of an institution of its nature. You know, the costs that it would have to incur. So in other words, Chair, what I'm trying to say is that the only way that they could procure these services from Ngobeni and Kim Heller and Professor Sepe was to use Sianaho attorneys as a conduit. And I remember asking Mr. Niels why they weren't just you know, made service providers for the Office of the Public Protector, and he said something to the effect that you know, it's perhaps because you know, the type of services that they were offering, and the fact that Mr. Ngobeni, as we now know, is not allowed to practice law in South Africa. You know, that wouldn't have ordinarily been allowed. And so, Chair, we really need to find a way to get this issue investigated, and more so the involvement of Sianaho attorneys. And as I indicated earlier, perhaps we should involve the Legal Practice Council, and the Auditor General of South Africa also needs to be involved, because these were monies that came from the Office of the Public Protector. And in certain instances where it was articles that were put on websites, etc., that were not necessarily legal opinions. They were passed off as legal opinions when you look at the payment that was done. So that also needs to be investigated, so that you know, someone needs to be held accountable for the payments that were made, because in certain instances it was passed off as a legal opinion when it wasn't a legal opinion. What Mr. Ngobeni had done was to write on websites defending the public protector, etc. Chair, also now coming to the issue of Mr. Nyembe, it's worrying that Mr. Nyembe, how he got the job, he simply wrote to the public protector and indicated that, you know, I'm a lawyer, part of this Lawyers for Radical Economic Transformation. And we also saw that he indicated how much he wanted to earn, you know, for his services and stuff. And the public protector employed him without, you know, following the proper procedure in terms of his employment. And a policy was created after the fact, you know, to almost validate his appointment as a political advisor. And eventually he was even given the position of chief of staff. So I think, you know, that in itself points to an element of misconduct on her part as the public protector. And I think, as Honorable Milam has repeatedly asked, why does she need a political advisor? That office is not political in its nature. It may, you know, be charged with some investigations that are politically charged and the like, but it's not supposed to be politically aligned to any kind of ideology, etc. It's supposed to serve the people of the Republic of South Africa, irrespective of their political affiliation and the like. And so if you have, you know, the public protector requiring a political advisor, you have to ask yourself, for what reason would she need a political advisor when that office is not political in its nature? It wasn't intended to be political in its nature. And so, Chair, just those points around the use of Sianaho attorney as a conduit for certain external parties to be paid for providing services that ordinarily wouldn't be permitted, you know, in terms of what is ordinarily permissible. Thank you very much, Chair.
Thank you, Honorable Nkosi.
With all what Honorable Gondo has indicated, then the questions 4 to 7 would be answered as follows: that the use of external people to influence her decisions didn't ensure her independence. So that her conduct was not independent. She sought legal advice from people who are not lawyers. She sought in that regard, she even received an opinion on how to attack a judge, which she continues to do. And on 5, yeah, that failure was, in my opinion, intentional on her part. She did not have any thing to prefer, and on the basis of what this legal advice and opinions were made, she then takes a decision. And in conducting the investigation, of course, that means that she would not be independent, and that it's intentional. There is no impartiality. There will never be impartiality if you use those type of services. And I also think that because there was internal capacity available, why wouldn't she rely on internal capacity? Secondly, if there existed a panel of attorneys, why for legal opinions didn't he go to that panel? Of course, we know that frequently Sianejo is appointed, but why wouldn't she go to Sianejo for an opinion instead of instructing that her staff consult Ngobeni? On an unrelated but relevant issue, Chair, is the conduct of Nyembe, her conduct in relation to Nyembe. And I think that I agree with Honorable Gondo on that. Secondly, on Ngobeni, I think that the committee may consider in its final recommendations we have this matter addressed by a body that is charged with that responsibility at institutional level or at professional level. That also goes to Sianejo for attempting to or fronting on behalf of Ngobeni, in other words, putting on their letterheads and thus owning a work that doesn't originate from them. I think it also should be referred to a professional body that deals with such. Yeah, Chair, that would be my input.
Thank you, Honorable Nkosi. Any other member? I think that was the last hand. Any other member, or is there any dissenting or differing view on what has been expressed?
Another gadget, I'm failing to raise up my hand. If I may be allowed, I just want to support my colleague's chair that here there was no issues of impartiality. Again, this was deliberately done, because to invite external factors of other people to influence you, it drives you to move out from independence. So I'm really in support of what my other colleagues has indicated, that here we have got a problem, more especially to invite a person who doesn't belong to that particular institution to be your advisor and advise you even to challenge judges. To me, this really is a gross misconduct, and it was done intentionally, not unintentional. Thank you, Chairperson.
Thank you, Honorable Suela. Thank you, honorable members. I think that's where we leave it there. Maybe any final remark, Honorable Advocate Mayosi, before I ask Slotsepo to put up the charge sheet.
No, I don't have anything to add, Chair. Thank you.
Okay. Ms. Muri and Ms. Ibrahim. Thank you. Honorable members, you have for the last 2 days, full 2 days and long days, and the team has been taking notes of the issues you have raised in detail. I have no intentions to repeat those hours. We have those details, but it's important just as a summary and closing to, even though you've done it, to repeat that exercise. That, for example, in the relation of charge 1, do you confirm or agree that the misconduct in charge 1 on South African Reserve Bank or CX, as raised in the independent panel, is sustained over our discussion the last 2 days?
Chair, yes, I agree. It's sustained. My name is Becky.
Thank you, Honorable Nkosi.
Honorable agreed with the charges.
Honorable Siwela agrees. Is there any dissenting view on that? None. I proceed. Do we agree, therefore, in terms of okay, Ms. Ibrahim?
Thank you, Chairperson. Chair, I just wanted to note that as the committee has been deliberating, we've obviously been taking notes of specific subcharges where the committee has felt that there wasn't enough evidence to sustain a subcharge. So as I indicated yesterday, the charges contain various subcharges, but we understand the general sense of where the committee is going on each charge. So we'll make sure that that is captured. And when we get to charge 3, on the incompetence, I'd just like to make a comment as to some of how that relates to charge 1 and charge 2.
We'll come there. Let's go to charge 2, the Friede, to ask members if you do confirm and agree that the misconduct charge as found to be prima facie in the independent panel. Do you agree that it is sustained?
Agreed.
Agreed,
Chairperson. Agreed.
Honorable Lothrit and Honorable Dlagode, thank you. We now go to 3 charges of incompetence in both 1 and 2, which is Sab and Friede. And maybe before I ask you, maybe Ms. Ibrahim to come in. This is about incompetence.
Yes, so Chair, you recall that the first charge is a charge of misconduct in respect of SARB, and the second charge is a charge of misconduct in respect of Friede. When we come to number 3, it's got to do with those same 2 cases, but now looking at incompetence as per the rules.
Yes.
So in the respect of SARB, charges 1.1.2, 3, 4, 5, and 6 are in fact repeated word for word in 7.1.2, 3, 4, 5, and 6. So they mirrored for both misconduct and incompetence. So the committee would have to make an assessment as to whether they feel that it rises to misconduct, otherwise incompetence on those ones for SARB. When it comes to Friede, it's slightly different. There isn't that word for word repetition. So if I give an example, 4.1 in Friede says that the PP narrowed the scope required by the 3 complaints without providing any rational proper explanation. But under incompetence, there's a charge that says failure to conduct a lawful and meaningful investigation, and the demonstration of a failure to appreciate her legal duty to come towards the aid of the vulnerable. So one could then argue on the same set, that the same set of facts would apply there. So the committee would need to just give us guidance on whether you're of the view that these charges under SARB, firstly 1.1.2 till 6, where you've said that that meets the threshold for misconduct, then when we draft it, we're not going to repeat that under incompetence, if that makes sense. And we'll do the same for Frieda, where the committee's indicated that there are certain things that they believe to have been misconduct.
Okay, and the incompetency would include the CD report, the FSCA, ne?
Yeah, that's separate, Chair. So under incompetence, there was the additional, the CD report was an additional issue. And then for Frieda, under incompetence, there were also some extra things. So for example, the PP is charged with demonstrating a failure to appreciate that her investigation was wholly inadequate and grossly negligent. So this would have been about how she conducted the litigation, in that she defended, if I could put it this way, a doomed report in the first place. Whereas on the misconduct, it's the fact that she perhaps gave contradictory statements. So we will do that analysis based on the comments that the committee's made now throughout the deliberations.
Thank you. Honorable Mylan.
Chair, I just need a clarity. Is it not possible for it to be both misconduct and incompetence on these particular cases?
If you have the evidence to motivate for that, but let me hear Mr. Ibrahim. It's possible.
So Chair, the difficulty is incompetence is when you don't have the knowledge to do something or the ability or skill to perform. So I don't know how to drive, therefore I haven't driven properly, as opposed to I know how to drive, but I've been negligent in the way that I've driven, or I've intentionally driven in a bad way to cause an accident, if that makes sense. So
you were leaving out in that incompetence this issue of it being a sustained habit, that you repeat. Yes. Yes. Okay, let me hear Honorable Mylan.
So Chair, if I can just come in again, the definition of incompetence, because it's a lack of knowledge to carry out and the ability or skill to perform, it means that where the committee was of the view that there was some deliberate intent. So in other words, if the committee was of the view that the PP failed to furnish a Section 7.9, not because she didn't know that she ought to have furnished a Section 7.9 notice, but she chose not to do that, then that doesn't take you to incompetence, that then takes you to misconduct.
Sure. Okay.
Thank you, Chair, I'm covered.
You covered, thank you.
Thank you.
Any further responses to the issues raised by Ms. Ibrahim? Or are we all together? Are we, Honorable Maneli?
Thanks, Chair. I take it that the issues that are raised are more to clarify us as who have been raising the issues.
Yeah.
So it's not a reopening of a discussion we've had. Yeah, I thought it's important that I raise that point. For that reason, Chair, it also gets to the point where in some instances we have raised this thing that you may have the knowledge, you are a legal person and all that. But necessarily where you even get to be unable to interpret the law correctly, surely it is not just a misconduct, it also gets to be an issue of incompetence. So I'm just saying, I take it that the point has been raised just for us to know that at a point when we get the final draft, that cleansing would have been done so that it's justified. For that reason, I'll agree. So that we move to the next point. Thank you, Chair.
Thank you, Honorable Maneli. With there's no other hand, let's therefore move. Are you happy, Mr. Brian?
Yes, Chair, that's in order.
Thank you. Thank you. And then there would have been the, as we mentioned, linked to that, the CD matter. And then you go to 4, which is a discussion we had where we had named individuals and members would have pronounced on each of those. We had a bit of a good discussion and some debate on 10.1. And then I think the team would have taken up those notes where members would have differentiated either this being harassment or victimization and so on. But I want to put that to you as well, whether you, in regard to those issues we discussed, in relation to the report of the independent panel on some of them, what your view would be. Honorable Ngosi.
Chair, I would say that we sustain that. Firstly, I want to bring in an issue I raised during in the day on different opinions of or different evidence given to the community, particularly by, I think, the doctor in the Western Cape. The
Yes,
lead,
Dr. Lamola.
Yeah, Mr. Lamola. Yes. I think that he presented a quite a cogent, different point in support of the PP, but measured against the, I don't want to use the word overwhelming, but the substantive and cogent opinions, I mean, evidence of all the others, it doesn't measure. Secondly, he was very remotely related to head office as indicated, and would therefore not have been in the cold face of the atmosphere of head office. So he is not like there in the action and in the atmosphere of this constant pressure that is applied to people and the audits that are issued to people because, let me say, in an unreasonable manner. I think even though he thinks the PP is a good person, which he thinks so, I think the experience and the lived experience of these others is quite different. And that will go to the other person. I can't remember the surname, the other witness. Thanks, Chair. But the issues are sustained.
Thank you, Honorable Ngosi. Any other member? Honorable Maneli.
Thank you, Chair. First, I agree on the part of noting those that would have been speaking for the PP, as well as the fact that there may be those, and particularly if we were to take Madiba, who took a different angle there. So I would want that when that report, I think that's a proposal, that is also captured, because we had agreed to take them one by one, even though they are put in the charge as listed collectively. I think for me that's important, so that in endorsing,
just repeat that. Who are those?
Yeah. No, the point I'm making, Chair, is that you have a list there of people.
Yes.
From Mr. Samuel and so on. I'm just saying that we have made, we have expressed a view individually on those. Yes. And that is why you would have others where we can't express a view as the outcome of this committee deliberation.
Sure.
So I'm just saying that in the final report, I take it that it will be understood that not making or expressing a view on those that we have indicated does not remove the fact that we agree with the charge. Thank you.
Okay, I get you. I was just looking at those names. Okay, that's fine. Thank you, Honorable Maneli. Any other member? None. Ms. Ibrahim, any comment?
No, that's it. Thank you, Chair.
I'm just checking if you're still there.
Yes,
Okay, thank you. I think the others are fresh. We've just done them, which is your CR17 and the SARS. Again, just to go back to you members in relation to independent panel, what your views are. Do we sustain?
In relation to SARS, we sustain, I propose. In relation to Busasa, we sustain, I propose. In relation to OGI, I propose we sustain.
Thank you. All right, thank you, Honorable Ngosi. Any other member?
I'm covered, Chair. Thank you.
Support.
Yes, I'm saying I support it, Chair, so I'm covered on the point, so I don't want to repeat. Thank you.
Right. Thank you.
Supported, Chair, supported.
Thank you, Honorable Nola. Is there any dissenting view or a differing view? Honorable Mailam? Is that a dissenting view?
No, Chair.
Oh, okay. I thought you had your hand up, so I saw wrong there. So thank you.
I support, Chair.
Thank you, thank you. Am I missing out anything further, Ms. Ibrahim? I think when
no, Chair, we
the
take
has
all
been
of
recorded. Yeah. Maybe just a small point to inquire from members. So there's also the issue of the party with Mr. Zwane. Do we have any evidence there to indicate that the PP would have intentionally done what is reported there, Honorable Maneli?
No, thank you, Chair. I would want to persuade the committee not to sustain that issue and exonerate the suspended PP on that matter. And my view is quite simple, Chair, is that we didn't get even Mr. Zwane giving any version to the committee itself. And if he came with a guest like it was in the passage, it's just also an applicant to just say, and funani, you know. So all I'm saying is that I think the relationship would have been understood to be professional, that it being a social gathering will also keep your professionalism in that regard. So exonerate on that one. And I'm not sure if you will go to this last point we're discussing, Chair, where we also talk to the James one.
Go there.
Yes, I think also on the James one, so that you are consistent, that there's no change of view at this point. It's also not to express a view there, but of course noting that it may be a point that has been looked at either by courts, but also the panel, but it has not really been engaged in the committee, hence no expression. So that no expression does not erase that from information available. Yes, there may have been those findings by other bodies. Thank you.
Thank you, Honorable Maneli. Any other member? No further comments.
I support Honorable Maneli that
we be consistent.
Okay. Thank you, Honorable Suela. Any dissenting view? None. Thank you. Any last point, Ms. Ibrahim?
Chair, we'll take the time to put everything together in the draft report, but that is where members will really need to apply their mind and make sure that we've captured everything correctly. Of course, we're going to use all the evidence that was before the committee, vis-a-vis the charges and the standards of conduct that I took the committee through yesterday.
Okay, thanks for that. Just to, as we wrap up, honorable members, before I thank you, just to indicate that we have the intention, so I need to still negotiate that with the team, so that I don't put them under too much pressure, because what we're interested in is the quality of our report. I was hoping to give you that timeline now, but not in a position, but we'll communicate that with you. The intention is for us to have that sign-off meeting for the report, and we're looking at coming Friday, but it looks to be tight given that we're working today. It would have been good if we were working only on Friday. So it will be between that day or maybe next Monday, because we want to make sure that go to that meeting so that you would have applied your mind into the report, and when you get to the meeting, we're able to have a flow of your commentary and your agreement on the issues that are emanating from your own discussion over the last 2 days, Friday up until 8:15, and today the time now is just after 6, having started from 9 o'clock. So that would be that meeting, which I call a sign of the report. We're also looking at having a separate day after that, where we're having a meeting, because remember, after we did the sign off, we're going to give the PP the last Audi to comment on that report, as would have been in our terms of reference and the directives in our program. The matter was expressed on Friday that we must maintain and keep that, regardless of whether she takes the opportunity or not take the opportunity. We're also looking at, therefore, maybe we can combine when we receive the response or non-responses to do what we're thinking as the reflections and lessons meeting, where some of the issues that have been raised here that are not having a direct correlation with the report, but get into the realm of the kind of lessons we're drawing out of our process, so that it benefits the next and future endeavors, it benefits the National Assembly. We know we need to have a dedicated meeting for that, which is not mixed with the report. The report has got to be very precise on the issues that are within our mandate, and as well as the motion. So that's part of the thinking. And so basically, after today, budget for additional 2 to 3 meetings to close shops properly, but they will not be as heavy as this one. You have done the difficult work. You have sacrificed. You have maintained a discipline. Today, every time I checked, you would have maintained quorum throughout the day on a Sunday, having started at 9. Truly committed to your cause of the oath you have taken as a parliamentarian, and the work that you have done under very difficult circumstances and conditions. But it's just to encourage members to indicate that we're almost there in terms of our work. And so we're going to be doing our work with the team in order to make sure that the ideas, the interactions, the interventions you have made are reflective of the report that you would have produced yourself. So just wanted to make that before I close the meeting. Honorable Sukas, I saw your hand.
Chair, no, I think I must possibly be out of step now because I just wanted to add general comments, but I think you've already advanced to the point of closing the meeting. So,
okay. Those comments will still be accommodated when we meet again, so they are not forbidden. Thank you, Honorable Sukas. Any last word from the evidence leaders for now? Or Ms. Ibrahim?
No, Chair.
Advocate Bauer?
Nothing on my side.
Okay, Advocate Malusi?
No, Chair, no last words from me.
That's fine. The last word call was just to check if all three of you are there. Thank you. Honorable members, if there is nothing else you want to raise or comment, we are going to be thanking you for really staying laser focused on this work, and you have given us further work with the team to go and produce a quality report on your behalf. So thank you very much. The time is 22 minutes past 6, and please go watch netball, the Proteas against Jamaica before it concludes. Thank you very much. The meeting is adjourned.
Thank you very much, Richard.
Thank you, Chairperson.
Recording stopped.